ಫೋನ್ ಬರ್ತದೆ ನಮ್ಮ ಹತ್ರ. ಆಯ್ತು, ಡಯಾಲಿಸಿಸ್ ಎಷ್ಟು ಕೊರೋನಾ ಟೈಮಿಂದ ಡಯಾಲಿಸಿಸ್. ನಮ್ಮ ಅಪ್ಪನ ಜೊತೆ ಹೋದವರೆಲ್ಲ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಹಾಸ್ಪಿಟಲ್.
Yes. Yes.
My lord, memo ಇದೆ. KT ಮ್ಯಾಟರ್ ಇಟ್ಸ್ ಅರ್ಜೆನ್ಸಿ ಮೈ ಲಾರ್ಡ್. ಏನಂತಂದ್ರೆ ಇದರಲ್ಲಿ ಫೈನಲ್ ಲಿಸ್ಟ್ ಬಿಡದೇನೆ ಆರ್ಡರ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ. ಸೊ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಮೈ ಲಾರ್ಡ್. KT ಮ್ಯಾಟರ್ ಮೈ ಲಾರ್ಡ್. PSI ಇದು ಫೈನಲ್ ಲಿಸ್ಟ್ ಬಿಡದೇನೆ ಆರ್ಡರ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ. ಸೊ ಇಟ್ಸ್ ಅರ್ಜೆನ್ಸಿ ಮೈ ಲಾರ್ಡ್. 2024 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದೀವಿ. ಸೊ ಟುಮಾರೋ ಆರ್ ಫ್ರೈಡೆ
ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
My lord, already one.
Next week ಹಾಕೋರಿ.
My lord, tomorrow or Friday, my lord. It's urgency, my lord.
ನಾಳೆ ಬೆಂಚ್ ಬೇರೆ ಬೇರೆ ಇದಾವಲ್ಲ. ನಾಳೆ ಫ್ರೈಡೆ ಎರಡು ಬೇರೆ
Friday.
ಎರಡು ದಿವಸ ಬೇರೆ ಬೆಂಚ್ ಇದೆ ಅದಕ್ಕೆ ತಳಿ.
Please, my lord, it's urgency.
All right.
Next week, tax matters.
ಯಾವ ಇಯರ್ದು? Which year?
No, 23.
23, a week after next.
My lords, may permit me to make a mention, my
Yes,
lord.
sir. Yes.
Lord, serial number 33, my lord. I appear for the appellant in this matter. Lord, senior counsel C.S. Ramdas is to argue this matter. My lord, he had to undertake travel to his village, Sondekopa, for a temple function, my lord. Today, he won't be able to.
My lord, I'm so sorry. You're on the other side.
Today, he won't be able to attend
On
the
the
court.
last 5 occasions, they had sought time.
All right. Not 22 matter. ಅಲ್ಲಿ ಬೇರೆ ಟೆಂಪಲ್ ಓಪನಿಂಗ್ ಇದೆ ಅಂತ ಒಂದು ಡೇಟ್ ಕೊಡೋಣ ಬೇರೆ.
My lord, finally, ಅಂತ ಹೇಳಿದ್ರಿ 3 ಸಲ. My only request is it may be taken up higher on the board. I'm in your hands, my lord.
ನಮ್ಮ ಹ್ಯಾಂಡ್ಸ್ ಅಲ್ಲ, ಎಲ್ಲರೂ ಇನ್ ದ ಹ್ಯಾಂಡ್ಸ್ ಆಫ್ ಲಾ ಅಂಡ್ ಜಸ್ಟಿಸ್ ಅಷ್ಟೇ. ಅಲ್ಲಿ ನೋಡಿ ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಅದ್ಯಾವುದೋ ಒಂದು ಟೆಂಪಲ್ ಓಪನಿಂಗಿಗೆ ಹೋಗಿದ್ದಾರೆ.
Last time ಮಹಾಕುಂಭಕ್ಕೆ ಹೋಗಿದ್ರು.
ಹಂಗೆ ಹೋಗ್ಕೊತಿರ್ತಾರೆ. ಕಾಲ್ ಆಫ್ಟರ್ 3 weeks. 3 weeks.
My lord,
Yes,
the date should be
Please.
fixed.
Yes, a call after 3 weeks. No date. Yes, next.
Obliged.
Huh?
Yeah, the English student also different, sir.
29. Not able to come. You want time? All right. Next week ಮಾಡ್ತೀರಾ? All right.
25.
Huh?
25 minutes.
25.
Next week, minutes.
Next week? All right.
19th March be convenient for the bench minutes.
My lords,
Item number 35, my lord. Can it be taken 35?
35.
Can it be taken next week, my lord?
You're not today, not ready? All right, week after next.
Much obliged.
my lords, item number 30. I'm for the petitioner, my lords. The arguing counsel is unwell today. If it could be taken tomorrow, I'd be deeply obliged, my lords.
Not well?
Not today, my lord.
Nayanthara is not well.
Not well, my lord.
What happened?
There's some viral.
All right, next week
essay.
ಹಾಕೋಣ.
ನಾಳೆ ತಗೋಬಹುದಾದ್ರೆ
ನಾಳೆ ಬೆಂಚ್ ಬೇರೆ ಇದೆಯಲ್ಲ, ನಾಳೆ ಮತ್ತು ಫ್ರೈಡೆ ಅನದರ್ ಬೆಂಚ್. ಸ್ಪೆಷಲ್ ಬೆಂಚ್ 371
ಸ್ವಾಮಿ.
Huh?
25ನೇ ತಾರೀಕು ಆದ್ಮೇಲೆ. Next week. 26th, my lords.
NTI society.
NTI society.
I was there standing counsel for 2 decades. No, not before.
Obliged.
Not before the bench comprising of KSDJ. Okay.
My lord, serial number 27. I am for the appellant in this matter, my lord.
27.
27, my lord. This is the original side appeal. The respondent has informed us that they will not be filing objections, so it may be
There is contents in this matter, your lordship.
it may be posted next week for hearing, my lord, if convenient to the bench.
All right, call week
19th.
after 2024 matter, na?
Please, my lord.
Week after next we'll have it.
Please, my lord.
Okay.
Please.
My lord, the bench had previously ruled that there will be no precipitative protection that the appellant will be
The
accorded.
interim order granted earlier would continue.
Please, my lord.
Okay.
Grateful.
Your lordship's kind permission, my lords. This is a matter for posting, my lords. This is a matter where all the respondents who are senior citizens, they have been absorbed into the various departments from Mysore lamps, how they have been denied their benefits, my lords. My request for a listing, my lords.
They are retired all.
My lords, most of them have retired, my lord.
Not week after next.
Grateful.
Yes. ಏನು urgency? No urgency, but still let wait. Week after next time. Okay.
For withdrawal, serial number 1 to 5, government advocate.
Appear for the
Ah.
petitioner, my lords.
In terms of memo.
My lords. Deeply obliged.
Serial number 6, Raghavendra S.
ಎಲ್ಲದರಲ್ಲೂ ಮೆಮೊ ಕೋಟ್ ಮಾಡಬೇಕು, ಕೋಟ್ ಮಾಡಬೇಕು.
Serial number 6, Raghavendra S.
For withdrawal, my lord.
Withdrawal.
Withdrawal.
All right.
For order, serial number 7, PD Surana.
My lords, for the state, my lord,
Yes.
compliance report is filed both with the registry as well as the.
They have
Honorable
changed
Registrar.
The names are entered in the name, the
My lords.
entries are made in the name of
My
the
lords.
forest department now.
My lords.
They have done.
My lord.
Perfect. Learned AGA appearing for
All appellants, my lord.
all appellants.
The, other than KSRTC, my lords, all
Appellants other than KSRTC
2 to 5.
submits that the compliance in terms of judgment and decree entered in RFA 1653 of 2011, 1653 of 2011 has been done by making necessary mutation of entries in the revenue records showing the subject land as belonging to the forest department.
Chamundi Betta State Forest.
ಅಲ್ಲಿ ಚಾಮುಂಡಿ ಬೆಟ್ಟ ರಿಸರ್ವ್ ಸ್ಟೇಟ್ ಫಾರೆಸ್ಟ್ ಅಲ್ಲ,
My lords.
ಸ್ಟೇಟ್ ರಿಸರ್ವ್ ಫಾರೆಸ್ಟ್,
State Reserve Forest.
ಸ್ಟೇಟ್ ರಿಸರ್ವ್ ಫಾರೆಸ್ಟ್ ಫಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ಬರ ಆಫೀಸರ್ಸ್ ಇದ್ದಾರಾ ಅಥವಾ ಕಂಪ್ಲೈನ್ಸ್ ಇದ್ರೆ ಬೇಡ ಅಂತ ಹೇಳಿದ್ವಿ ಬರೋದು ಬರ್ಕ ಇನ್ ವ್ಯೂ ಆಫ್ ದ ಅಬೌವ್ ನೋ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ನೀಡ್ ಬಿ ಪಾಸ್ಟ್.
Deeply obliged.
ಓಕೆ, ಅಟ್ ಲೀಸ್ಟ್ ಆ ಫಾರೆಸ್ಟ್ ಉಳಿಸ್ಕೊಳ್ಳಿ.
My lords.
ಅದೆಲ್ಲ ಎಲ್ಲ ಹಂಗ ತಿನ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ
It is our collective responsibility.
ಮತ್ತೆ
ಮಾಡ್ತೀವಿ.
ಎಲ್ಲ ತಿನ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ ಉಳಿಬೇಕಲ್ಲ,
My lords.
ಎಲ್ಲ ತಿನ್ಲಿಕ್ಕೆ ಇರಲ್ಲ, ಸ್ವಲ್ಪ ಬಿಡ್ಬೇಕಾಗ್ತದೆ ಮುಂದಿನ ಜನಾಂಗಕ್ಕೆ.
Serial number 8, Sundara Raman,
ಎಸ್
Sachin BS.
ಎಸ್ ಸರ್. Professor is waiting for which case? Professor Ravivaram Kumar is waiting for which case? ಯಾವ್ದು ಬೇರೆ ಕೇಸ್ ನಮ್ದಿಲ್ಲ, ನಮ್ಮ ಮಾಡಿ ನೋಡಿ ಇದು ಮಾಡ್ತಾ ಇದಾರ. ಎನಿವೆ ಲೆಟ್ ಅಸ್ ಸಿ. ಎಸ್ ಸರ್.
Yes,
Number 8.
this- we have complied with that requirement of giving those books, no, that has been done.
Then compliance is done.
This
Submits the learned
Yes.
senior advocate, Mr. Dhan Chinnappa. Yes.
This, my lord, relates to the Professor Keshav, Justice Keshav Narayan Committee report with respect to, my lord, the Arkavati property. Lord, I've made a short list of dates, my lord, if I may just hand it over to your lordships.
ಕೊಡಿ
I'll very quickly take your lordships through the issues that are there.
ಕೊಡಿ ಕೊಡಿ. Was this matter heard for some time other day?
No, my lordships had not heard it,
Not heard.
not heard it. But I think similar matters were heard by your lordships in other cases.
Correct.
So, Lord, there are 2-3 issues here.
Yes.
The issue of the property being landlocked, which is really an admitted fact, and there being no development on this property at all. Our committee, my lord, holds that, one, of course, they hold that you're a subsequent purchaser. That is one issue which is there in this case. But notwithstanding that, my lord, the real issue which ought to have been answered is where the situation of where the land located and whether the surrounding lands have all been dropped from acquisition, owing to which, my lord, this one pocket has remained as it is. And secondly,
It fits into that Junjamma,
yes, with Junjamma as well as Bondu Ramaswamy itself,
Ramaswamy also.
because that is a specific requirement to be analyzed. That has not been done by the committee. And then, Lord, what also happens is the original owner, Dodda Papama, had filed a writ petition with me, where she had confirmed that I am the owner of the property.
Where is that?
Yes, Lord. She had executed a confirmation. May I just 1 minute take
Yes,
you
yes,
through the dates? I think it will become very.
yes.
Lord, the first item is that they were the owners of the property. There's no dispute on that.
Your ownership is not in dispute.
My ownership, my lord, of course, now they dispute it because they say you're a subsequent
But you
purchaser.
say there is confirmation
The
of.
confirmation from the original owner.
the conversions, my lord, were there to residential use. Then, my lord, in 1993, one Lokesh was given power of attorney to take various steps to form and sell sites in 103/1, 2, 3, and 5. But a layout was formed, my lord, including survey number 103/4.
103.
3/4. This is the subject property here. 103/4.
Last one, last but one, na?
Yes.
103/4.
Yes. My lord, I must, in all fairness, first point out that the power of attorney did not authorize him to form the layout in 103/4.
Only one layout, one per land.
No, he was supposed to do it in 1, 2, 3, and 5.
1, 2, 3, and 5.
5. But the layout actually, my lord, was formed in all 4, all 5 of them, including 103/4.
Okay.
And site number, lords, 296, 297, 298, and 299 are in survey number 103/4.
Okay.
Then, lord, in 1994, those 4 sites were sold through the GPA holder to various persons.
Through GPA holder.
Through the GPA holder. Now, that sale is confirmed, which is why I'm saying that there's no dispute on the sale.
That lady has
That
confirmed.
lady has subsequently executed a confirmation deed.
Okay.
Then in 2003, my lord, is a preliminary notification.
2003 is preliminary notification.
Preliminary notification, which included, my lord, 103/1 to 103/5.
Yes.
The final declaration, my lord, is in 2004, my lord,
Yes.
in which only 103/4 is part of the final notification.
Rest of the lands are kept left out.
Left out. That is the entire surround. I'll show you, lordships, the plan.
So we are concerned with 103/4 alone now.
Only 4. Then, Lord, 15/4/2005, learned single judge's order, quashing the acquisition.
Yes.
Then, Lord, 25/11/2005 is the division bench order allowing the writ appeals, but giving directions to eliminate discrimination.
Yes.
After that order, my lord, the properties were again sold. After the order of the division bench, on 29/4/2010, those 4 sites were again sold to two other persons, one Sridhar and one Srinivasa Rao.
They are sold to others.
Sold to others.
Yes.
Then, Lord, on 5/5/2010, Supreme Court in Bandhu Ramaswamy's case affirmed the order of the division bench and issued certain directions, which I'll take your lordship through. 1 or 2 directions I want to show you, lordship. On 5/7/2012, Lord, Sridhar and Srinivasa Rao sold all 4 sites to the petitioner by 4 separate sale deeds. Of course, this is my submission, not what is found there. I've just said it was possibly believed that the clarifications would inure to the benefits of the parties, as survey number 103/4 was landlocked and was not suitable for formation of a layout.
Okay.
This, my lord, I must say, it's not part of anything else, but it is a submission by me.
But they are by registered sale deeds.
Registered sale deeds.
Okay.
That's how I became the owner of the property.
Okay.
Then, Lord, on 9/10/2013, Dodda Papamma and her son Nagaraj executed confirmation deeds in favor of the petitioner, confirming that site numbers 296
In respect of these 4 sites.
5 sites were formed out of survey number 103/4.
Yes.
And confirmed that it is really part of that land, which, my lord, is very important because she has accepted the divesting of her right in the land in 1994 itself. Because, my lord, for her, it was easier to then say, I'll take compensation or something else. But she confirms that she had lost her title with respect to these 4 sites at the very least.
Is it a registered instrument?
Yes, it's a registered instrument. That is also a registered instrument.
Yes.
Then, Lord, we made, as required, Lord, by Bandhu Ramaswamy's case, we made a representation to the BDA for dropping the acquisition in respect of these 4 sites. That was rejected. Then, Lord, the final declaration was published. We filed a writ petition along with Dodda Papamma. Dodda Papamma and the petitioner
who confirmed your
it, and the original owner of the property, joined, my lord, in filing a writ petition challenging it. And that is, my lord, noticed in the order of the learned single judge. Then on 27/9/2021, Lord, writ petitions were disposed of by a common order. High Court noticed that the property was landlocked as other survey numbers were denotified. Contention of BDA was also noticed that 24 sites were formed in the layout, 6 sites were already allotted. However, photographs show the contrary. There's not one road, my lord, in that entire area. I have the photographs even as of today. No, nothing has been done. The Justice Keshan Narayan Committee was constituted with 2 other members. On 23/2/23, the committee rejected the request of the petitioner seeking deletion of lands on various grounds. Lord, I'll just read this note. This actually summarizes what we have to say. Dodda Papama had already been allotted sites on 8617 in a completely different location, not in survey number 103/4. This was during the pendency of writ petition 37.
Other than 103/4.
Because Bondu Ramaswamy says you can allot sites in that very area, not someone else. What seems to have happened, Lord, is, and it's a very strange thing. She gets allotted some 6 sites in some other land, and the very next month, it's all sold to some third parties. But in any event, Lord, this was not disclosed to the High Court, not disclosed actually to the committee. For the first time in the objections filed before your lordships, this disclosure comes out that actually we spoke to Dodda Papama, took her somewhere else, despite the fact that she has confirmed that I don't have title in the land anymore. And then it is sold off to some other third parties within 1 month. This day, on day 1, allotment and sale to her. 30 days later, sale to third parties.
Okay.
This was during the pendency of the writ petition. Allocation was made despite Dodda
Whether
Papama.
those sale deeds mention anything about a confirmation deed?
No, because,
Nothing.
no, my lord, because as a matter of fact, those are
They could not
BDS,
have.
BDS sale deeds to her, not in 103/4.
It's
Had
in
it been
respect of other side.
some other
areas.
property somewhere else is allocated to her, though this land was available, even according to them. This allocation was made despite Dodda Papama confirming that the site number 296 to 99 was already sold from out of survey number 103/4, which she had confirmed in favor of the petitioner, and this fact was within the knowledge of BDA. It is extremely important to note 6 sites which were allotted to her were sold within 1 month on 3/7/2017 to a third party, making the transaction rather suspect. This despite the fact that the litigation in the above writ petition continued. BDA did not even think it fit to bring this fact to the notice of the court. All of the disclosed only to the committee to create a fait accompli situation. However, such allotment is contrary to the direction of Bondu Ramaswamy that sites could be allotted only in the area acquired and not outside. Para 160 million. Then said site 29699 does not form part of survey number 103/4. This finding has been made despite the fact that Dodda Papama has confirmed the location of the said sites, and which resulted in Dodda Papama losing title as early as 1994. Because confirmation law does not create a new right. It confirms an earlier right. Because she rectifies a mistake which is there in the GPA and says, if the GPA did include 103/4, and he was authorized to sell these sites come in 103/4.
These are 5 sites.
These 4 sites.
4 sites.
4 sites, 296 to 99. And therefore, once he has made that confirmation to say Dodda Papama still continues to have title, and therefore she is entitled to be given those 5 sites, was completely wrong. Then, Lord, sale of subsequent date of preliminary notification. Then 2 material issues were not considered, according to me. Committee did not answer the most important question in para 162 as to whether the land was landlocked, and if so landlocked, could any layout be formed. Committee also did not answer if the land was at all developed into a layout as claimed by the BDA, when it is clear that there is no layout whatsoever formed in the said extent of land, as is clear from the photographs. This is, my lord, the entire issue in this case. Now, my lord, I'll just show you Bondu Ramaswamy, 2 paragraphs. Along with the objection statement not filed by the BDA, they produce all the judgments.
My lords, we have filed additional documents, my lords, along with a memo.
Along with memo, you have produced additional document also.
Judgments compilation itself we have filed.
This is a judgment
It's a separate compilation.
Oh, I'm sorry, judgment compilation. I'm so sorry. Judgment compilation.
Judgment
I missed.
compilation.
Yes, my lords.
The 3 or 4 judgments are there.
4 judgments.
Rulings.
Yes, my lords.
Yes, sir.
Lord, please come to page 375, my lord, of this compilation. That is the conclusions, my lord, of in Bondu Ramaswamy's case. Para 160, in view of the foregoing.
Yes.
In regard to acquisition of lands in Kempapura and Sriram, BDA is required to consider the objections to the acquisitions having regard to the fact that large areas were not initially notified for acquisition. More than 50% of whatever that was proposed was also subsequently deleted. BDA has to consider whether in view of deletions to a large extent, whether development with respect to balance has become illogical and impractical, And if so, whether the balance area should be deleted from acquisition. If BDA proposed to continue the acquisition, file a report within 4 months. In regard to villages of Venkateshpura, Nagwara, Hendur, and Chellakere, where there are several very small pockets of acquired land surrounded by lands which are not acquired or which were deleted from the proposed acquisition, BDA may consider whether such small pockets should also be deleted if they are not suitable for forming self-contained layouts. Acquisition thereof cannot be justified on the ground. These small islands of acquired land could be used as a standalone park or playground in regard to a layout formed in a different unconnected land in other villages. Similar isolated pockets in other villages should be dealt with in a similar manner. BDA shall give an option to each writ petitioner whose land has been acquired for Arkavati to accept allotment of 15% of the land acquired from him by way of developed lots in lieu of compensation. Any fractions in excess of 15% may be charged prevailing rates of allotment. Or in cases where the extent of land acquired exceeds half an acre, that won't apply, my lord, because in addition to claiming compensation, without prejudice seek reference, allotment of a plot measuring 30 by 40 for every half acre acquired at the prevailing allotment price.
Which of the directions is relevant?
But according to me, 2 and 3. Now, 2 requires not small isolated pockets to be kept out. Because it's not only for those villages, but also for similarly situated, last sentence, similar isolated pockets in other villages should also be dealt with in a similar manner.
So a kind of general direction.
Yes, ma'am, that's the general direction. And allotment is 15% only in that area. Because it says accept allotment of 15% of the land acquired from him in lieu of, by way of developed lots.
Yes.
Therefore, my lord, when the committee was constituted by this honorable court.
So the fourth one, just read that.
Yes.
Item 4.
Any allotments made by BDA either by forming layouts or by way of bulk allotments will be subject to the above.
Any fact matrix that would attract serial number 4 also?
No, my lord,
So no allotment is made.
no.
In other words, even if allotment is made, that should be ignored.
Yes.
If it is contrary to
If
these
it's contrary
propositions.
to.
But that will not apply to you because no such matter, assertion.
Yes, my lord. No, in my case, what I'm saying, my lord, is 3 required allotment in this area, if at all. Because then, by applying the principle of feeding the grant by estoppel, I would have got the benefit of those sites which came to me. Now, what they have done is, and it, to my mind, not seems deliberate because nothing was disclosed to anybody until the filing of the statement of objections, that allotment was made in some other area and not in the area acquired from the petitioner or from Dodda Papamma.
So that allotment has to be in the same area.
It has to be, it's basically, I'm
That's
taking,
how Bandura
taking your land, I'm giving you developed property to the extent of
the
15%.
same land.
In the same land. Because then there's no real, actually, there shouldn't be a transfer of property in that sense. Because acquisition is done, therefore I'm giving back to you what I've acquired from you. And it is not the case that this land has been formed into a park or something of that kind. Their claim is it is actually a layout and 6 sites from that have been allotted to someone else. We do not know who it is and how they've made that allotment. Because there is no formation of a site. And my lord, I have produced some documents which will show this fact very clearly. Because all around, there is no land which connects the Arkavati layout at all. All around are all denotified. There is only one small pocket of 1 acre, which, my lord, is available for the purposes of whatever development that they claim they can do. But there is no connection whatsoever to any other part of the Arkavati layout. Lord, may kindly take the rejoinder which we had filed, Lord.
Rejoinder.
Rejoinder copy.
Annexure AA. Lord, may kindly see annexure AA, my lord. In page 41.
ಈ rejoinder ಯಾವುದಕ್ಕೆ our objection
Our objections.
What you are meeting in this?
Yes. No, I want to show, my lord, that the land surrounding it has been fully denotified or not notified for acquisition, making it a pocket which is away from all other lands which form part of the Arkavati acquisition. Annexure AA, page 41, my lord will see 103/4. Photographs.
3/4.
My lord will see around it 103/1, 103/2.
1, 2, 3, 5, we know.
Yes,
4 is 103/4 adjoining the road.
adjoining the road. Around it, my lord, is 103/2, 1, 105/2B. None of it is part of the layout. Photographs. Give me the photographs. Because when I thought the photographs were already on record, unfortunately they aren't.
Yeah, not the photographs also.
But I'll file this along with the memo, my lord. I'm very sorry.
No, it's all right.
They are.
Documents can be filed along with a memo.
No, I'm saying it is not with a memo right now,
Okay.
which is why I'm very.
Put it. Go. Original photographs ಇದೆ, no?
Yes, yes. They are aerial photographs, not of to show that exact location. Okay,
ಅಲ್ಲೇನೋ ಸ್ಟ್ರಕ್ಚರ್ ಇದೆಯಲ್ಲ ಏನದು?
that is some other structure. That's also on property, my lord, which is not acquired or given up. Our structure, the structure in the middle, my lord, that's a structure built by us.
Your structure.
Our structure.
ಅದು ಎಂಟೈರ್ ಏರಿಯಾ ಡೆವಲಪ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟದ.
ಬೇರೆ ಎಲ್ಲ 103/2, 3, all of them are developed, which were all denotified or not notified. Not notified in the final declaration.
Bandu Ramaswamy covers both not notified or denotified while deciding whether it's a pocket or not.
It's a pocket or not. The idea, my lord, is you must connect it to the rest of the
That's
layout.
right.
You can't have one. This can't become one new
Integrity.
Arkavati layout.
Integrity.
There's no integrity to the layout.
What aspect committee has not considered according
Lord,
to you?
committee says, as I pointed out those 3 points, it says because in the original sale deed, which was executed in 1994, 103/4 is not mentioned, but subsequently confirmed by the landowner. That confirmation we can't take into account.
That confirmation?
We cannot take into account. It seems to have been created later. But the fact remains, my lord, it is a situation where the original owner is saying, yes, it is part of the layout. Yes, it was transferred validly. And therefore, I don't have title with respect to that portion of the land.
That
What
committee
more
does not believe.
Committee does not believe. Committee says, I ignore that.
Where is that discussion in
Yes,
committee's report? Just show that.
If your lordships take the first volume,
It's a registered instrument.
it's a registered instrument. My lord, may kindly come to
Petition.
page 48, my lord, of volume 1. Page 48, volume 1. The 3 points for consideration is there at page 48.
Para 12.
Para 12. Where the claim of Srimati Doddapamma seeking deletion of land bearing 103/4 from acquisition is tenable. Where the sites claimed to have been purchased by second petition Sunita form part of survey 103/4. If answer to point 2 is in the affirmative, whether the second petition is entitled to any relief in respect to sites claimed to have been purchased by her as per the scheme formulated under the judgment of the division bench. Then, Lord, the exact consideration, my Lord will kindly find.
Which that Bandu Ramaswamy?
No, on Bandu Ramaswamy. This is
Then
division bench.
not referred to apex court judgment.
No, but he refers to it,
Referred.
but
Why third point
Okay.
she is, the committee is referring to anta, division bench. Law has marched na a little
No, I-
after division bench, apex court
correct,
made
it should have
certain.
been apex court.
Ah.
Think not the, because there were some directions in the division bench order which was confirmed by the apex court, possibly that's the.
Confirmed with a little modification,
some
not
modification.
ditto confirmation actually.
Appeal, on the Gopal bench, division bench order, RPC. But can I request you to kindly come to page 58, my lord, or the exact consideration I'm showing. On top, therefore the rectification indeed. I'm sorry.
Therefore, the rectification deed and
Indeed.
confirmation deeds cannot
Not
be the basis to hold that the sites in question form part of 103/4. So there was an issue as to the identity of the,
Yes,
Property.
that is, I'll tell you also why. The reason, Lord, was the first sale deeds did not mention 103/4 in the schedule, but mentioned these survey numbers. But the point, Lord, was the site numbers were formed in this 103/4 on location basis, which is why we got a confirmation from Dodda Papamma saying that it is actually 103/4. So the
is there, is it their case that identity is incorrect?
Lord,
Have you taken up that contention at least anywhere as to the identity of the land, which the landowner says, this is the land anta, confirmation deed. Whether committee disputes that?
Committee
Does not dispute. Did you dispute? As BDA, you have no role to play there.
we have no role to play, my lords, just to save the precious time of the court, my lords. The no relief was granted in the earlier round of litigation to the petitioner to approach the committee. That is the moot point which has to be answered. No relief was granted in the earlier round of litigation for the petitioner to approach the committee.
But that is not the ground on which committee
That
has
is one of
rejected.
the, that is the one of the ground.
Where is that?
Yes. Because he is a subsequent purchaser. He is a subsequent purchaser.
Correct.
He purchased it, my lords, let me put it in this way. Acquisition of Arkavati layout was upheld by the apex court.
Correct.
The apex court has confirmed the judgment of the division bench.
Correct.
Division bench has allowed the appeal of the BDA and reversed the judgment of the single judge. Division bench, what division bench has held is that acquisition is upheld, and while upholding the acquisition, two relief is granted to one is revenue site holder and one to is landowners. Let me put it in this way. For revenue site purchases, what are the relief which was confined is that if you are revenue purchaser, if you are revenue site holder, if you have purchased the property before PN, then you are entitled for following relief, that you can make an application for an allotment of alternative site, certain aspects which have been contained in the division bench. Insofar as landowners are concerned, they can seek for deletion of land. Well, this is a case where he is a revenue site purchaser who purchased the property after issuance of PN. That the division bench judgment was upheld by the apex court.
Correct.
And thereafter, in pursuant to the apex court judgment, we issued another notification to show that on consideration of the Bandu Ramaswamy's case, these are the land which are deleted, these are the land which has been included in the notification. So that notification, again, subsequent notification was called in question by the petitioners, including his landowner. In the writ petition, no relief was granted to the petitioners to approach the committee. The original landowners has already taken a compensation.
Who is the original owner?
Yes, Dodda Papamma has already taken the compensation.
In respect of this land? also?
Yes.
that is that allotment of sites which they made.
Yes, that means in the sense,
That
in
is
the
what-
way, by way of a compensation,
That
we
will
have-
inure, that will inure to the benefit of the petitioners by virtue of feeding the grant by estoppel.
no, let me put it in this way. Now, by way of a compensation, what the apex court says is that either you can take monetary compensation or you can take 40% of developed site.
Correct.
Pursuant to the decision of the apex court, the landowner opted for developed site,
Correct.
for which the very petitioner was present during the proceedings
That-
before the land acquisition officer.
No, what's your answer to feeding the grant by estoppel? Section 43 of the Transfer of Property Act,
Yes.
which you have held applicable to this proceedings like this. If that, who is that lady, Dodda
Dodda Papamma.
Papamma.
The Papamma. If you have granted compensatory sites,
Correct.
and Papamma says in favor of these people, is it not going to fit the
My lords, Papamma has not executed a sale deed in his favor.
confirmation?
My lords, confirmation, my lords, at the time of granting compensation to Dodda Papamma, it is with the consent of the petitioner, the compensation was granted.
Very well. No issue at all. Where is the conflict?
My lords, once the compensation is received, question of deletion, all those things does not arise. My respectful submission. That is my first submission. Second submission is that the petitioner have no locus standi to seek for deletion of land. He cannot approach the committee. No relief was granted in the earlier round of litigation, asking the petitioner to approach the committee because he is a subsequent purchaser.
Only those
Landowners, I'm sorry.
for going before the committee,
Yes.
order of the court is necessary?
Order of the court is,
Not necessary.
yes.
That is whoever would fit into the parameters of
Correct.
this Vandu Ramaswamy.
Yes, sir. Yes.
I think a committee is appointed pursuant to judgment of
Yes.
Justice Arvind Kumar.
Yes.
Is it not?
Yes.
So whoever would fit into the parameters, he can approach the
Committee.
committee. Therefore, no relief was granted in the writ petition is no answer to silence their whatever right they have within the parameters. Anta.
My lords, now within the parameter, my lords, let me put it in this way. Within parameter and ಏನು? Within parameter in the sense, only landowners, not a site holder. Division bench has specifically said that two relief is granted. One for revenue site holder and another relief
Owners
is
of the
landowner.
land.
Only those landowners, they can seek for exclusion of land on the ground that adjacent land is deleted. So please delete my land on the ground it falls within a green belt area or it is a built up area. My lords, I'll take my lords to the division bench judgment. Let me clarify it. And the judgment of the division bench was upheld by the apex court with a further clarification, nothing more. Kindly I draw my lord's attention. Copy diya, sir. My lords, I have placed a judgment on record on 2/11/2023. Division bench including the apex court judgment. My lords, idiyala.
Yeah,
Yes, sir.
I will say that. Read it anyway.
Yes,
We'll
sir.
read again.
Yes, sir.
No
I'll
problem.
take my lords.
About half a dozen time it is read now to us. Anyway, we'll read it again.
Wait.
Because something new may emerge.
Yes,
We
sir.
do not know.
Yes.
The same thing which I had given you, lordship.
My lords, I draw my lord's attention to page number 439 of the judgment.
No, you
Division
read,
bench judgment.
ಇದರಲ್ಲಿ
Adರಲ್ಲಿ
439 of division bench judgment.
288, page 288.
288, sir. Sir. ಆರ್ಡರ್ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ತಮಿಳು.
Correct.
ಅದರಲ್ಲಿ ಎ ನೋಡಿ, ಎ ಮೈ ಲಾರ್ಡ್ ಸಿ ಮೈ ಲಾರ್ಡ್ಸ್ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಸಿ. My lords got it. Acquisition of the land for the formation of Arkavati layout is upheld.
Correct.
Subject to following conditions.
Ah.
Insofar as site owners, kindly mark this, are concerned, they are entitled to the following reliefs.
Site owners for writ petitioners
Yes.
shall register themselves as
Yes,
applicants
sir.
for allotment under the BDA 84 rules within 2 months.
Yes, sir. My lords, these are the points which is been condition imposed by the division bench insofar as the site owners.
This arrangement.
Yes,
This is number 1. CA1.
Yes, sir. Yes, sir. A1,
CA2.
register themselves. 2, petitioner shall file an application for allotment of site antala ide.
Ah.
BD will treat the application entitled to priority. Just may lords may skip it. If there are no rival claimants for compensation in regard to the plots claim, if ownership of the petition in regard to respect of the sites which have been acquired is not disputed, BDA shall calculate the compensation antala ide.
Correct.
My lords, 5 nodi rival claimants idre. If there are rival claimants in regard to the survey numbers of sites or if any petitioner's title in regard to the sites are
Reference to-
challenged,
reference to
reference
civil
ಮಾಡಬೇಕು
court.
ಅಂತಿದೆ.
Ah.
Sir, ಮತ್ತೆ sub clause 7 ನೋಡಿ sir.
The above scheme,
Above scheme, sir. The above scheme will be available only those who are the owners as a consequence of execution of registered sale deed in their favor prior to date of criminal notification, not to a GPA agreement holder. Next, D, my lord's court. This is what I was pointing out. Insofar as landowners, excluding site owners, are entitled to following reliefs.
site owner.
Yes. Now the petitioner is taking the benefit of this subclause D.
He is not landowner.
He is not a landowner, he is a site owner.
So.
And he purchased the site after issuance of PN. And in any event, my lords, if my lords may construe also, my lords, landowner has already taken the campus. There is a dispute between them. This is what exactly committee has held. Committee has extracted this judgment. Arvind Kumar judgment also. Next. Any other page number? Huh?
526.
Let's what the
Last paragraph read in that page 300.
paragraph 8 says so.
D one adadmel last paragraph. Page 300.
300.
Athwa internal page 442.
Yes, sir.
It is made clear.
ಅದೇ ಲ್ಯಾಂಡ್ ಓನರ್ಸ್ಗೆ ಸಂಬಂಧಪಟ್ಟ
What?
It is made clear that BDA shall consider such request, keeping in mind the status of the land as on date of criminal notification, and to exclude any developments, improvements, constructions put up subsequent to the preliminary notification, and then decide whether their case are similar to that of landowners whose lands are notified for acquisition, notified and whose objections are upheld, and no final notification is issued. My lords, D, my lords, for para number D, the division bench also called out the conditions. What are the parameters which has to be considered while filing an application by the landowner for exclusion of their land?
Yeah.
This is what the division bench has said. And my lord, same principle has been reiterated by the single judge also in a subsequent writ petition.
Yes.
That is my one submission. And second submission, my lords, single judge order also, my lords, the owner, including petitioner, was a party in the earlier round of litigation. My lords, in the earlier round of litigation, though it is a common judgment, a specific order is issued by the learned single judge saying that, my lords would find it at page number 526 in the same compilation.
Has, my lord, what is to be done?
Sir, now, ನನ್ನ page ಬೇಡ 740 of the single judge judgment.
ನಿಮ್ದ್ರಲ್ಲೇ. Para 89 actually considers the scope of what the committee.
My
must
lords
do.
may ignore it. My lords may ignore it. My lords may take it at page, I'll take my lords to page 526.
ಯಾವ್ದ್ರಲ್ಲಿ ಇದು
Adralle, that is what my learned friend only has filed. I'm only requesting my learned friend to read from para 89
All
at
right.
page 521.
521
521.
Same order ಅದು.
Same order. No, but this is the order of Justice Arvind Kumar.
Yes, I'm grateful. my lords. I'll take my lords to page 529, 521, para 89.
89.
Yes, sir.
Honorable Justice Arvind Kumar or Judge.
Yes, my lords. For which the petitioner was also party in that proceedings. In the light of the aforesaid facts, this court is of a considered view that these aspects will have to be dealt by the examining the claims afresh, and for ensuring that there is a clear and absolute transparency in the said process, it would be apt and appropriate to constitute a committee. Committee is accordingly constituted, comprising of following 3 persons, so and so, so. These are 3 persons which has been constituted. Next, my lords, I take my lords to very next page. My lords may skip para number 90.
91.
91, my lords may take
Relevant.
relevant. Then my lords may, I'll take my lord, which is relevant for my case is concerned, I take my lords to page 526. My lords got it, page 526. ಅದರಲ್ಲಿ 11ನೇ ಪಾಯಿಂಟ್ 526ರಲ್ಲಿ
The applicants.
yes, who are claiming, my lords got it,
Yes.
the applicants, writ petitioners, who are the parties who are claiming relief based on the sale transaction which has taken place subsequent to the issuance of preliminary notification dated 3/2/2020 would not be entitled to any protection or relief whatsoever, and their claim stands rejected. Now coming to the facts, petitioner purchased the subject site on well, its preliminary notification was issued on 3/2/2003.
3/2/2003.
Yes,
Yes, date is mentioned in the order.
Yes,
That
it is
judgment.
mentioned in the order. Or my lords, I'll just pass on the synopsis so that my lords, it will be easy for my lords to. ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ನನಗೆ my lords, just my lords take to directly I'll take to the preliminary notification dated. Now kindly see the synopsis. My lords got it. My lords got it. 9/7/1971, Dodda Papamma, so and so,
property.
purchase the property, 103/3, 1 acre, so and so, 10/3/4. This is the subject matter of lease here. Next, Deputy Commissioner issued a conversion order from agriculture to
92.
residential purpose, 10/3/4 illa idralli. Next idralli.
Yeah.
Next, 18/7/1992, Deputy Commissioner issued a conversion order from agriculture to residential purpose insofar as 103/1. Next, Dodda Papamma executed a GPA in favor of R. Lokesh, 23/4/1993.
103/4 ಎಲ್ಲಿ?
ಹೌದು,
Conversion.
ಕನ್ವರ್ಷನ್ ಅಲ್ಲಿ ಇಲ್ಲ ಸರ್,
Conversion.
ಇಲ್ಲ.
Whether 104 is not converted,
It wasn't. It was not converted.
not converted.
Next, sir, 4/3/1994, Lokesh executed a sale deed of the site bearing so and so, carved out of 103/2,
Lokesh is GPA holder.
GPA holder, sir. 103/5. Next, 7/3/1994, Lokesh
Sale
executed.
deed actually says owners represented by Lokesh. It doesn't say Lokesh executed the sale deed. So the sale deed says all the owners represented by Lokesh.
Right. Lokesh executed a sale deed, so and so, 103/2, 103/3, so and so. Next, Lokesh executed a sale deed in site bearing number so and so, 14/60, carved out of 103/2, 103/3, 103/5. Next, Lokesh executed a sale deed so and so. Next, sir, 3/2/2003, BDA issued a preliminary notification for formation of Arkavati layout, including survey number 3/4. State government issued a final notification, that is on 23/2/2004, including survey number 103/4, measuring 1 acre 1 guntas. Next, 4/12/2004, land acquisition officer has taken the possession of land under section 16 of the Land Acquisition Acts. Next, 8/9/2004, land acquisition officer has passed an award and same has been approved on 10/11/2004. Some of the landowners filed a writ petition challenging the acquisition proceeding in WP number so and so. 15/4/2005, writ petition filed by the landowners in connected matter has been allowed by this court by quashing the acquisition proceedings initiated by the BDA for formation of
That
Arkavati.
is set aside.
Set aside, sir. Division bench, 25/11/2005, sir. Division bench of the Honorable Court allow the writ appeal filed by the BDA by setting aside the order so and so by imposing some conditions. Next, 3/3/2010, Dodda Papamma has cancelled a GPA power of attorney executed in favor of R. Lokesh. Next, 29/4/2010, Venkatesh sold site bearing 296 crore out of survey number 103/2, 10/3/3, 103/5 to 1 Sridhara. Next, 29/4/2010, Rajgopal PB sold site number crore out of survey number 103/2, 10/3/5 to 1 Sridhara. Some of the landowners preferred a special leave petition before the Honorable Supreme Court challenging the order dated in writ appeal number so and so. Next, Idu Banduramasamy's case, 5/5/2010. Honorable Apex Court has upheld the order of the division bench so and so, so and so. Next, 26/7/2010, Manjula sold site bearing survey number bearing number 297 crore out of survey number 103/2, 10/3.
1 second.
Yes, sir.
How Apex Court treated the division bench judgment?
Sir, Apex Court has upheld the division bench judgment with further clarification, sir.
Very.
Yes. Sir, Apex Court judgment ಅಲ್ಲಿ yes, sir. Page 375, sir.
Foregoing, we
Noor
affirm the
Arvat, sir.
decision of the division bench
Is-
subject to the following further directions. and
Clarification. Yes, sir.
It added, it superadded the condition.
ಹೌದು ಸರ್.
It did not reduce the
ಮಾಡಿಫೈ
scope.
ಮಾಡಲಿಲ್ಲ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್.
Yes.
ಎಸ್ ಸರ್. ಇದು ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಐ ಸ್ಟಾಪ್ಡ್.
Or Raghu sold site bearing number 298.
ಎಸ್ ಸರ್. ರಘು ಸರ್.
Manjula sold.
ಮಂಜುಳಾ ಆಯ್ತು, ಮತ್ತೆ ರಘು ಪುನಃ ಮಾರ್ತಾರೆ 26/7/2010.
Correct.
ಮತ್ತೆ 18/3/2011 ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಪಾಸ್ಡ್ ರೆಸೊಲ್ಯೂಷನ್ ಸ್ಟೇಟಿಂಗ್ ದಟ್ ಲ್ಯಾಂಡ್ ಓನರ್ ಕ್ಯಾನ್ ಆಸ್ಕ್ ಫಾರ್ ಕಾಂಪನ್ಸೇಷನ್ ಇನ್ ದ ಫಾರ್ಮ್ ಆಫ್ 40% ಡೆವಲಪ್ಡ್ ಸೈಟ್ ಅಂಡರ್ 4060 ಸ್ಕೀಮ್. ನೆಕ್ಸ್ಟ್ 5/2/2012 ಶ್ರೀಧರ ಸೋಲ್ಡ್ ಸೈಟ್ ಬೇರಿಂಗ್ ನಂಬರ್ 299 ಕಾರ್ಡ್ ಔಟ್ ಆಫ್ so and so to the petitioner. Kindly mark this.
Yes.
5/7/2012 Sridhara sold site bearing number so and so to the petitioner. Next, 5/7/2012 Srinivas Rao sold the site bearing number so and so to the petitioner. Next, 5/7/2012 Srinivas Rao sold the site bearing number so and so to the petitioner. Next, Srimati Srimati Dodda Papamma and others filed a writ petition seeking mandamus directing the respondent to release the award of the compensation or alternative lands. Next, 26/7/2013, Honorable High Court has disposed of the writ petition in WP number directing the BDA to grant the cash compensation or the land in lieu of cash compensation in accordance with law.
Of that confirmation deed of Dodda Papamma is dated what?
Dated ಇಲ್ಲೇ ಬರ್ದಿದ್ದೀನಿ ಸರ್, 9/10/2013.
Next point.
ಹೌದು ಇದೆ ಸರ್.
ಅಲ್ಲ ಅದಲ್ಲ 9/10/2013 ನೋಟ್.
ಅದೇ 9/10 ಬರ್ದಿದ್ದೀನಿ.
First the
Sir,
GPA order.
26/8/2013, rectification deed executed by Lokesh in favor of the petitioner by inserting survey number 103/1 and 103/4 only after cancellation power of attorney. Next, sir. 9/10/2013, Dodda Papamma and KT Nagraj executed a confirmation deed in favor of the petitioner insofar as site
Who is
bearing.
KT Nagraj?
son
Son
of
of- son.
Son of Dodda Papamma.
four confirmation deeds. For each site, 4 confirmation.
ಸೇಮ್ ಡೇಲೇ ಇದೆ, ಎಲ್ಲ ಒಂದೇ ಡೇಟ್ ಇದೆ ಸರ್.
Okay.
Next, 14/2/2014, representation was given by the petitioner to BDA seeking denotification or deletion of land or deletion of site in question. Next, 18/6/2014, state government has issued a revised final notification for formation of Arkavati layout, including petitioner in survey number 103/4, sir. Justice Arvind Kumar Mudde notification challenge madidara. Ide notification.
Very same
Very
notification.
same. Next, 31/7/2014, Dodda Papamma and petitioner filed a writ petition in WP number 37446-2014 challenging the acquisition proceedings.
Status quo.
Honorable High Court has directed the parties to maintain status quo with regard to the possession as also nature of the property, sir. Next, 11/3/2014, BDA issued an endorsement stating that BDA has passed an award and possession has been taken, hence the same cannot be denotified. Next, 2/8/2016, land acquisition officer has passed an order by recommending the land compensation in lieu of compensation following the order dated 26/7/2013 passed in WP number so and so, and by considering the representation given by the Dodda Papamma dated so and so. BDA has allotted 4 sites to Srimati Dodda Papamma in lieu of cash compensation under 4060 scheme as under. Next.
This is the property which is not the subject property. It's
ಇಲ್ಲಿ
outside.
ಎಲ್ಲಾದ್ರೂ ಕೊಡ್ಬೋದು ಅಂತಿದೆ. 27/9/2021 ಸರ್. ಅದು ಇಷ್ಟು ಕೊಟ್ಟಿದೀವಿ ಸೈಟ್ಸ್ ಡೀಟೇಲ್ಸ್. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 12ರಲ್ಲಿ ಸರ್. 27/9/2021, Honorable High Court had disposed of the writ petition filed by the petitioner in WP number so has been rejected along the batch of by upholding the revised final notification.
Which
And-
included 103/4.
ಹೌದು ಸರ್. ಇಲ್ಲಿನ ಕೋಟ್ ಮಾಡಿದೀನಿ. The appellant writ petitioner who are claiming relief based on sale transaction which has taken place subsequent to issuance of PN would not be entitled to any protection, which I have already read, my lord, sir. Next, 9/12/2022, petitioner filed an application written arguments before the Honorable Justice K.N. Keshavan on a committee. 23/2/2023, Honorable Justice Keshavan, after hearing the petitioner, BDA passed an order by rejecting the claim of petitioner in WP and directed BDA to execute the sale deed in favor of the allottees of the site in survey number 103/4. ಅಲ್ಲಿ allot ಮಾಡಿಬಿಟ್ಟಿದ್ದೀವಿ. Petitioner filed a suit. My lords, kindly mark it. Petitioner has filed a suit bearing seeking permanent injunction in respect of suit scheduled property. Trial court dismissed the suit by exercising the power under Order 7, Rule 11. Suit is not maintainable after considering all issues raised by the petitioners. Next page is the bullet points, which is a point of my argument.
Conversion. Sale deeds. Locate
Bullet
sale
points.
deeds.
Just made a bullet points.
But don't direct the bullets to us.
Sorry, sir. Only at me, my lord.
Yes. But there are some countries where judges will have bulletproof cabin and then they hear the arguments.
Especially in the
Fortunately, it's not
international
like-
criminal courts, my lord.
Huh?
International criminal courts.
International criminal courts, they will have that way.
We're all protected.
And most important matters, there are allottees here. And the committee also directed the BDA to execute the sale. Allottees are not parties in these proceedings. In any event, if my lords, in any event, if court takes an opinion that the land is to be deleted, then allottees would be the affected party.
I don't even know who the allottees are, my lord.
No, they have said now.
I don't think they've given a description of the allottees.
Where have you said that you have allotted the sites?
My lords, in the before committee, one allotee is also party.
They were
Party,
party.
And they were, the single judge has asked them to approach the committee. Everything has to be decided by the.
First point I ಹೇಳೋದು ಬೇಡವಾ? ಇಷ್ಟಾದ್ಮೇಲೆ ಹೇಳಿದ್ರೆ.
Who are the allottees?
Because whichever way, if we
Correct,
want
sir.
to make an order, suppose in their absence, suppose we allow or if we reject, absolutely no
Yes, of
issues. But if you want us to hear on merits, then without them, we would not have heard at all. We have spent more than an hour now on this. But he says, panel counsel says they were parties before the committee.
Committee or parties, and the committee also heard both the petitioner, including allottees.
Only 4.
And committee has rejected the claim of the petitioner and directed the BDA to execute a sale in favor of the allottees.
There are only 5.
Order ಇದೆ.
When did you execute the sale deed?
Sale deed ಮಾಡ್ಲಿಲ್ಲ ಇನ್ನ ಸ್ಟೇಟಸ್ ಕೋ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ರಿಟ್ ಅಲ್ಲಿ.
Therefore, no interest is created in their.
Interest ಇಲ್ಲ ಅಲಾಟ್ ಆಗಿದೆ. Please come sale agreement.
No
Please
sale
come
deed.
sale
my lord.
agreement
There's no
ಆಗಿದೆ.
sale deed.
Please come sale.
Sale deeds have been executed.
ಇಲ್ಲ
Not
ಲೀಸ್
yet.
ಕಮ್ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಆಗಿದೆ ಅಂತೆ ಸರ್.
These come sale agreement.
ಹೌದು.
That is after filing of the petition or before?
ಮುಂಚೆನೆ ಆಗಿದೆ ಸರ್.
Before filing of the petition.
ಹೌದು.
Date, ಯಾವ ಡೇಟ್ ಕೊಡಿ?
ಎಸ್ ಸರ್. ಇಲ್ಲಿ ಕಮಿಟಿ ಆರ್ಡರ್ಲೇ ಇದೆ.
Committee order.
ಕಮಿಟಿ ಆರ್ಡರ್
This is filed on 24 April 2023.
ಹೌದು ಸರ್.
Committee order is dated?
ಸರ್ ಕಮಿಟಿ ಆರ್ಡರ್ ಇಸ್ ಡೇಟೆಡ್
23/2/23.
ಎಸ್ ಸರ್.
ನೀವು ಅಷ್ಟು ಫಾಸ್ಟ್ ಆಗಿ ಮಾಡ್ತಾರೆ ಸಾಮಾನ್ಯ ಮಾಡಲ್ಲ ನೀವು. ನಾವು ರಿಟ್ ಹಾಕಿ ಮಾಡಿದ್ರೆ ಮಾಡಲ್ಲ, ಎಷ್ಟು ಬೇಗನೆ ಆಗಿ ಹೋಗಿದೆ ಎಲ್ಲ.
ಪೇಜ್ 67 ಸರ್. ದಿ ಕ್ಲೇಮ್ ಪುಟ್ ಫೋರ್ತ್ ಬೈ ದಿ ಸೆಕೆಂಡ್ ಪಿಟಿಷನರ್ ಅಪ್ಲಿಕೆಂಟ್ಸ್ ಶ್ರೀಮತಿ ಇದು so and so. Next, subclause 3, BDA shall execute the sale deeds
Correct.
in favor of the allottees of the site found in survey number so and so. And thereafter BDA has to place the allottees in the position of the sites by removing the encroachment if any thereon ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಬರ್ತಾರೆ. That is dated?
ಇದು ಕಮಿಟಿ ಆರ್ಡರ್ ಡೇಟೆಡ್
23rd February.
23rd February sir.
23rd February.
ಹೌದು ಸರ್.
They have filed a petition on 24 April.
ಹೌದು ಸರ್.
In the meanwhile, you executed the sale deed.
ಸೇಲ್ ಡೀಡ್ ಆಗಿಲ್ಲ. ಸೇಲ್ ಡೀಡ್ ಆಗಿಲ್ಲ ಸರ್.
ಆಗಿಲ್ಲ.
Possession is with us only, Manoj. As your lordships can see, there's a building right in the heart.
ಸೇಲ್ ಡೀಡ್ ಆಗಿಲ್ಲ ಸರ್.
There's no sale deed, nothing has been done. Don't know what.
Probably because of the pressure of the allottee made me to move the matter.
All right, but say,
So the allottees are fully aware, my lawyer friend points out of the proceedings here.
Correct ಹೇಳ್ಬೇಕು.
ಲೀಸ್ ಕಮ್ ಸೇಲ್ ಕೊಟ್ಟಿರ ಅವರಿಗೆ?
ಕೊಟ್ಟಿದೀವಿ ಸರ್.
ಮತ್ತೆ ಲೀಸ್ ಕಮ್ ಸೇಲ್ ಇದ್ರು ಇಂಟ್ರೆಸ್ಟ್ ಕ್ರಿಯೇಟ್ ಆಗ್ತದೆ.
Copy thing. Allotment is ಅಂತ ಹೇಳಿದ್ರೆ ಅಷ್ಟೇ. That's all, there is no mention of any lease come
Sir,
sale.
lease come sale deed is mentioned.
No.
Just make a statement now.
ಇಲ್ಲಿಯಾ?
We'll record your statement.
ಓಎಸ್ಎಲ್ ಇದೆಯಾ? ಕೊಡಿ. ಈಗ ಟೈಮ್ ಇಲ್ಲ.
ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿರಿ ನೋಡಿ.
ಆ ಸೂತ್ರ ಪಾರ್ಟಿ ಮಾಡಿ.
ಇಂಥದ್ದೆಲ್ಲ ಫಸ್ಟ್ ಪಾಯಿಂಟ್ ಬಿಗಿನಿಂಗ್ ನಾಗೆ ಹೇಳ್ಬೇಕು. ಸೊ ದಟ್ ನಮ್ಗೆ ಒಂದು ತಾಸು ನಾವು ವೇಸ್ಟ್ ಅನ್ನಲ್ಲ. ಬಟ್ we could have said make party, not make party. ಏನಾರ ಒಂದು ಹೇಳಿ ಕೊಟ್ಟಿರ್ತಾ. ಈಗ ಅವ್ರು ಇಲ್ದಂಗೆ ನಾವು ಏನು ಆರ್ಡರ್ ಮಾಡ್ಲಿಕ್ಕೂ ನಮ್ಗೆ ಎಷ್ಟು ಸಮಸ್ಯೆ ಇದೆ.
ಸಮಸ್ಯೆ ಆಗ್ತದೆ ಸರ್. ಹೌದು.
To create a demise of a lease, you must first put the party in possession. There can't be a lease without possession. Manoj. Then it becomes an agreement to lease without possession. It has to be necessarily a lease.
Because definition
Where
itself
possession
says transfer of possession and enjoyment.
Enjoyment
Right
of the-
to possession, transfer of right to possession and enjoyment. Read section 105 ಯಾವ್ದು? Transfer of property act.
ಹೇಳಿದಾರ? My lords, may I just enlighten my lords? ನಂತರ ಕಾಪಿ ಇಲ್ಲ ಈಗ.
Lease of immovable property is a transfer of a right.
So right,
I know. but the
right to enjoyment.
To enjoy
If
such
right to
property.
enjoyment is given, whether he exercises right or not, ಅಲ್ಲಿ possession ಇದೆಯಾ? A lease of room property is a transfer of a right to enjoy such property made for a certain time, so and so. So if right to enjoyment is given,
Yes, not, but he can't, not.
enjoy unless possession is
Unless
given.
I have.
Now, how
in-
courts have interpreted?
But from what I know, Milord, is under the stamp act, for instance, Milord, the difference between an agreement to lease and a lease deed is possession, nothing else. An agreement, therefore, if you have to put a person in possession of the property, only then it will take the characteristics of a lease. If there's no possession, there's no lease.
ಆಮೇಲೆ ನಮ್ಮ ಜಸ್ಟಿಸ್ ರವೀಂದ್ರನ್ ಸಾಹೇಬ್ರದ್ದು ಒಂದು
Yes, his lordship has interpreted the difference.
ಪಾಪ ಮಾಸ್
Yes,
ಜಡ್ಜ್ಮೆಂಟ್.
exactly. He has interpreted the difference saying, if it's only an agreement to put a person in future into the property, then it is never a lease. deed.
But it's a right, it's only executory
Executory in
agreement.
nature, not an executed document.
ಯಾವ್ದದು judgment? ಅಯ್ಯಲ್ಲ?
My lords, sir, I'm sorry, there are additional things. Even sale deed also is being executed on it. 5 ಜನಕ್ಕೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿದಾರಂತೆ.
ಯಾವತ್ತು?
14.
2014.
14.
10 years before writ
ಹೌದು,
petition was filed.
ಹೌದು. That's what said this what is-
ಮಾಡಿದಾರಂತಲ್ಲ ಮತ್ತಲ್ಲಿ. At least now you have come to know they are saying that one now.
My dear friend said lease come sale deed, first allotment, now lease come sale deed become sale deed.
Matter of record, I'll produce this.
ಅಲ್ಲ ಹಾಗಲ್ಲ, ಫಸ್ಟ್ ಅವರು lease come sale deed ಮಾತ್ರ ಅಂತ ಹೇಳಿದ್ರು ಅದಕ್ಕೆ.
Very instruction.
Proper instructions sir.
Well,
ಅವ್ರು
sale-
ಸೇಲ್ ಡೀಡ್ ಆಗಿತ್ತು.
ಅದೇ-
Even if it is lease, had court has gone to the extent of saying, even if without lease, if there is allotment is there.
Some
It-
right is there.
Some right.
Now,
is
the
there.
point also is, we are claiming about 10,000 square feet out of the entire extent of 1 acre.
But
of
if
land.
that is so, why?
And
did
they
you-
say
you
they've
did
given
not
a
tell
lot-
it to the committee. We have already granted sale deed anta.
Sale deed
My lords,
will-
committee, my lords, in fact,
Not heard in the matter.
no, we have heard in the matter. My lords, committee has dealt with the claim of the petitioner,
Yeah,
has
the
not
direction
dealt.
is
No,
ಇಲ್ಲ.
there is a direction.
My lords, of course, my lords, even committee, because committee also approached there. The allotee also approached before the committee.
Totally, 1 acre.
Because
One acre.
the single judge has directed
One
all the
simple
parties
answer,
to
bro.
approach there.
103 is 1 acres. 103/4 is 1 acre of land. Our entitlement is 10,000 square feet of land out of 4 sites. Now, in 1 acre, if they've allotted to someone 4 sites, nothing more than that. Because there are only 4 allottees. That means leaves, because even if you take 50%, that is 20 guntas of land. So there must be
ನೀವು
additional land available without the presence of those allottees as well. Because
That's all
entire,
right. But anyway, then they have to be, they answer the description of necessary party in Razia Begum.
no, they answered.
At least ನೀವೇನಾದ್ರು now they are saying,
Yes, we'll,
at least now you could,
we'll do that, right?
petitioners,
I'm sure they are present in court. I can serve them here.
ಬಂದಿದ್ದಾರೆ ಬರ್ಲಿಲ್ಲ ಅಂತ sir. ಬರ್ಲಿಲ್ಲ
ಯಾರು?
ಕೋರ್ಟಿಗೆ ಬರ್ಲಿಲ್ಲ sir.
Allottees ಬಂದಿದ್ದಾರೆ ಅಂತ ಕೇಳಿದೆ ಅವ್ರು. ಇಲ್ಲ ಇದ್ರೆ.
they think that BDA has allotted, it will look after our interests ಅನ್ಕೊಂಡು. They are under that interest. But we can't, ಇಂಥವೆಲ್ಲ ಮೊದಲೇ ಹೇಳ್ಬಿಡ್ಬೇಕು. Otherwise ನೋಡಿ ಎಷ್ಟು ಟೈಮ್ ಮತ್ತೊಂದ್ಸರಿ ನಾವು ಹಿಯರಿಂಗ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
ಹೌದು.
Learned senior panel counsel appearing for the BDA submits that the subject sites along with other property have been allotted in favor of others who are not impleaded as parties to, who are not arrayed as parties to the writ petition.
Names is, yeah, that's it.
Writ petition. First off, at this stage, Mr. Dhan Chinnappa seeks leave of the court to take instructions from his clients and then come back as to what should be made in the circumstance. First off, call this matter after 2 weeks.
My lords, may have it next week more well. If I'm impleading them, I'll implead them.
ಅಲ್ಲ ಹೆಂಗೆ ಅವ್ರು ನೀವು ಹೇರ್ ಮಾಡ್ದಂಗೆ ನಾವು ಪಾರ್ಟ್ ಔಟ್ ಮಾಡ್ಲಿಕ್ಕೆ
I'll
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಗೊತ್ತಿಲ್ಲ. ನಮ್ ಕೇಳ್ದಂಗೆ ನೀವ್ಯಾಕೆ ಪಾರ್ಟ್ ಔಟ್ ಮಾಡಿದಿರಿ ಅಂತ ನಮ್ ಪ್ರಶ್ನೆ ಹಾಕಿದ್ರೆ ಮುಂದೆ ನಾವು ಅವ್ರಿಗೆ ಏನು ಉತ್ತರ
ಆಗಲ್ಲ. Next week ಹಾಕೊಂಡ್ರೆ I'll file the application itself.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇನ್ನೆಲ್ಲ ಮೊದ್ಲೇ ಹೇಳ್ಬೇಕು ಆಕ್ಚುಲಿ.
I didn't know about that. They
ಅಲ್ಲ
said,
ಅವ್ರಾದ್ರು ಈಗ
ಇಲ್ಲ ಅವ್ರ ಸೂಟ್ ಅಲ್ಲಿ ಅವ್ರೊಂದು
ಹಾ.
ಸೂಟ್ ಹಾಕ್ತಾರೆ ಅದ್ರಲ್ಲಿ allottees ನ ಪಾರ್ಟಿ ಮಾಡ್ತಾರೆ ಸೂಟ್ ಅಲ್ಲೇ ಇದೆ
ಅಲ್ಲ ನೀವು ಬೇರೆ ಯಾರನ್ನೋ ಮಾಡಿದ್ದೀರಾ ಅಂತ ಅಷ್ಟೇ.
ಆ ಪ್ಲೈನ್ ಸೂಟ್ ವಜಾ ಆಗ್ತದೆ
ಮಾಡಿದ್ದಾರೆ.
ಅದ್ರಲ್ಲೆಲ್ಲ allottees ಪಾರ್ಟಿ ಇದ್ದಾರೆ
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಪಾರ್ಟಿ
ಅನಕ್ಷರ R1 ಅವ್ರ ಇದ್ರಲ್ಲೇ ಇದೆ.
ಮತ್ತೆ
anyway,
ವಯಸ್ಸಾಕಿರೋದು ಅವರೇ ತಾನೆ.
we learned facts.
facts. I also learned some facts.
ಆಗ್ತದೆ ಸರಿ. ಎಷ್ಟು ಟೈಮ್ ಆಯ್ತು ನೋಡಿ, 1 hour ಗಿಂತ ಜಾಸ್ತಿ ಹೋಗ್ಬಿಡ್ತಿದೆ.
I'm sorry.
You also did.
I'm
not-
sorry, Mulata.
No, you also did not know that. Anyway, these things happen. These are all prices we pay. Yes,
Till number 9, yes, Anmati.
The interim order.
interim order to continue. Yes,
Yes, and 7 office. Application for delay has been filed today, my lord. There are all minor objections, my lord. I will do it in the course of the day, my lord. And the issue is pending before Supreme Court, my lord. Whether 194 LA proviso, whether the tax has to be deducted.
5 times.
Your lordship, I will do it today only, my lord. Application for delay has been.
5 times ಆಗಿದೆ already. ಹಂಗಾಗಿ so you have to pay something ಇನ್ಮೇಲೆ ಬೇರೆ ಬುಕ್ಸ್ ಕೊಟ್ಟರು ಪೇ ಮುಟ್ಟಲ್ಲ ನಮಗೆ. ಸ್ವಲ್ಪ ದುಡ್ಡು ಕೊಟ್ಟು ಬಿಡಿ.
Within 1:30, I will do it. my lord.
Huh?
Within 1:30.
That's all right, no problem.
Application for delay has been.
ಒಂದ್ಸರಿ
filed.
ಎರಡ್ ಸರಿ ಕರೆಕ್ಟ್ ಅದು ಅಲ್ಲ ಒಂದು ಕನ್ಸಿಡರ್ ಮಾಡೋಣಂತೆ. ನೋಟಿಸ್ ಮಾಡಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮಾಡಿ ಕೊಡಿ ಬೇಗನೆ ಕೂತ್ಕೊಂಡು
Please, my lord.
ಕೊಡಿ ಕೊಡಿ. 4 ಸರಿ 5 ಸರಿ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದು ಹೋಗ್ಬಿಟ್ರೆ ಬೇರೆ ಇದಾಗಿ ಹೋಗ್ತದೆ. ಕೊಡಿ
Please.
ಮಾಡಿಕೊಡಿ. ಅಪ್ಲಿಕೇಶನ್ ತರಿಸಿ
It's already filed. my lord.
ಅಲ್ಲಿಂದ ಪಡಿಸಾಗಿದೆ. ಅಪ್ಲಿಕೇಶನ್ ತರಿಸ್ಬಿಟ್ರಿ. Compliance to be done within 2 days. Post next week. Yes.
Number 10, yes, Anmati.
Page number 37 to 41, I am not relying upon, my lord. Those documents, my lord, it's not required for the consideration of the case, my lord.
Serial number?
10 days.
10, my lord. Page number 37 to 41, I will not rely upon those documents, my lord.
Opponent rely upon ಮಾಡೋದಿದ್ರೆ?
It's not required, my lord. They will also not rely upon, my
He
lord.
has told, he has whispered you.
No, my lord, that question will not arise, my lord. Only issue is, my lord, whether the notice issued by the assessing authority, only legal issue is involved, my lord.
Learned panel counsel submits that he would not bank upon page numbers?
37 to 41, my lord.
Page numbers 37 to 41. 41, full stop. He also adds that even the other side may not rely upon. Anyway, let us see. It's a strange argument, but let us see. Notice.
I may be permitted to take out notice, my lord.
Aye.
Number 11, YB Raviraj. Tata Krishna.
Yes. Yes. very
My
well.
lord, 18 days delay, my lord.
Conduct.
And office objection, my lord, legible copy. Actually, what is pure question of law is involved, my lord. My lordship had rendered, my lord, Wipro Limited judgment. Pure question of law. Either some single
Wipro.
judge just followed, my lord, Wipro Limited.
Where we refer to.
If the order giving effect is not, my lord, done within time, whether
That,
244 AB, one,
I remember, sir. We refer to Kalidasas, Raghuvamsha and Chanakya's Arthashastra. That judgment, that question arises here.
My lord, but as of admission, it can be taken next week, like.
Admission. Admission is a matter between appellant and court.
No, my lord,
I'm
we have
secretary.
engaged senior counsel for that.
Eh?
We have engaged senior counsel, Mr. K.K. Chaitanya, for that one. Can it be?
Correct, but admission, you want next week?
Yes.
All right. 2 weeks, like within a dispensary.
my lord, judgment, my lord, Wipro Limited judgment, we have come up in appeal before the division.
Was it not in appeal?
It is in appeal. my lord.
In appeal, still in appeal. Appeal is pending.
Pending.
Then let us see, next time. Yes.
Much of-
Number 12, YB Raviraj.
My lord, 121 days delay, my lord.
Notice. Dispensation idea
Yeah,
along with submission.
We'll take notice.
My lord, he's taking.
Issue notice, Shri so and so PS.
Lochana S. Babu.
Yes.
My lord, delay may be controlled.
Control ಮಾಡ್ಬೋದಾ?
We'd like to file an objection. my
You want
lord.
to file objection? All right.
Number 13,
Much of.
Government Advocate M. Krishnappa.
Acknowledgement of service is awaited, my lord.
Service is awaited.
Awaited,
Service is.
await.
Any, maybe taken up after 2 weeks, my lord, because the interim order granted got automatically vacated because the service was not,
In
steps
fact,
were not
my-
taken on time, my lord.
My learned friend may kindly take note of this. The respondents who are not served here, in fact, they did not represent before the tribunal. They may be dispensed with notice, may be
In any
dispensed
case,
with-
my
they
lord,
were-
we have
they-
already
they were-
taken steps, my
They,
lord.
they
After
were
2 weeks,
unrepresented before the
Huh?
KAT.
it may be taken up after 2 weeks, my lord. That is all.
Await. Right, await notice. Entry order ಇತ್ತನಲ್ಲಿ?
Interim order vacate ಆಯ್ತು ಸ್ವಾಮಿ. ನಮ್ಮ ಕಡೆಯಿಂದ there was, your lordship's order was to comply with the payment of process fee within a week's time. That was not done, my lord, by the
ಅದ್
concerned
ಮಾಡ್ಲಿಲ್ಲ,
officers.
ಎರಡನೇ ಸಲನು ಮಾಡ್ಲಿಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತು.
Now we have paid.
There was entry model.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ವೆಕೇಟ್ ಆಗಿದೆ.
Entry model. Vacate ಆಗಿದೆ ಅಂದ್ರೆ operation of order ಆಗಿತ್ತು. We had granted entry model.
Indeed, my lord. Yes, my lord.
Entry order was granted, subject to condition, and that stood vacated because condition was not complied with. First, learned AGA submits that there was some lapse on the part of his office, and lapse be condoned and entry order be continued. First up, we agree with this. Entry order continued. Yes,
Be grateful.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ರೆ ಪುನಃ ಬರಲ್ಲ.
Number 14, Sri Rajshekar.
For the petition, my lord, kindly seek pass over, my lord.
Pass over.
Please.
Brother, ಇವತ್ತು ಆಗ್ಲಿಕ್ಕೆಲ್ಲ ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
Steps in respect of our court.
ನೋಡಿ, steps within 1 week.
My lord, so short date, my lord, the
ಅಲ್ಲ,
petition is,
ಸ್ಟೆಪ್ ತೊಳಿ, ಸರ್ವಿಸ್ ಆಗಿ ಬರ್ಬೇಕು.
will serve it, my lord, today itself.
Within 1 week, post immediately after service.
My lord, so
Service
date-
ಆದ್ಮೇಲೆ ಮೆಮೊ ಮೂವ್ ಮಾಡಿ ತಗೊಂಡು. Yes,
Translation.
translation dispensed.
Number 15, Chetan AC.
Professor is appearing.
Yes, professor. ಅವ್ರಿಗೆ ಹೇಳಿ, ಪ್ರೊಫೆಸರ್ ನಮ್ಮ ಕಡೆ ನೋಡ್ಲಿಕ್ಕೆ. Professor has to look at us.
ನೋಡ್ತಾ ಇದ್ದೀನಿ. ನೋಡ್ತಾ. This is simple case.
ತಮ್ಮ ದೃಷ್ಟಿ ಬೀಳ್ಲಿ ಅಂತ
ಸರಿ.
ಹೇಳಿದ್ವಿ. ತಮ್ಮ ದೃಷ್ಟಿ ನಮ್ಮ ಮೇಲೆ ಬೀಳ್ಲಿ ಅನ್ನೋದಕ್ಕೆ ಹೇಳಿದ್ವಿ.
ಇಲ್ಲ, ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಈಗ ಸುಮಾರು 90 minutes ತಮ್ಮನ್ನೇ ನೋಡ್ತಾ ಇದ್ದೀನಿ.
ಅಷ್ಟು ಹೋಯ್ತು ಅದು. ಅದ್ರಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮಿಗೆ ಎಲ್ಲ ಸೀಲ್ ಡೀಡ್ ಮಾಡಿಕೊಟ್ಟೇವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ರು ಅವ್ರಿಗೆ.
Yes, yes.
Yes, sir.
Now the short question for consideration is this. Now the third respondent was granted a site under G category. Under G category.
Not maintainable.
Pursuant to the orders of this honorable court, the said site was cancelled. After the cancellation of the site was resumed by BDA and the site was allotted to me by an order on 14/8/2019.
There is one.
And thereafter,
Whether that immunity extends in personam.
no,
There is
well,
objection, office objection, professor.
yes.
Office objection raises, it says governor
Yeah.
cannot be made a party. That way it is clarified along with submission. What is the law on the point? We also do not much know.
With due respects, that immunity does not extend to
Person.
the either contractual transactions which the honorable governor would have entered earlier, or for the rights and liabilities that he has already incurred even before becoming the governor. Now, the instant case, the site was cancelled. That site was
Which is, we want
cancelled
to know
and it was resumed.
immunity, professor. Immunity of the governor, which is that famous judgment, apex court judgment
Please.
on that. Immunity of the governor.
Subsequently. 361.
361.
Article 361 is the
Constitution bench
provision.
judgment. Yes, sir.
Yes, article.
What is 361?
Yes.
Is it Rameshwara Dayal?
This is for. Yes,
Rameshwara Prasad.
Yes,
That
Rameshwar
judgment
Prasad.
considered.
Yeah, Bihar case.
Bihar case.
The Bihar case.
I think
Rameshwar.
this question is also, my vague memory says it is answered.
Rameshwar Prasad relating to.
Rameshwara Prasad versus State of Union of India, State of Bihar. The Constitution bench judgment. I think your question is also answered. I do not know
361 may
exactly.
kind.
Yes, sir.
Yes. Yes, even malafides, allegations of malafides against the governor. It was entertained in that case.
The president or the governor also not answered any court for the exercise of performance of powers and duties of his office for any act done or purported to done by him in the exercise and avoidance conduct of the district brought under review by any court or body of the course of conduct. 60, that is impeachment, provided for that nothing in this action has restricted the right of any person to bring appropriate proceedings against the government of India, the government of the state. So if act is not in discharge of the office of the governor, that is not protected. Professor out of station idara no?
Yes,
Bangalore.
if it is not a good
reason.
No, the facts are very simple. That question may not arise for the simple reason. The site was allotted to me. By playing a fraud on the court, by suppressing the information that the site has already been resumed from him and it has been allotted to me. There is no prayer for cancellation of the allotment. There is no prayer for setting aside the resumption that was done. Be that as it may, he obtains an order from this honorable court and immediately sells the property in favor of respondents 4 and 5. I have therefore sought for review of the order that was obtained by him at the hands of this honorable court as per Annexure A, page 11. Page 11.
Because of Shivdev Singh.
I am obliged. Yes.
Good.
1963 Supreme Court 1109, para 8.
The office objection as to the maintainability of writ petition is overruled after prima facie looking into the text of Article 361 of the Constitution of India as construed by the Apex Court in Rameshwara Prasad versus
2006.
Union of India. 2006
2 SCC 1
2006
Union
SCC.
of India.
Yes. First issue emergent full stop. We have also looked into the Apex Court decision in Shivdev Singh versus
Shivdev Singh versus State of Punjab.
State of Punjab.
AR 1963
Supreme Court, page
1909.
190. ನೀವು ಗೌರ್ಮೆಂಟ್ಗೆ ಅಪೀಲ್ ಆಗ್ತೀರಾ? Learned EGA
R1
EGA is requested to accept notice for first respondent, emergent notice to the rest. BDA.
I have sought for the innocuous interim order.
Panel counsel Sri M.E. Charate is requested to accept notice for the second respondent, emergent notice to the rest. What is the interim prayer, sir? Not to alienate. Interim order as prayed. As prayed. Not to alienate or not to encumber the property.
Because yes, not to encumber. Obliged.
Number 16. Anu Parnale.
For the petition, I seek for a passover, my lord. Senior
Passover.
counsel, please.
All right, please.
Hearing on yes, number 17. Yes, Anmati.
It may be called along with ITA 111 of 2024, my lord.
Call along with. Yes. ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿರಾ? ಕಾಪಿ ಅಪ್ಲಿಕೇಶನ್
Notice ಆಗಿಲ್ಲ.
ನೋಟಿಸ್ ಆಗಿಲ್ಲ. Okay. 18.
My lord, serial number 18, notice has to go 6 short day of 6 days delay.
All right.
Emergency.
Emergent notice.
Number 19. Government advocate.
ಏನಿಲ್ಲ. Special order. Yes.
Served on 355 days within 98.
Government advocate.
Government advocate.
ಯಾರು?
Review petition.
Review petition.
I'm appearing.
Yes.
in this matter, the issue relates to grant of benefit under 41C2 of the KCSR, my lord.
41C2.
C2.
Ah.
My lord, the benefit applies only to the junior commissioned officers or below, my lord.
Not
person-
of this category.
This person was a commissioned officer, my lord. He was a major.
So
Therefore-
JCO, junior commissioned officers, extra apply ಆಗ್ತದೆ and below.
And below, my lord. That is what KCSR 41.
ಓದಿ. ಅವ್ರೇನ್ ಮತ್ತೆ response is heard already.
But there was a mistake on the part of the government also, my lord.
All right.
We pointed out the wrong provision in para 3, it is recorded.
Delay condone ಮಾಡೋಣ.
Delay,
condone ಮಾಡಿ.
please.
ಮಕ್ಕಳು. Application in IA number 1 of 2024 supported by an affidavit seeks condonation of delay of 355 days in filing, Brooked in filing the appeal. Full stop. A plausible explanation has been offered. Full stop. Even otherwise, there is an arguable case for review. Since the benefit of the kind is arguably available to the officials of JCO or below cadre, comma, the respondent writ petitioner being of the above cadre. Delay condoned. Application allowed, delay condoned. Post after 2 weeks,
Please, grateful.
20 to 20. ಇದ್ರದ್ದು ಕಾಪಿ ಅವರಿಗೆ ಪೋಸ್ಟ್ ಮಾಡಿಬಿಡಿ ನೀವೇ. The review petitioner shall send a copy of this order to the respondent writ petitioner by speed post immediately. Now, if he wants to come, let him come. So we'll come back within few minutes.
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಸರ್, ಮಾಡಿ ಸರ್, ಮೇಡಮ್ ತೊಗೊಳ್ಳಿ. ನೋಟಿಸ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಾಕಿ.
ಇಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ. 2 days ಟೈಮ್ ಕೊಟ್ರಲ್ಲ ಅದಕ್ಕೆ ಅಲ್ಲೇ ಮಾಡೋಣ.
ಅಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅಲ್ಲೇ ಇದೆ ಕ್ವಶ್ಚನ್ ಪೇಪರ್ ಇದೆ. Nageshwara accepts notice for respondent. 20 ಎಷ್ಟು ಮೂರು ನೋಟಿಸ್ 2021 22.
Date is not given. I requested for a date. The order was granted.
also. ಎಷ್ಟಾಯ್ತು ಈಗ 16 ಆಯ್ತಾ? ಈಗ ಆಯ್ತಲ್ಲ.
7 ಆಗಿದೆ
Sir, sir. Sir,
ಒಂದಲ್ಲಿ ಒಳ್ಳೆ ಇಲ್ಲ.
Yes.
Serial number 20 to 22.
Take notice in this.
20 and serial number 20, my lord, 52 days delay.
I'll take note.
You will take notice.
You know, delay may be controlled, my lord, 52 days.
All right.
Delay me.
ನೋಡಮ್ಮ ಅಯ್ಯ ಹಾ
Number 21, IV Raviraj.
You know, 53 days delay.
ಹಾ you want to appear? All right.
You know, delay may be controlled.
ಅಯ್ಯ ಡಿಲೇ ಕಂಡು
And 22, my lord, 12 days.
ಫಾರ್ಮೆಟ್ ಮಾಡ್ಕೋಬೇಕು
22, IV Raviraj.
I'll appear.
12 days.
12 days, my lord.
Huh.
You know, the identical matter, my lord, in the case of the same SSC, the matter has been admitted.
Admitted. Allowed, delay condoned. We are told at the, we are told by the learned panel council appearing for the revenue that in identical fact matrix.
Same respondent.
That too between the same parties in ITA number 39/2025. Appeal of the revenue has been admitted and therefore this appeal also needs to be admitted. Full stop. We agree with the same. Appeal is admitted on the substantial questions of law enlisted in the pleadings. Which are as under. Okay. Call this appeal along with other appeal. Yes.
Number 23, Satish K.
It may be passed over, my lord. Age.
Passed over.
Passed over.
Pass over. Yes.
Admission matters, number 24, Mohan Maya.
The matter, my lord, where order of the learned, my lord, the authority's order, my lord, was based on a Gujarat judgment. That has been overruled by the Supreme Court, my lord, the last time.
Last occasion, my lord, it may be sent back, my lord, just one submission on instructions. My instructions are that irrespective of the following of the Gujarat High Court judgment, the SESTAC has passed an order on merits, so that may be recorded.
On merits also.
They have,
That to make that submission, fact should be available. You ಹೇಳಿದ್ದೆಲ್ಲ submission record ಮಾಡಿಕೊಳ್ಳೋದಿಲ್ಲ ನಮಗೆ.
they have considered the agreements.
Where is that? You have to demonstrate. If you demonstrate, if it's there, we'll consider. ಕೊಡಿ. ಭಾಳ ಅಂದ್ರೆ ಇವಾಗ ವೇಮೆಂಟ್ಲಿ ಅಪೋಸಿಟ್ ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳ್ಕೋಬಹುದು. ಬಟ್ ಇಲ್ಲದಂತ ಫ್ಯಾಕ್ಟ್ಸ್ ಅನ್ನು ಬರ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲಿದೆ ಅದಕ್ಕೋಸ್ಕರ.
First updates on that.
Learned senior advocate appearing for the appellant CC submits that the order of the tribunal, CSTAT, is structured on the basis of Gujarat High Court judgment. And the said judgment tagadu decision, and that the said decision has been overturned by the apex court in 2023.
2024, my lord, sorry.
2024 ಏನದು ಇದು citation ಏನು ಹೊರಡ್ರೆ
2023 SCC online SC 1593, my lord. ಅದನ್ನು ಕೊಟ್ಟಿ.
ನೋಡಮ್ಮ. Full stop. Next, learned senior panel counsel appearing for the revenue opposes the appeal contending that the judgment of the tribunal is even otherwise sustainable.
Please.
And therefore interference of this court is not called for. First, however, that aspect has not been demonstrated by drawing attention of the court to the contents of the order, impugned order. First, next paragraph. When the law is declared by the apex court after overturning the decision of a high court, comma, although that is not a ground for review, comma, that would become a very strong ground for appeal. First stop. Next paragraph. Since, only one sentence. since the substratum of the order withers away because of apex court decision rendered subsequently, comma, these appeals need to be favored. And accordingly, they are. First stop, appeals are allowed, impugned orders are set at naught. Matter remanded to the CSTAT for consideration afresh in accordance with law.
All contentions.
All contentions of the parties are kept open for peace. Okay.
All of them are not similar.
Same orders.
Different periods.
Separate order. ಅಲ್ಲಿ ಒಂದು ಕ್ವಶನ್ just ಫ್ರೇಮ್ ಮಾಡ್ಕೋಬೇಕು. When High Court order is reversed, whether order of the tribunal which is structured on that basis would be sustainable or not. First off, we answer the question in favor of the assessee. Okay.
Number 26, government advocate. M. Tirumalesh.
Lord's matter.
Yes.
Identical matter, my lords, your lordships were pleased to admit.
We have admitted.
My lords.
But
STRP 12 of 2024, question of whether input tax credit with respect to inputs that go into medical samples, free samples. Lords, same issue, different assessment here.
This appeal is admitted in terms of the questions of law.
Questions of law.
Questions of law framed at paragraph.
My lords. Paragraph 8 on page 11.
At page 11, which read as under. First, adadmele, we have also noted that similar matter is admitted by this court in ITA number, in
STRP number 12 of 2024.
12 of.
No, sorry,
This
11
is
of
12.
2020.
11 of 2020. First, call this appeal along with that appeal. Yes.
Number 28, 28.
Yes, Vani madam.
Question for consideration before your lordships, lords, whether the addition made merely based on the statement recorded during the search without there being any incriminating material, support of such addition is sustainable or not.
Take notice. Issue emergent notice. Learned Senior Panel Counsel Shri Raviraj is requested to accept notice for the respondent. Revenue, respond revenue. Are you on copy kodi?
Copy kodi.
Admit madboda? Appeal is admitted.
Page
on
number
the
23.
Following substantial questions of law at page 23 and 24,
Please.
23 and 24.
For further hearings, number 31, K. N. Subbareddy. Madhukar M. Deshpande.
Cross over.
Thirty-two, E. Sanmati, S. Parthasarthi.
Yes, sir. Yes.
Yes, ma'am.
Yes. Yes.
Your Lordship, in this case, Your Lordship, the assessing authority has made certain additions, my lord, on the ground that the transaction, what you have shown it in the return is not genuine and it's a colorable device. First point, my lord.
Why he calls it as colorable?
Your Lordship, it is colorable device, my lord, on the ground that in order to escape from payment of tax, to evade payment of tax, what they have done is they have introduced this assessee into the partnership firm.
But the returns filed by the assessee mentioning everything is accepted.
Your Lordship, what is relevant for this case is whether the firm has filed the return of income or not. That will not have any bearing in this case. The case of the department is that the introduction of this assessee into the partnership firm and subsequently retiring him, giving some benefit, it is a colorable device.
Why is it not
Inducing-
permissible in?
Your Lordship, the assessee is
Where
taking.
is the prohibition?
Your Lordship, the Honorable Supreme Court has said that if the partnership, in the partnership, if the partner retires from the firm, Your Lordship, there is no requirement for payment of tax. But at the same time, the department has to go into the genuineness of the transaction, the real transaction. In Sunil Siddhartha Bhai, my lord, whether the device, whether is there a device adopted by the assessee to.
You
That-
answer simple things we're asking
Yes,
you.
ma'am.
Is it open to the partners to retire from the partnership firm or not?
Your Lordship, it is open for them, my lord. Yes,
Okay. When they go out,
yes, my lord.
if something is given to them,
Yes, my lord.
is it permissible or not?
It is permissible, my lord. What they have done is, my lord, in order to escape from payment of tax when they receive this amount, he invested 7 crores. When he went out, my lord, from the partnership firm, he received around 24.5 crores. The difference, 16.5 crore, has been added by the assessee as a business income, stating that this retirement is fake. You are claiming 16.5 crores as a retirement benefit when you
Because of
retire.
the hugeness of the amount.
Yes, my lord. No,
Suppose if
be-
it's intellectual property.
Your Lordship, because of the real transaction in, my lord, they have suppressed. They have shown this admission and retirement to get out, they get rid of payment of tax. That is my first submission, my lord. In order to escape from payment of tax on this 16.5 crores, they only say that I have retired from the firm, therefore I am not liable to pay.
He became the partner on 22/10/2000, June 2001. He became partner in June 2000.
Yes, my lord. Your Lordship, he became partner, my lord, on 21/6/2001.
Correct. 21/6/2001.
2001. He retired from the partnership on 22/10/2003.
22/10/2003.
2003.
When he became the partner, he had invested 7 crores.
7 crore, my lord.
Ah.
When he retired, my lord, on 22/10/2003, he got 24.5 crores to his credit. Out of that, 16.5 crores is the difference amount. Therefore, we have added that.
1 second. What was the income of the firm as such, partnership firm, during that period?
Your Lordship, there is no, it was, Your Lordship, as per the return filed, they have stated that they have not conducted any operations during this year. That is admitted fact, my lord.
During between June 2001 and October 2003.
Yes, my lord.
They did not conduct any transaction.
Then there was no, it was not active. Even though the firm was there, it was not active.
Andre no active andre.
They had not commenced any commercial activities.
Where is that?
Your Lordship, it is there in the paper book filed by the assessee, my lord.
Show that.
Your Lordship, page number 38, my lord.
I don't know. Do fraud or it is impermissible enforcement, we can understand.
Your Lordship, assessment year 2004-5.
2000,
4-5. What is involved in this case, my lord? At page number 37, the firm's
tell page
page 37, my lord.
of the appeal book.
Paper book filed by the assessee, my lord.
Paper book filed by the assessee.
Yes, my lord.
Thirty-seven.
37, my lord. Your Lordship may kindly see the assessment year 2011-12.
Ah.
In the first one, my lord, on the right side. Your Lordship may kindly see the entire thing in the column, it is shown as nil. There is no, right side column, rupees admele. Nil, ante, entire thing. There is no transaction at all. They have not declared anything. Nil, your Lordship, on the right side column, my lord. Income from salary, income from also, all, everything income, it has been shown as nil. In the next page, your Lordship may kindly see page 38. Page 38, the firm has, next page, the firm has not commenced any commercial activities during the financial year and the total income of the firm is taken to be nil. Before that signing, my lord, before the signature.
To an outgoing partner,
Yes, my lord.
only income or profit earned alone should be given to him, or it is open to the firm. Saying that A, B, C, the
Yes, my lord.
C is a trouble creator.
Yes, my lord.
ನಾವು ಅವನಿಗೆ ಹೇಳ್ತೇವೆ ನೋಡು ನೀನು ಫರ್ಮಿಗೆ ರಿಟೈರ್ ಮಾಡಿಬಿಟ್ರೆ
ಹ್ಮ್.
ಒಂದು ಪ್ರಾಪರ್ಟಿ ಇದೆ ನಮ್ಮಲ್ಲಿ ಈ ಪ್ರಾಪರ್ಟಿ ಇಷ್ಟು ವ್ಯಾಲ್ಯೂ ನಿಮ್ಗೆ ಕೊಟ್ಟು ಬಿಡ್ತೇವೆ. ನೀನು ತರಕಾರಿ ಇಷ್ಟು ತಂದಿದ್ದಪ್ಪ 1 ಕೋಟಿ ತಂದಿದ್ದೆ,
Yes, my lord.
ನಿನಗೊಂದು 5 ಕೋಟಿ ಕೊಡ್ತೇವೆ, ಬಿಟ್ಟು ಹೋಗು, ನಮಗೊಂದು ಹೆಡ್ಡೇಕ್ ಬೇಡ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ.
Yes, my lord.
ಅಥವಾ ಹಿ ಹಿಮ್ಸೆಲ್ಫ್ ಮೇಸೆ
Yes, my lord.
ನಂದು ಇಂಟೆಲೆಕ್ಚುಯಲ್ IQ ಇಸ್ ವೆರಿ ಹೈ,
Yes, my lord.
ನಾನು ಬೇರೆ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ನಲ್ಲಿ ಇದ್ರೆ ಇನ್ನೂ ಜಾಸ್ತಿ ಬರ್ತದೆ, ನನ್ಗೆ ಇಲ್ಲಿ ವರ್ಕೌಟ್ ಆಗಲ್ಲ, ಹಾಗಾಗಿ ನಾನು ಬಿಟ್ಟು ಹೋಗ್ತೇನೆ.
Yes,
ಇಲ್ಲ ಬಿಡೋದು ಹೋಗೋದು ಬೇಡ, ನಿನಗೆ ಬೇರೆ ಒಂದು ವ್ಯವಸ್ಥೆ ಮಾಡ್ತೀವಿ ಅಂತ ಏನೋ ಒಂದು ಹೇಳ್ತಾರೆ. ಈ ಎರಡು ಸಿಚುವೇಶನ್ ಕಾಂಟ್ರಾಸ್ಟ್ ಮಾಡ್ಬೇಕು. ಅದನ್ನ ವಾಟ್ ಈಸ್ ಗಿವನ್ ಟು ಒನ್ ಆಫ್ ದ ಪಾರ್ಟ್ನರ್ಸ್
Yes, my lord.
ಆಫ್ ದ ಫರ್ಮ್, ಅದು ಏನು ಅಂತೀರಿ ನೀವು?
Your Lordship, that is retirement.
ಅದನ್ನ at his hands it is an income ಅಂತ ನೀವು ಟ್ರೀಟ್ ಮಾಡೋದು.
Yes, my lord. That is a business income of the assessee. The assessee is involved in the business of real estate. What his intention is, object of the assessee is to earn profits from making investments in the property.
Correct.
Your Lordship, originally what the assessee did was he entered into a partnership agreement with Dayanand Pai. Your Lordship, that is dated below 33/2001, wherein there was an agreement that you make investment in this property, we will give of 7 crores or 9 crores, whatever it may be. In return to that, I will give some 1 lakh square feet built up area. Your Lordship, after that, Lord, this they have taken up this modus operandi of admitting him as a partner in the firm and retiring him in order to evade tax on the built up area what he was supposed to get.
Instead of that,
He got this 24 crores. That is the only real transaction which has been taken place.
Therefore, you suspect it to be
Colorable
may not
device.
be genuine.
Just one paragraph from the Honorable Supreme Court judgment. Genuine firm ಹೇಗೆ decide ಮಾಡಬೇಕು, genuine ಇದೆಯಲ್ಲ one.
Tax planning as such is permitted.
It is
but tax
permitted.
Evasion is prohibited.
If it is within
Avoidance is prohibited.
4 corners of the act, they can do it.
ಅದು ಕಾರ್ನರ್ಸ್ ಎಲ್ಲಿದಾವು ಅಂತ 4 ಕಾರ್ನರ್ಸ್ ನೀವು ಹೇಳುವಲ್ಲಿ ಇದಾವೋ ಅಥವಾ ಇನ್ನು ವೈಡರ್ ಸ್ಪೇಸ್ ನಲ್ಲಿ ಇದಾವೋ ಅನ್ನೋದು ವಿಚ್ ಇಸ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್.
Your Lordship, page number 5, my lord. This is Sunil Siddhartha Bai versus Commissioner of Income Tax, my lord. The first citation, my lord. Your Lordship, in this case, the Honorable Supreme Court, my lord, at paragraph number 20, my lord. Page number 13, my lord.
We have decided.
Page number 13, we have decided.
Page 15.
Yes, my lord.
But we have decided these appeals on the assumption that the partnership firm in question is a genuine firm and not the result of a sham or unreal transaction, and that the transfer by the partner of his personal asset to the partnership firm represents a genuine intention to contribute to the share capital of the firm for the purpose of carrying on the partnership business. If the transfer of the personal asset by the assessee to a partnership in which he is or becomes a partner is merely a device or ruse for converting the asset into money which would substantially remain available of his benefit without liability to income tax on a capital gain. It will be open to the IT authorities to go behind the transaction and examine whether the transaction of creating the partnership is a genuine or sham transaction, and even where the partnership is genuine, the transaction of transferring the personal asset to the partnership firm represents a real attempt to contribute to the share capital of the partnership firm for the purpose of carrying on partnership business, or is nothing but a device or a ruse to convert the personal asset into the money substantially for the benefit of the assessee while evading tax on a capital gain. The ITO will be entitled to consider all the relevant indicia in this regard, whether the partnership is formed between the assessee and his wife and children or substantially limited to them, whether the personal asset is sold by the partnership firm soon after it is transferred by the assessee to it, whether the partnership firm has no substantial or real business or the record shows that there was no real need for the partnership firm for such capital contribution from the assessee. All these and other pertinent considerations may be taken into regard when the ITO enters upon a scrutiny of the transaction for in the task of determining whether a transaction is sham or illusory transaction or a device or ruse. He is entitled to penetrate the wheel covering it and ascertain the truth. What the
ಸ್ವಲ್ಪ ನಿಧಾನವಾಗಿರ್ಬೇಕು, ನಾವು ಪ್ರೊಸೆಸ್ ಮಾಡ್ಬೇಕಲ್ಲ. ನೀವೇನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಅಂತ ಸ್ವಲ್ಪ ಗ್ಯಾಪ್ ಕೊಡ್ಬೇಕು.
Sorry.
This judgment speaks of two things.
Yes, ma'am.
Number one, a fictitious firm
Yes, ma'am.
or a sham firm,
Yes, ma'am.
or firm is genuine but transaction is fictitious. Two aspects, these things.
Yes, ma'am.
ಎರಡನ್ನೂ ಅಸರ್ಟನ್ ಮಾಡುವಂತ ಅಥಾರಿಟಿ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಆಫೀಸರ್ಸ್ ಇರತ್ತೆ
Yes, ma'am.
ಅನ್ಕೊಂಡು ಹೇಳ್ತು.
Yes, ma'am.
ಅದನ್ನ ಯಾವ ರೀತಿ ಡಿಸೈಡ್ ಮಾಡಬೇಕು, ಇದು ಹಿಂಗ ಆಗಿದೆ ಇಲ್ಲ ಅನ್ಕೊಂಡು ಕಾಮನ್ ಸೆನ್ಸ್ ಅನ್ನು ಉಪೇಕ್ಷಣೆ ಮಾಡೋದು,
Yes, ma'am.
whether there are any principles evolved, because partnership law is very old law in England, whether that any ಇದನ್ನ ನಾರ್ಮೇಟಿವ್ ಬೇಸಿಸ್ ಏನ್ರ ಇದೆಯಾ ಇದು ಮಾಡ್ಲಿಕ್ಕೆ, ಹಿಂಗಿದ್ರೆ we should feel that it is indication of its being a fictitious transaction.
Yes,
Now firm, you don't doubt the genuineness of the firm as such,
Yes, ma'am.
because you have accepted the firm as an assessee, you have taken the return also, you have not reopened it either.
Yes, ma'am.
Therefore, you have accepted that firm is in existence. You don't doubt the existence of or genuineness of the firm as such.
Yes,
Number one. One second.
One, yes, ma'am.
ಪೂರ ಕೇಳ್ಕೊಬೇಕು. Or is it your case that even firm is fictitious apart from the transaction? Which is your case?
Your Lordship, my contention is that the firm, there is existence. There is no, it is not active on,
Correct.
it is actively not involved, but the
Firm is not doing the ಹಂಗು ಅನ್ನಂಗಿಲ್ಲ. ಈಗ ನಾವು ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್ ಮಾಡ್ತೀವಿ ನಾವು.
Yes,
ಏನು ಒಂದು ಪ್ರಾಪರ್ಟಿ ತಗೊಳ್ಳೋದು ಮಾರೋದಿರ್ತದೆ.
Yes.
ನಾನು ಈ ಪ್ರಾಪರ್ಟಿ ತಗೊಂಡು 10 ವರ್ಷ ಮಲ್ಕೊಳ್ತೇನೆ,
Yes, ma'am.
ಹೇಳಿದ್ರು ರೇಟ್ ಮ್ಯಾಲಕ್ಕೆ ಅಂತ.
Yes, ma'am.
10 ವರ್ಷ ಆದ್ಮೇಲೆ ನಾ ಮಾರ್ತೇನೆ. ಕ್ಯಾನ್ ಯು ಸೇ ದಟ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್ ಈಸ್ ಸ್ಲೀಪಿಂಗ್? ಇಟ್ಸ್ ಎ ವೇಟಿಂಗ್ ಜೆಸ್ಟೇಷನ್ ಪೀರಿಯಡ್ ನನಗೆ. ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅಂದ್ರೆ ಏನು, ಎವ್ರಿ ಡೇ ನಾವು ಕೇರ್ ಮಾರ್ಕೆಟ್ನಾಗ ಅಡ್ಡಾಡಿ ಹೂವು ಹಣ್ಣು ತೊಗೊಂಬಂದು ಪೂಜೆ ಮಾಡಿ ಅದ್ ಮಾಡೋ ಅಗತ್ಯ ಇಲ್ಲ. It the very fact that I want to wait so that the property prices shoot up and one fine day I sell them. Therefore, firm is not active. ಅಂದ್ರೆ ಅದು ಬಿಸಿನೆಸ್ ಏನು ಅನ್ನೋದ್ರ ಮೇಲೆ ಇರ್ತದೆ. ಮಿರ್ಚಿ ಮಾರುವಂತ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್ ಇದ್ರೆ ದಿವಸ ಮೆಣಸಿಕಾಯಿ ತೊಗೊಂಬರ್ಬೇಕು, ಹಿಟ್ ತೊಗೊಂಬರ್ಬೇಕು, ಎಣ್ಣೆ ತೊಗೊಂಬರ್ಬೇಕು, ಮಿರ್ಚಿ ಮಾಡ್ಬೇಕು, ಮಾರ್ಬೇಕು. ಹಂಗಿರಲ್ಲ ಇದು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಬಿಸಿನೆಸ್. Therefore, ಅವರು ಎಲ್ಲ ಇದರಲ್ಲಿ ನಿಲ್ ಅಂತ ಬರ್ದಾರೆ ಅರ್ಥ. Firm is inactive ಅನ್ನೋ ಕನ್ಕ್ಲೂಷನ್ ಬರ್ಲಿಕ್ಕೆ. That is what Lord Lindley,
Yes,
the great judge of House of Lords said. Lord Lindley said, you can't assume merely because transactions have not taken place The firm is sleeping, although partners may be sleeping for the benefit of the firm.
Your Lordship, chronology of the events drawn by the assessing authority will throw the light whether it is genuine or not. Just 2 pages from the assessment order to give the facts of the case, my Lord.
Yes. Read.
Your Lordship, assessment order is at page number 55, my Lord.
Pick 5.
Yes, my Lord, 55, my Lord. Your Lordship,
Yes.
in page number 65, my Lord, the relevant facts chronologically, the assessing authority brings out date-wise. Page 65, my Lord. In the middle of the page, your Lordship will get it.
So paragraph reading. Now we are not on same page nowadays. Judges and lawyers are not on same pages.
Your
Yes.
page 65 of my appeal memo, my Lord.
Appeal memo 65.
65.
Signature is there. In the result, appeal is allowed, assessment is quashed.
Your Lordship, running ink page 65, my Lord.
Him appeal nalli.
Appeal nalli, 200 of 2017 appeal
Ah.
memo, my Lord.
200 of 2017, correct.
Appeal memo, page 65, my Lord. Ink page, my Lord.
65.
Your Lordship,
ತೋರಿಸ್ಬಿಡಿ ಒಂದು ಸರಿ ಪೇಜ್ ಸರಿಯಾರ ಮಾಡಿಕೊಡಿ at least. One line order ಇದೆ ಅದರಲ್ಲಿ. Appeal is
Your Lordship, I'm sorry, in this is 76.
76. ಕೊಡಿ. At least page number ಆದ್ರೂ ಸರಿ ಹಾಕೋಬೇಕು.
Your Lordship, in the middle of the page, madam, Messrs. Bangalore Housing Development and Investment is a partnership firm formed in 1986. The facts relevant to the issue under consideration are as under. Number 1, Milord, Shri Dayanand Pai, one of the leading real estate developer, had entered into an agreement on 26/1/1985 for the purchase of property at so and so number, Milord. This is the Guntas at Lost Milord Morzaria Housing Complex. Second, Milord, second date 16/1/1986, a partnership firm by name so and so, Milord, was constituted. Number 3, I will go to just, I will only read relevant.
Correct.
On 16/1/1986, Dayanand Pai contributed his right, title and interest acquired consequent to the agreement of the partnership firm. The firm entered into an agreement on 4/2/1986 to buy the property.
Property bought on 29/9.
Yes, my Lord. The property was brought by way of sale deed executed on 29/9/1986. The firm has only once asset being property identified as Morzaria Housing Complex. All the monies required for investment were brought in by Medical Relief Society for South Canara, and profit sharing ratio between the partners was that Medical Relief Society had 99% share and Sri Dayanand Pai has 1% share. During the previous year relevant to assessment year 2001-2, the property was revalued and surplus on revaluation amounting to rupees 33 crore 46 lakh 99,000 was credited to the accounts of Sri Ramdas Pai. On 10/3/2001, Satish Pai was induced into the partnership firm, but without introduction of any capital. The profit sharing ratio became 98/1/1.
1:1.
1:1.
Yes.
To the partners of Medical Relief Society, Sri Dayanand Pai
And his son.
his son. On 30/3/2001, Sri Ramdas Pai, representing Medical Relief Society of South Canara, retired from the partnership, and the profit sharing ratio among the leftover partners became 50% each. The amount standing in the credit of Sri Ramdas Pai, basically representing the investment made and profit consequent to revaluation of property, was transferred to a loan account. On 21/6/2001, the Sri Dinesh Ranka entered into partnership, and profit sharing ratio of became 34% in favor of Sri Dayanand Pai, 33% in favor of Dinesh Ranka and Sri Satish Pai. On 23/6/2000.
One nimisha.
Yes, ma'am.
34, 33.
Yes, ma'am.
ಆಯ್ತು ಉಳಿದಿದ್ದು
And Satish Pai, my lord,
Which-
it is not mentioned.
is 33.
Is 33. my lord.
Okay.
No. On 23/6/2001, Sri Satish Pai retired from the partnership, surrendering his share in favor of Sri Dayanand Pai. Dinesh Ranka was continued with 33%. Amount of rupees 1 crore was invested by Sri Dinesh Ranka during the previous year 2001-2 and 6 crores during the previous year 2002-3. On 6/10/2003, the property was revalued and amount of rupees 16.5 crores was credited to the capital account of Sri Dinesh Ranka. On 6/10/2003, Sri Satish Pai was introduced to the partnership and the profit sharing ratio became 35%, 33% and 32% in favor of Dayanand Pai. Sri Dinesh Ranka and Sri Satish Pai is respectively. On 22/10/2003, Dinesh Ranka retired from the partnership and he was due an amount of rupees 23 crores 50 lakhs, being his capital investment of rupees 7 crores and the surplus of 16.5 crores. The amount of the 23.5 crores has been paid to Sri Dinesh Ranka during the period 5/11/2003 to 21/12/2003. As per the books of account of Bangalore Housing Development and Investment, the source of this money is Dayanand Pai, who happens to be the other partner. As could be seen, Sri Dayanand Pai intended to buy the property identified as Morzaria Housing Complex. Initially, the Medical Relief Society has brought in money. The property has been brought by the firm Mrs. Bangalore Housing Development and Investment, of which Sri Dayanand Pai and Medical Relief Society are partners. During 2000-2001, a revaluation has been made and a Medical Relief Society has drawn the surplus. During 2001-2002, Sri Dinesh Ranka has come in as a partner, and during 2003-4, he has walked out drawing surplus. On both the occasions, care has been taken to induct Sri Satish Pai just to prior to
the event of the retiring.
Of a partner, and once new partner inducted, Sri Satish Pai has retired. The fact that remains that both Medical Relief Society and Sri Dinesh Ranka have drawn the surplus in lieu of investment they made, but care has been taken to give a transaction a color of retirement benefit so as to shelter can be taken under the various decisions and avoid payment of taxes. For that matter, right from the inception of the firm till date, it has not carried out any activity, business activity, except for giving the property to IBC Knowledge Park Private Limited, wherein the surrendering right in 69% of land of 4 lakh square feet of built-up area to be received. Under the circumstances, partnership deeds drawn are only a device, and actual transaction of both Medical Relief Society and the Sri Dinesh Ranka are only with Dayanand Pai. Sri Dayanand Pai intended to buy the property. Medical Relief Society came in with the financial support later to facilitate commercial exploitation of the property by Sri Dayanand Pai. Medical Relief Society decided to take surplus and leave. At this juncture, Dinesh Ranka appears to have come with the financial support, and on later date, he has walked out with the surplus. The capital brought out by Sri Dinesh Ranka has been drawn by Sri Dayanand Pai. The real nature of transaction is financing for a right over the property and later relinquishment of rights on payment of value appreciation. The firm did not carry on any business activity either to accumulate profit or loss or to earn any goodwill, so that the partners relinquishing the rights and could attribute the surplus to such activity. Hence, under the circumstances, the amount of rupees 16.4 crore is taxable in the hands of Sri Dinesh Ranka.
How tribunal views this?
Your Lordship, this is second round of litigation before the tribunal. This honorable court remanded the matter.
How tribunal
Colorable
views this?
device ilvo, howdo ilvo anta tribunal, my lord, at page number, internal page 5, para 5, my lord. Page number 13, my lord.
13.
13, my lord. Tribunal judgment, internal page 5, my lord.
Para 5.
Para 5, my lord. We have considered the rival submissions, my lord. It starts with
Partnership deed is produced. It's reproduced.
yes, madam. Relevant paragraph, para 6, internal page 9.
where are the promises made to this assessee in the partnership deed? If he retires, what would be given to him?
That is in your lordship, the deed of retirement.
Reproduce ಆಗಿದೆ ನೋಡಿ.
Yes, ma'am.
ಅಲ್ಲಿ partnership deed,
Yes, ma'am.
they have reproduced at page para 5.
Yes, ma'am.
At the time of his
Yes, ma'am.
induction, correct?
Yes, ma'am. You'll,
That is 31 March 2001.
March 2001, my lord.
Yes, he is inducted. Suppose where is the retirement clause?
Your lordship, retirement clause.
See, come to
Yes, ma'am.
page 14, why he has been inducted. Please see the reason they have given. Second partner being experienced in development of properties in the nearby locality has been helping the first partner in securing various permissions under the ULC or Act and also obtaining a denotification from the acquisition proceedings, etc. Assisted the first partner on several ways in respect of the property agreed to be bought by the first partner. ಅಲ್ಲೊಂದು judgment ತೆಗಿರಿ. Dayananda Pai versus. Which is that? Sorry. No, not that. 1 second. Which is that judgment which Apex Court considered, Deepashri, the GVK Rao report? Which is that judgment? Under Cooperative Society, 1995, AR 95. Sayyid Khader versus so and so ಇರ್ಬೇಕು. Sorry, where his name and there are two more judgments where the land acquisition proceedings were upheld.
Yes, ma'am.
Mentioning Mr. Dayanand Pai. There are judgments. It also mentions GVK Rao report. Anybody remembers?
Citation of Syed Khan
Ah.
is 1995 to
Correct.
CC page 677.
Correct, agree. Sayyid Khader versus. And there is another judgment, brother. Just take out that HMT versus so and so. HMT Cooperative Housing Cooperative Society versus so and so. G. Ramaswamy had argued. Is that judgment?
HMT House Building Cooperative Society
Versus?
versus Syed Kadir on 21st February 1995.
Right. No, judgment.
Citation.
What else? And Acquisition Act. Karnataka Cooperative Societies Act. Karnataka High Court judgment on the pipe. In one judgment,
Yes, ma'am.
this court has held
Yes, ma'am.
the transactions of this person
Yes,
are
ma'am.
all bogus transactions. There is one judgment which went to apex court and affirmed also. Just take out that one. Research your head. Again. ಎಲ್ಲ ಅದೆಲ್ಲ ನೀವು ರಿಸರ್ಚ್ ಮಾಡ್ಕೊಂಡು ಬರ್ಬೇಕು ಇವತ್ತು ಹಂಗೆ ಎರಡು ಪೇಪರ್ಸ್ ಅಲ್ಲಿ ತಿರುಗಿಸಿ ಹೋಗ್ಬಿಟ್ರೆ ಹೆಂಗೆ ಹೌ ಎಸ್
Lordship, kindly see the conduct of the parties, my lord. To evade tax, this route has been taken. This is the modus operandi of the parties to not to pay the taxes. The Honorable Supreme Court subsequently in McDowell case, my lord,
yes, we'll come back to you. All. Yes, sir. Or any other point you want to address?
Your Lordship, if I don't succeed on these points, whether it is the capital receipt or revenue receipt, I have to argue, my lord. If I don't succeed on colorable device.
This is first factor.
Yes,
First ground. Then the second one is
suppose if it is said that it is not a colorable device, whether the income of profit of rupees 16.5 crores or 24.5 received by this assessee, whether it
is
can be
income or not.
income or not, whether it is a capital receipt, it is exempt. He is not liable to pay tax. If it is revenue receipt, he has to pay tax. On that point, the tribunal itself has not considered this point. It has to go back. Capital receipt or revenue receipt has not been dealt with.
Where have you taken up the substantial question of law?
Your Lordship, question number 3, my lord. Your Lord, whether on the facts and in the circumstances of the case, the tribunal is right in holding that a sum of rupees 16.5 crores received by SSC cannot be brought to tax under the head income, business income, as the same has been received on transfer of built-up area as held by assessing officer and confirmed by the Commissioner of Income Tax Appeals. This is not directly on that point. I can just.
This aspect is not considered by the
No, my
tribunal.
lord.
Yes.
Your Lordship, at the time of hearing, Your Lordship can them frame additional substantial of question of
Then
law. my lord.
even otherwise that
Otherwise, yes.
can be read. This is your submission. Yes, sir. Yes, please take your seat. Yes, sir.
Yes, your lordship. The verb.
Put on mic. Yes, sir.
Your lordship, in this case, the main question is whether the amount of 16.5 crores, which was taken back by the partner, the respondent here,
Taken back or taken?
is a respondent in this case.
Yes, but word is taken, not taken back. Your investment is 7 crore.
No, no. What
Six-
I,
six
see, I
plus
have
1
put
crore.
a capital of 7 crore when I become the partner in 2001,
Correct.
21st June
21, 6,
2001.
2001.
2001.
Yes.
And I retired from the firm on 22/10/2023.
Three.
At that time,
2003.
after 2 years. And I had been given 23 crores 50,000 rupees, 50 lakhs. So my additional amount I received
It's not 2 years, it is 1 year, 4 months.
to that how money has come. The money has come because of the revaluation of the asset. The firm has got a asset with a 13 crores, which is under development. The value of the asset was revalued. Capital of each partner has been increased to the extent of the valuation. That is how the 16.5 crores has been added, which I withdrew when I retired. So it is not an income of the firm to consider as income in my hand. It is a capital receipt. There are a number of judgments to support that case. So any amount in excess of the original capital, if I receive, it is a capital receipt.
When
I'm not liable to tax.
When you gained entry to the firm.
But firm,
No, we have a question.
yes,
You gained entry to the firm
Hmm.
on 21/6/2001.
One.
What was the asset value?
At the time, asset value, the book value only see what of your option.
Let us see the book value.
The book value is what I can give what has been reflected in the firm's account. I will.
Let us see.
Yeah.
Let us see.
31st March 31, 21, 2001. Like that.
How within 1 year, 4 months,
Yes, yes.
that leap appreciation can
No, that,
take?
because your lordship, the value of the asset shown as on 21st June 21 was the original value. See, the firm actually revalue asset only later.
For with retrospective effect, profit will be given to you.
No, what happened is, as the partnership is concerned, as on the date of retirement, whatever capital is there, you can withdraw. The capital is on account of enhanced valuation of the asset.
Now, when you gained entry, the value of the asset holding is X.
Yes, yes.
When you left, it is X plus Y. That Y component, can it be more than 207%?
No, that is, I would like to submit that you also.
Yes.
When I was admitted into the firm, the value reflected in the balance sheet is not real market value as on the day. That is
But
not so.
the value when you left was also not the market value.
No, but that means we actually revalued it. We say to enhance the capital, my potential, it was revalued. Your lordship is, the firm is, that asset belongs to the firm at every point of time. It is not something somebody contributed into the firm and somebody taking it away by way of either property or cash equivalent. This asset was purchased by the firm as early as 1986. And the same value reflected in the balance sheet keep on year after year. Though the increased valuation never been reflected. But now we wanted to revalue it because the firm is taking off this time after this man retired. This also for
We'll take an extreme example.
Your lordship?
We'll take an extreme example to assess the consequences of accepting your argument now.
Yes.
You entered the partnership firm.
Yeah.
Not on 21/6.
Yes.
But you entered it on 22/6/2003.
No, your lordship.
Second.
Yes, yes.
Just
Yes,
logic.
Yes, yes, sir.
Logic,
I will listen. I will listen to you.
Ah, in logic, if you want to understand, take the extreme example, says Chanakya. Now we are putting an example of your own case. We are altering the date now.
Yes.
You come to the firm on Padya and you go out on Purnima. But firm owned the property.
Yes.
Since 1857.
Yes.
The second
Yes.
struggle for independence in the country. Value of the property in 1857 to 2003.
Yes.
That will be in exponential growth of value of the real estate. You mean to say you were there in the firm
Yes.
for 15 days. And whatever appreciation took place from 1857 to 1947 to 2003, October 1 to October 14.
Yes.
You are entitled to whole entire appreciation. That gives doubt to the human mind.
Your Lordship, my point, I request Honorable Court, my submission. When I become a partner, the potential of the firm would have been much, much higher. But what is reflected in the balance sheet is that amount. So real value to be ascertained, I revalue the asset, which had happened in 2003. And
Revalue the asset, well and good. You are
Right.
entitled to, for me, is entitled to.
Yes.
But with effect from which date you are doing that, which is the baseline for that revaluation?
When I became a partner in
That should be
2001.
your entry point. Your entry
That
point.
was 2001.
Your exit point. Between these two, we can understand. Little this side, that side also we can understand.
Your Lordship, my point is when I entered into the partnership, inducted into the partnership, though the balance sheet shows lower value, real value also shows much more. It is not necessity the partner should revalue at every time. At the time of admission, they decide not to revalue the asset. The basic, Your Lordship, here, from the preamble of the partnership, this man has an expertise. It was inducted into the firm for the purpose of development of this property. It was gone for a period of.
What is his qualification?
He's a developer.
No, what is his educational qualification?
Qualification exactly, I'm not. Well, he was in the business and he was doing lot of projects and other things. He has got expertise in planning, getting all the licenses, and also to put up construction. So this expertise is available. Firm is going a property, so he was inducted into the partnership to develop the property, then to share the profit by all the partners. And he has contributed capital also. It is not a make-believe. He simply entered and came out with, he put his capital and substantial capital. And see, between the partners, there was some controversy. He decided to retire. He didn't want to continue. And 2003, he retired. Your Lordship may notice here, the firm was constituted in 1986 between Ramdas Pai, Dayanand Pai. Then his brother Satish Pai joined. That is on 30th March 2001, a little before. Then he retired on 21/6/2001, Mr. Satish Pai. And this Dinesh Ranga was inducted. And you remember, Your Lordship, in 2003, Dinesh Ranga goes out, Satish Pai is brought in because there was some family dispute, something would have been there.
Yes.
So we are not concerned
No, that's
about
not
that.
the case. That is not the case here.
That's not the case here.
Absolutely no family dispute at all.
No, there would have been.
That would have been
so many things.
that
But
is
here is the
some,
case.
Foundational
yes.
facts.
Here,
Argument.
the Dinesh Ranga came out because of some misunderstanding.
That is not the case, Santa.
No, what I want to say, why he has come out suddenly, that question could have been there because it's not been brought out record why it has come, how it happened, no. He retired and Satish Pai was inducted. It's a reconstitution of the firm. And at the time they decided to value all the assets of the firm. each partner's share has been decided. I mean, found,
All right, we'll come back.
recorded.
After we have meeting now, appointment of recruitment of judges meeting we have got now. We'll come back.
Not much.
Yes.
ಕೊಡಿ ಮಿಡಲ್ ಹೇಳಿರುತ್ತೆ ಬೋಗಸ್ ಅಂತ
ಬೋಗಸ್ ಅಂತ ನಾನು ಹುಡುಕ್ತಾ ಇದ್ದೀನಿ, ನನಗೆ ಸಿಗ್ತಿಲ್ಲ.
ಇನ್ನೊಂದು HMT ಅಲ್ಲ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಹೇಳಿದ್ರು
Diamond price, bogus. He said the bogus 110.
Police transactions bogus ಅಂತ ಎಲ್ಲೋ ಹೇಳಿದ್ದಾರೆ.
Syed Khader.
ಸೈಯದ್ ಖಾದರ್ ಕೊಡಿ.
In internet slow ಇದೆ. ಹಾ ಸರ್, ಓಕೆ ಸರ್. ಮನುಪತ್ರ citation, but you will.
ರವೀಂದ್ರ ಅವರೇ, ಇಲ್ಲಿ ಯಾರೋ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಹೌದಾ?
ಇದನ್ನ ಕಳ್ಸಕ್ಕೆ ಮೇಲ್ ಮಾಡಕ್ಕಾಗತ್ತೆ.
ಯಾಕೆ ಓಪನ್ ಆಗ್ತಾ ಇದೆಯಾ?
ಶೇರ್ ಅಂತ ಇರುತ್ತೆ ನೋಡಿ.
ನಿಂಗೆ ಯಾಕೆ ರಿಸ್ಕ್? ಬಾಂಬ್ಗೆ ಬಿಕ್ಕಿದ್ರೆ ಡಮಾರ್ ಇಟ್ಟಿರ್ತೇವೆ. ಅವ್ನು ನೋಡಿ ಬಾಂಬ್ ಅವತ್ತು ಎಲ್ಲಿ ಬತ್ತವನೆ.
ನಿಮ್ದು ಇದೆ ಸರ್.
SANM 80 HI dot dot EI E for England, I for India, I at the rate of Gmail.
Sir, you know, Sanmati, what is the subject? Whatever, income tax. Sorry, ಇದೇನೋ ಹೋಗ್ತಾ ಇಲ್ಲ. ಸುಮ್ಮನೆ ತಗೊಂಡು. We'll get it. Supreme Court.
ಇದೆ ಸರ್.
Trying to.
ಇದೊಂದು ಸ್ವಲ್ಪ ಆಯ್ತು ಅಂತ.
Okay, thank you.
But the Diamond 5 bogus.
ಮೇಡಮ್, ಯಾರ ಬಂದು ಕೇಳಿದ್ರೆ ಫೋನ್ ಇಲ್ಲೇ ಇರ್ತದೆ.
ತೆಕ್ಕೊಂಡ್ಬಿಡಿ ಸರ್, ಇದು ಬರೋದು. ಅಯ್ಯೋ ಇಲ್ಲೇ ಐತೆ. ಬಿಟ್ಟೋಗಿದ್ದಾರೆ, ಮತ್ತೆ ಏನೋ ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಾಗ್ತಿಲ್ಲ. ನೀವು ಅದು ಕಾಲ್ ಮಾಡಿ ಯಾರ್ದು ಗೊತ್ತಾಗ್ಬಿಟ್ಟಲ್ಲ. ಬಂದಿದ್ರಿ ಯಾರು ಬಂದಿಲ್ಲ. ಸರ್ ಇಲ್ಲೇ ಇದೆ, ಬನ್ನಿ ಅಂತ ಹೇಳಿ ಯಾರು ಅಂತ. ಏನ್ ಹೆಸರು ಅವ್ರದ್ದು? ಶಂಕರ್ ನಾಯ್ಕ್. ಶ್ರೀಧರ್ ಆರಂಭಿ ಯಾರು?
ಶ್ರೀಧರ್ ಆರಂಭಿ ಇದೆಯಾ? ಹಾ, ಇಲ್ಲಿದೆ ಮೇಡಮ್, ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಎಲ್ಲಿದ್ದೀರಾ? ಬಂದ್ಬಿಡಿ. ಇಲ್ಲಿ 7 ಅಲ್ಲಿ ನಾನು ತಗೊಳ್ಳ
ಸ್ವಲ್ಪ
ನಾನು ಇಲ್ಲೇ ಇರ್ತೀನಿ 13 ಅಲ್ಲಿ. ಅವ್ರನ್ನ ಕಳಿಸ್ತೀನಿ.
ಇಲ್ಲೇ ಇದ್ರೆ ಪೋರ್ಟಲ್ ಅಲ್ಲಿ ಬಂದು ಕೇಳ್ಬೇಕಲ್ಲ ಸರ್.
ಹಂಗಾದ್ರೆ ಅವ್ರು ಬರ್ತಾರೆ.
ಅವ್ರ ಹೆಸರೇನು? ಮಿಸ್ ವಾಯ್ಸ್ ಕಾಲ್ ಅಲ್ಲಿಂದ ಬಂದಿದ್ಯಲ್ಲ.
ನಾನು ಕಾಲ್ ಮಾಡಿದ್ರೆ ಯಾವ ಬೇರೆ ಯಾವುದೇ ಕೇಸ್ ಅವ್ರಿಗೆ ಕಳಿಸ್ತೀನಿ.
ಮುಖ ನೋಡ್ಬಿಟ್ಟು ಕೊಡ್ತೀನಿ. ಫೋನ್ ಇದ್ರೆ ನೀವೇನ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ನೋಡ್ಬಿಟ್ರೆ ಇಟ್ಟಿರ್ತೀನಿ ಇಲ್ಲಿ. ಅದು ಫೋಟೋಸ್ ಲಿಸ್ಟಲ್ಲಿ ಅವ್ರ ಮುಖ ತೋರ್ಸುದು ಅವ್ರದ್ದು ಇದ್ರೆ ಕೊಡೋಣ. ಅಲ್ಲ ಏನಂದ್ರೆ ಅವ್ರ ಮುಖ ಇವ್ರೇ ಬಂದಿದ್ರೆ ಅವ್ರ ಇದ್ರಲ್ಲಿ ಏನೇನು ಯಾರು 55 ಇದ್ರಲ್ಲಿ ಏನೇನು ನಿಮ್ದೇನ ಮೊಬೈಲು? ಬರ್ಬೇಕಲ್ಲ ಸರ್?
ಇದೆ 31. ಯಾರು ಅಡ್ವೊಕೇಟ್? ಪಾಸ್ ಓವರ್. ಲತೀಫ್ ಸರ್ ಫೋನ್ ಮಾಡಿ. ಲತೀಫ್ ಸರ್ ಅಡ್ವೊಕೇಟ್ ನಿಮ್ಮ ಹತ್ರ ಕೊಡ್ಲಿಕ್ಕೆ. ಇದೆ ಹಾಫ್ ಡೇ ಅಂದಿದ್ರು. ಆಫ್ಟರ್ನೂನ್ ಹಾಫ್ ಡೇ ಅಂತ ಈಗ ಫುಲ್ ಡೇ ಅಂತ ನೋಡೋಣ. ಫುಲ್ ಖುಷಿ. ಇವತ್ತಾಗತ್ ಬಿಡಿ, ಎಷ್ಟು ಜನ ಆಗುತ್ತೆ. 4 ಗಂಟೆ ಮೇಲೆ ಅದೆಲ್ಲ ಕೂತ್ಕೊಳ್ಳಲ್ಲ. ಏನ್ ಬೇಡ ಬೇಡ, ನಾವೆಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ವಿ ಎಲ್ಲ ಮ್ಯಾಟರ್ಸು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ. ತಮಗೆ ಫೋನ್ ಮಾಡಿದ್ರು, ತಮಗೆ ಫೋನ್ ಮಾಡಿದ್ರು ಯಾರು ಅಷ್ಟೊಂದು ಮಾಡಿದ್ರೆ ಅಂತ ಮಾಡ್ಬೇಕು. ನಾನು ಹೆಣ್ಣು ಕಲಿ ಮಾಡಿದ್ರೆ ಊಟ ಮಾಡ್ಬೇಕಾ, ಗಾಡಿ ಓಡಿಸ್ಬಾರ್ದ? ಎಲ್ಲ ಹೋಗಿದೆ, ನಾನು ಚೆಕ್ ಮಾಡ್ಬಿಡು. ಪೆಂಡಿಂಗ್ ಬರ್ತಿದೆ, ಸ್ಪೋರ್ಟಿಂಗ್ ಬರ್ತಿದೆ. ಹೇಳ್ತೀನಿ, ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ. ಕೊಟ್ಟಿದ್ದೀನಿ ಸರಿ. ಕುಡಿ, ನಾವು ಅವತ್ತೇ ಕಳಿಸ್ತೀವಿ. ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಬೆಂಚ್ ಇದ್ರೆ ಕಳಿಸ್ತೀವಿ. ಬೆಂಚ್ ಜೋಶಿ ಸಾಹೇಬ್ ಬೆಂಚ್ ಹಾಕ್ತಾ ಇದೆ. ಶುಕ್ರವಾರ ಬೆಂಚ್ ಜೋಶಿ ಸಾಹೇಬ್. ಹಾ, ಮಧ್ಯಾಹ್ನ ಊಟ ಮುಗಿಸ್ಕೊಂಡಿದ್ದೀರಾ?
ಕೋರ್ಟ್ ಕಲ್ಲಪ್ಪ ನೋಡಿ Serial
ಕ್ಲಾಸ್ ತೊಗೊಳಕ್ ಬಂದಿದ್ದೀರಾ ನನಗೆ?
ಗ್ಲಾಸರಿ ಏನೋ ಕ್ಲಾಸ್ ಈಗ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಬೇಡ ಅಂದ್ರು.
Exact figure. I'll give you the exact figure.
Yes.
They filed a new paper book, Your Lordship. Paper. What is filed today?
Today.
At page 5.
Page number?
Page number 5.
It is filed today.
Today.
You have served a copy on him.
Yes, yes.
We'll call it tomorrow. Just look into and tell us. Yes. And bring your short notes of arguments.
Yeah.
Yes. Because it runs into 78 pages. If
Yes.
you have given it today, then he has to at least glance once. We'll call this on Monday. Okay. Monday, further hearing.
Your Lordship, when?
Monday?
Tuesday.
Tuesday.
Next Tuesday.
Next Tuesday. Yes. Please bring your notes of arguments also.
Yes, Your Lordship.
Yes.
Much obliged.
My office have already filed it. In view of this additional document, I will file additional one.
Just see them and
I will make the complete this thing, Mrs. Madam.
yes. Yes.
Outdoor matters.
Hmm.
For 16.
What was the date it was circulated?
Now, this circular will not direct that circular out there. No, in our case,
Yes.
the stand of the government is that you have proceeded to
Register the
documents without this e-khata. Normal manual khata is there. Without e-khata, you have registered is the allegation.
Where is that allegation?
Yes, Lord, kindly see page 96 is the Shokat notice,
96.
second para. ಸದರಿ ವರದಿಯಲ್ಲಿ ದಸ್ತಾವೇಜುಗಳ ನೋಂದಣಿಯನ್ನು ಈ ಸ್ವತ್ತು ಒಂದು ಅಂತರಾಂಶದಿಂದ ಈ ಖಾತಾ ಪಡೆಯದೆ ಇಂಟಿಗ್ರೇಷನ್ ವಿಧಾನ ಅನುಸರಿಸದೆ 140 ದಸ್ತಾವೇಜುಗಳನ್ನು ಸರ್ಕಾರ ಆದೇಶದ ಸಂಖ್ಯೆ 12/9/24ರಂದು
ಈ ಖಾತಾ ಇಲ್ದಂಗೆ ಅಥವಾ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಾರ್ಮೇಟಿವ್ ಪ್ರೊಸೆಸ್ ಏನೇನಿದೆ ಏನೇನ್ ಬೇಕು ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
ಅಲ್ಲ ಅದರಲ್ಲಿ ಅದೇ ದಟ್ ದಿ ಮ್ಯಾನ್ಯುಯಲ್ ಖಾತಾ ಇಸ್ ದೇರ್.
ಅಲ್ಲ, we do not know.
Yeah.
What is the real requirement? What is the protocol?
But
All the documents should be there for registration of property.
ಅದರಲ್ಲಿ what is required is only there, my lord, under section 21 to identify the area.
21 of Karnataka
21 of the Registration Act.
Karnataka Registration Act. ಕರ್ನಾಟಕ ರಿಜಿಸ್ಟ್ರೇಷನ್ ರೂಲ್ಸು ಇರಬೇಕು.
ರೂಲ್ಸು ಇದೆ. ರೂಲ್ಸ್ ಅಲ್ಲಿ ಅದೇ 171 ಡೀಲ್ಸ್ ವಿತ್ ರೀಸನ್ ಫಾರ್ ರೆಫ್ಯೂಸಲ್ ಟು ರಿಜಿಸ್ಟರ್. ಅದು ಯಾವ್ದ್ರಲ್ಲೂ ಇದು ಬರೋಲ್ಲ. ಓನ್ಲಿ ಥಿಂಗ್ ಇಸ್ ಲ್ಯಾಂಡ್ ಶುಡ್ ಬಿ ಐಡೆಂಟಿಫೈಯಬಲ್. ದಟ್ ಈಸ್ ದ ಓನ್ಲಿ ರೀಸನ್. But what, my lord, in an earlier proceeding, this issue came up when they refused to register. This court said that if you have any such objection that a particular document is to be registered, you should modify your software and make it as part of the software itself. Otherwise, failing which, Document which is not contemplated under the Registration Act cannot be insisted on that basis, a document cannot be refused. Unless they say, suppose a person has a manual khata, I cannot say, well, that is sufficient to identify along with other document. Now the state says, now in all sub-registrar's office, they are registering on the basis of the manual khata. But however, they have targeted 2 sub-registrars, that is one in this case and one in my case. But in all cases, it is going on, saying that on manual khata it is being done. But the government circular, which is issued, kindly see.
What is the power of the government to issue circular? Where
That
is
is
the power
important.
of the government?
That is important. Earlier, they had issued a circular under 22A. That is under the Registration Act, which was quashed by this court. Matter is pending before the Supreme Court.
Yes.
Adu stay agide earlier.
The one which Bhagwat had argued.
Earlier.
Here had argued. That was 10 years ago. So and so.
Now, this issue, there are 2 provisions which becomes relevant.
Yes.
One is section 21 or 22.
Please read.
Yeah. 21 only says, section 21, no non-testamentary document relating to immovable property shall be accepted for registration unless it contains a description of such property sufficient to identify the same. Houses and towns shall be described as situated in north or other side of the street or road to which they front and by their existing former occupancies by their numbers in the house, so and so. But this also does not enable government to issue a circular. This is
Any power given to government to issue circular,
yes, that
clarification,
cannot,
etc.
is not, I could not lay, according to me, there is no such power. Hello.
Under Indian Registration Act also?
22A nal baralla adu. Rajasthan or that was the relied upon by.
Correct. Circulars. Is decided.
22A only says, state government may by notification in the official gazette declare that registration of any document or class of document is opposed to public policy.
That's all.
It
can't say this should be the procedure of registration. Which law normates the registration process?
Well, Registration Act and rules only. Yes. Section 17 deals with
17 deals with what are compulsorily registrable,
yes,
non-testamentary.
and how it should be, inquiry should be done under 34.
34.
And that whether he is the person executant, verify his identity. And then on what grounds a document can be refused is provided in the rules also. That is quite exhaustive.
On what ground?
Yes.
The sub-registrar can refuse to register
yes,
a document.
Yes.
But
Rule 171 of the registration rules.
Karnataka registration rules, huh?
Yes.
171. Yes. ಅದು shall ಹಂಗೆ ಹೇಳಲ್ಲ ಅದು. Registration shall not be done ಅಂತ ಹಿಂಗೇನೋ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ ನಾವು.
Reasons for refusal to register. When registration is refused, the reason for shall be recorded in the book. They will usually come under one or more of the heads mentioned below. ಆ ತರ ಬರುತ್ತೆ.
ಈ ಖಾತಾ ಈ generated under which law?
ಈ ಖಾತಾ is under Land Revenue Act.
Under which law? ಈ ಖಾತಾ is generated
Executive order ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
So we have in respect of properties, my lords, which come within the Gram Panchayat limits. My lords, the Gram Panchayat rules have been amended. In respect of BBMP limits, corporation limits, my lords, the rule has been amended and the software has been provided, my lords, where
Rule amended to the effect?
My lords, I recollect, my lords, with regard to the Gram Panchayat rules, with regard to municipal corporations, my lords, this question, they are not urged before the KAT. This is falling from my lords, my lords.
What is your power to say?
Please, my lords.
See, courts have said.
Please, my lords.
The act of registering a document is quasi-judicial, largely quasi-judicial in nature. Justice Case Seged's judgment, very old judgment. If it is a quasi-judicial power, what is the power of the government to prescribe? You should have this document. You may have power.
Please.
Show that power.
Lords, what we are saying is this. What we have actually done is, we have, my lords, digitalized the khata in so far, my lords, as the corporations, my lords, and the gram panchayats are concerned. Now that is, my lords, under a particular software. We have integrated.
Where is your power? When he can register, means registration is the rule.
Please.
Refusal to register a document is an exception.
Please.
That's how Justice J.P. Shivaprakash broadly has held like that. Anyway, now read 171, Rule 171. 171 indicates
Reasons for refusal to register.
they will usually come under one or more of the heads mentioned below.
Please.
Document written in language with the registering officer does not understand. He cannot register it.
Please, my lords.
So A, B, C, D, so and so,
Okay,
in which it comes.
Lords, this question was not raised. Can I have a day's time? I'll do it. My lords, my lords, insofar as I've got all the details pertaining, my lords, to how we have communicated it, my lords, and whatever queries.
You might have committed 100 things.
Hello,
We are asking,
Hello,
what is, ours is ours limited, the government is a basic feature. Ours is a limited government.
Lords, either
Basu's book, D.D. Basu's thesis on a
since this was
PhD.
Not even part of the pleadings, my lords. Can I just have a day's time, my lords? Tomorrow morning I'll. Please.
How, ನೋಡಿ ನಾಳೆ ಮತ್ತೆ ಹಿಂಗ್ ಬೇರೆ ಏನೋ ಹೇಳ್ಬೇಡಿ, ಈಗ ಇಷ್ಟ ಬೇಕು ನನಗೆ.
Please.
The registration process is normative.
Please.
Rules say it should be done like this. Ordinarily, A, B, C, D are the grounds on which he can refuse to register.
Please.
Because refusal to register will have drastic consequences, because where a document is compulsorily registrable, if it is not registered, the intended transaction does not come into force. Section 48, 49 of the Registration Act. Therefore, it's a very serious matter. Under which law e-khata is generated?
Please.
Which law empowers the government to tell the sub-registrars, you shall not register the documents unless A, B, C, D documents are on your table?
Okay.
Where is that power?
I'll answer
that. And it is not the government, who issued that circular?
Lords, it is a government order issued by the.
Government order.
Executive power.
Which sector? Where is the executive power? It is covered by the legislation.
No, this is.
Field is covered by the registration.
Field is covered by the legislation.
Then where is the question of
No,
executive
lords, if
power?
there, I will demonstrate, lords. I will.
ಅದನ್ನ ಇದನ್ನ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. Bijo Emmanuel, where field is covered, of course, you have only argued that.
So that is my lord, sir.
Yes.
I will not even
To
let-
youngsters, we are saying that BC Justice B.K. Mukherjee's judgment, Ram Jawaya Kapoor versus State of Punjab, and Lakshmindra Tirtha Swamiyar versus, that is Shirur Mutt case. Then 86 Supreme Court, Bijo Emmanuel versus State of Kerala, which has been reiterated in Puttaswamy 2 perhaps. Just look into and come back.
Please.
Okay.
It's covered, my lords, by statute. There is no argument at all.
That's what.
Please, my lord. And only if I can fill in the gaps.
It is covered ಅಂದ್ರೆ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ನಲ್ಲಿ ಏನ್ ಹೇಳ್ಯಾರ ಅದಷ್ಟೇ ಕವರ್, ಇನ್ನು ಉಳಿದಿದ್ನೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಅಂತಂದ್ರೆ ಅದನ್ನ ಒಪ್ಪಿಲ್ಲ
ಇಲ್ಲ,
ಸುಪ್ರೀಂ
ಇಲ್ಲ,
ಕೋರ್ಟ್.
ಅದು ಒಪ್ಪಲ್ಲ, ಅದು.
ಹಾ,
That's the point. There-
ಇದ್ರಲ್ಲಿ ಏನಿದೆಯಲ್ಲ ಇಷ್ಟನ್ನೇ ಮಾಡ್ಬೇಕು ನೀವು.
Please.
That is the idea of limited government. Limited government. It's a famous book by D.D. Basu.
No, my lords, there is a
His
separate
thesis.
challenge to the e-khata. I'll just.
Let us see. Not, what's your, you can't, you cannot treat these quasi judicial authorities as your SDCs. Yes. Tomorrow not possible. Monday ಹಾಕೋತೇವೆ ಇದನ್ನ.
Please.
Tomorrow, day after, special bench ಇದೆ ಅದಕ್ಕೆ. Okay. Okay.
Procedural matters, number 23.
Yes.
Similar.
Similar.
Same.
Follow along with. Okay.
Procedural matters, number 31. K. N. Subbareddy.
2015 matter.
Madhukar Deshpande.
Matter relating to,
Huh?
matter relating to undi, installation of undi in the temple, my lord.
In the temple. Installation of hundi. Who has installed?
Trustees.
Is it the section 23-24 temple or just another ordinary temple? Notified temple? Notified temple. Government district deputy commissioner wants to put the hundi there. In particular place in the temple. These are the facts of the case. Now, we have read and come back. Where is your power to do that?
My colleague is in this matter.
Colleague is appearing. Next week ಹಾಕೋಣ ಅಷ್ಟೇ ಕೇಸ್ ಅದು. ನೀವು ಅಲ್ಲಿ ಹೋಗಿ ಹುಂಡಿ ಇಡ್ತೇವೆ ಅಂತ ಹೇಳ್ತೀರಿ. ಹುಂಡಿ ಯಾವ ಜಾಗದಲ್ಲಿ ಇಡಬೇಕು ಏನು, ಟೆಂಪಲ್ ಒಳಗಡೆ ಏನ್ ಮಾಡ್ಬೋದು, to whom that domain belongs to whom? What apex court said in Shirur Math case. That you have to say. Shirur Math case and Dharmasthala matter with KK. Mr. Nambiar had argued that matter before Pi bench. Take out that judgment, I think 1960s. The floor of the temple belongs to whom is the question. To put it in the words, the floor of the church belongs to whom? The American Supreme Court used to ask. Similar doctrine, almost like that. Yes. Next week, at the request of learned government advocate, finally. Next week time ಕೊಡಂಗಿಲ್ಲ. Argue ಮಾಡ್ಬೇಕು.
Number 34, Sanmati.
For 2 weeks time, so the instruction of the reassessment orders ಇದೆ. So
All right, 2 weeks at the request of the panel council. Yes. Next.
Number 36, Nagaraj S. Jain, K. Prasanna Shetty.
Point number 2.
Where is your friend? Here.
Next week.
Next week ಹಾಕೋಣ. Call next week to enable Nagaraj Jain to come and argue.
Number 37, Dilip M. Lochana S. Babu.
My lords, in this matter, my lords, additional solicitor general is engaged. My lords, kindly have this matter, my lords, on the second week of April, my lords. My lords,
AST coming from Delhi,
my lords, from here itself,
from here only.
here. My lords, there is one,
Shankar.
A matter which has been followed by the tribunal, the Bombay High Court is pending with the Supreme Court, and that is likely to be listed on 2nd of April.
2nd of April.
Then we will call it little later.
Better.
Nodi.
After vacation.
Second week of April, please. At the request of both the sides, call this matter in the second week of April. Since some questions are being debated, some similar questions are being debated on the floor of the apex court of the country. Yes.
38, Prithvish.
Prithvish.
Number 36.
36 ಎಲ್ಲಿದ್ರಿ ನೀವು? ಮತ್ತಿರ್ಲೇ ಇಲ್ಲಲ್ಲ ಕೊಡಿ. ಯಾರು? Next week ಹಾಕೋತಾರೆ. He wants to file objections next week ಹಾಕೊಂಡು ನಾಗರಾಜ್.
Question is
ಅವ್ರೇನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೇವೆ ಅಂತ ಮುಂದಿನ
honorably acquitted.
ಅದೇ.
That's all the question.
Okay, ನೋಡೋಣ.
ನಾವು ರಾಮನಾರ್ ಕೇಸ್ ಮಾಡಿ ಒಂದು 5 ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿದ್ವಿ.
ಯಾರು? PV ರುದ್ರಪ್ಪ.
ಹೌದು, ರುದ್ರಪ್ಪ.
PV ರುದ್ರಪ್ಪನ?
ಹೌದು, PV ರುದ್ರಪ್ಪ and other.
Yes. Next week ಬರುತ್ತೆ. Okay. Yes.
Number 38, Prithvish.
Yes.
This is regarding promotion to backlog vacancies.
Yes.
Total cadre strength is 14 in the
You want
residual
to
cadre.
In the
Yes.
connected matter, he appears since he's
Ah.
senior.
It relates to determination of the backlog vacancies.
Yes.
But how it has to be done and who has to do it is the issue involved. But the present issue relates to, my lord, promotion to the post of range fire officer, regional fire officers from the cadre of district fire officers.
ಏನಾರ ಅರ್ಜೆನ್ಸಿ ಇದೆಯೇನೋ?
There is an interim order
Operating against us.
against them, therefore they,
My application has been partly allowed by the tribunal, and tribunal has directed consideration of our cases. That has been
ನಮ್ಗೆ
stayed.
ಓದೋದಾಗಿಲ್ಲ ಅದಕ್ಕೆ ಬೇರೆ
Status quo order has been-
ಓದ್ಕೊಂಬಂದ್ವಿ ಇವೆಲ್ಲ ಟೈಮ್ ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ರು. ನಾವ್ ಯಾವ ಓದಿಲ್ಲ ಈಗ ನಡೆಸ್ಬೇಕು ಅಂತ
Ultimately,
ನೀವು
my
ಬಟ್
lord,
ನಮ್ಗೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡಿ. We'll also read and come back so
Please.
that we can save
Question
time.
is this one.
Ah.
Whether whatever be the nomenclature they give, whether roster can operate once the fixed percentage of reservation is reached.
It
For
cannot ಅಂತ.
Karnataka. It 15, at that point of time, 15% and 3% was the reservation. R.K. Sabharwal says, the moment fixed percentage is reached, operation of roster stops. Thereafter it is only replacement. And no, my lord, sir.
ಅಂದ್ರೆ ರಿಪ್ಲೇಸ್ಮೆಂಟ್ ಅಂದ್ರೆ ಎಲ್ಲೆಲ್ಲಿ ಯಾವ್ದಾವ ವೇಕೆನ್ಸಿ ಆಗ್ತದೆ ಆಯಾ ವೇಕೆನ್ಸಿಗೆ ಆಯಾ ಕ್ಯಾಂಡಿಡೇಟ್
before that,
Replacement
my lord,
case.
before coming to that position, my lord, what the government order 13/4/99 says is, not this is followed by 3/2/99 government order, which is, my lord, placing reliance on the Sabharwal's case. What the subsequent government order says is, my lord, until and unless all the backlog vacancies are filled up,
That is
the roster shall be operated.
That
Then only the roster would be stopped operating. Determination of the percentage of 15% and 3% would be only after filling up of all the backlog vacancies.
Yeah,
That issue has not been considered by the tribunal, my lord, while deciding the issue.
Well, factually also, factually also, my lord, there are no backlogs which can be pointed.
That is,
out.
they
Apart from
themselves say that
backlogs-
there are 2+1 backlog in the pleadings.
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ಕೊಳ್ಳಿ ಗವರ್ಮೆಂಟ್ ಹೇಳ್ಬೇಕು ಏನಿದೆ
Yes.
ಅಂತ.
Government is also in petition,
In favor of the
as challenged
petitioners
it.
as supporting the.
According to them, roster operates eternally, which is frowned upon, and the Nagaraj, which went from Karnataka Act only, Supreme Court said
It
that
ceases.
50% is the norm. Subsequently, it has been reiterated in Judicial Election Law. Some states ventured to increase it beyond 50%, notably Chhattisgarh and Bihar. Those two have been set aside, and Supreme Court has admitted the appeal, but no stay has been granted. Now, my lord, as against a cadre strength of 13, 11 people, 14, 11 people are belonging to SC.
And that is including persons who have been promoted, my lord, on the basis of their own seniority. That cannot be termed as a determination for 15% and 3%.
On the guise of filling up vacancy, my lord, at any point of time, the strength cannot exceed the 17% and 7%
No, no.
cutoff, which is fixed by the state.
The question is, when a person belonging to a reserved category is promoted on the strength of his merit and seniority, would he occupy the roster
Even
point
excluding
fixed
that,
for
it comes to
SC
10.
Or is it GM
Yes.
candidate?
That's the question.
That is issue,
Now
that
the
issue is already decided, my lord.
Tribunal says that though you are filled up in term of your
Seniority.
seniority, you occupy not only the general merit roster, but also the roster point belonging to a scheduled caste or scheduled tribe. And therefore, by promotion of one person, 2 roster points are occupied.
Let them tell, my lord.
And it has to be counted.
I agree.
The finding
that,
of the tribunal is.
I agree, my lord. There is a say that if according to his seniority has been promoted, he cannot be counted against this.
At all.
Let them say who are the persons.
Yes.
Even excluding that, out of 11, it will come to A6.
That's a
Lords,
fact.
I have-
Therefore, tribunal is wrong. Striking
Tribunal
down
is
all
wrong.
our promotions, tribunal even.
Tribunal
going
is
by
wrong
learned
to the
senior
extent
counsel
it did not
judgment is
allow
wrong.
my application fully. But I am satisfied with what it has said, therefore I am not questioning.
ಇಷ್ಟೇ ಕೇಸ್.
Ište case.
ಇಷ್ಟೇ ತಾನೆ?
Yes.
ಬೇರೆ ಬೇರೆ ಏನಾರ ಹೇಳೋದಿದೆಯಾ?
My lord, one more issue is, my lord, my lord, it is as per the 1992 rules, my lord, it is the social welfare department which has to, my lord, determine that. Yes, my lord. But now the tribunal comes to conclusion, no, it is only the DPR which has to maintain the roster and the, my lord, determination of backlog vacancies. That may not be correct, my lord. And secondly, my lord, one circular was issued on, in 2021 specifically stating that, my lord, the persons who are promoted against their own seniority and promotion, they cannot be counted to determine 15% and 3%. But that the tribunal comes to conclusion, my lord, that the circular is contrary to the directions issued by the tribunal, which has not attained finality at all. My lord, on that count, my lord, the application of the order of the tribunal has to go.
One more.
I have filed detailed synopsis, my
Tribunal
lords.
says-
Detail, I have
Tribunal says, my lord, these back, I'm sorry.
Gopal.
Ultimately, whatever the tribunal may say,
15% is a simple arithmetic calculation.
15%
and 7%, 17% and 7%. Yeah, just
even otherwise, that does not, it
Yes.
cannot exceed that
Yes.
one.
Whomsoever they exclude, it exceeds.
Allah, those who came to that position based upon seniority and
Yes.
merit, they
Yes.
have to be excluded.
Yes.
Not that one.
Huh?
It's not that.
That, yes.
Suppose, my lords, district fire officer is the feeder cadre. In that, a seniority list is there. According to their seniority in the district forest or the district fire officer's cadre, and in turn, according to his seniority, if a person is promoted, he cannot be taken into consideration for computing 15%.
Correct.
Avarni exclude madidrunu, it exceeds 70%.
17%.
70% of the cadre
70%.
strength. It cannot be. And the state's
true.
argument is.
Not correct.
Not
Not
correct.
the social welfare department has issued the,
Arithmetical calculation.
Well, it's
It can be ascertained from the
easily,
records
my lords.
whether
My lords,
it
total strength is 16, my lords.
Huh?
Total strength is 16. 16.
16.
Yes, my lords. For the cadre of regional fire officers. Out of this 16, 2 posts for Hyderabad, Karnataka region.
exceeds. 16 is the cadre strength.
Howdo. Out of this, 2 posts for Hyderabad, Karnataka region. Cadre strength for the post of regional fire officer.
That's what.
Ah.
That means 14.
14.
2.
14. No, 16 minus 2. 14.
That's what.
14.
I said 14 plus 2.
Please, my lords. Out of this 14, 1 post is occupied.
1 second.
Out of this 14, 1 post is occupied.
Yes.
So what remains is 13.
13.
Out of this 13, now on the guise of filling up backlog vacancies, 6 persons belonging to the caste of scheduled caste and 2 persons belonging to the caste of scheduled tribe have been promoted. So out of 18, 13 persons.
1 second.
Out of 13, 8 persons.
Out of 13,
8 persons.
8 are SCs.
6 are
6
SC.
are SCs. 2 are STs.
STs. In the total strength of 14 mallots, now 6 plus 2, 8. This is more than, as the learned senior council submitted, more than 70%. 14 ಅಲ್ಲಿ 8 ಆದರೆ 14 ಅಲ್ಲಿ 7 ಆದರೆ 50, 8 ಆದರೆ more than 60% ಆಯ್ತು. But this is
You want to find
ಅಲ್ಲ ಇದು
not the
fact.
correct way of calculation.
Absolutely.
How?
I'll put it this way. That under Article 16, backlog vacancies form a separate order, separate class. The calculation of backlog vacancies are not placed before your launch. Now let's
ಅಲ್ಲ cadre strength 16.
ಅಲ್ಲ ಅದಕ್ಕೆ ಹಳೇದು ಬ್ಯಾಕ್ಲಾಗ್ ವೇಕೆನ್ಸೀಸ್ ಬರ್ತಾ ಇರುತ್ತಲ್ಲ ಅದೆಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಟ್
Running account.
that is how it has to be calculated.
ಫೀಡರ್ seniority tribunal, and tribunal comes to a conclusion, my lords, that the roster point maintained in the promotional cadre is wrong. Feeder cadre seniority basic list is not placed, and this is how, my lords, tribunal has determined. My lords, I will, and one of the most important, tribunal does not say there is no backlog vacancy. It says backlog vacancy is there, but law of limitation applies. I point out the exact paragraph and the sentence where tribunal says law of limitation applies for filling up backlog vacancy.
Because there is a delay in identifying the backlog vacancies by the social welfare department. We are not entitled to be appointed against the backlog vacancy is the finding of the tribunal.
For limitation law to apply to backlog vacancies.
Here the problem is social welfare department. He behaves as if it is a super cadre controlling authority. When the issue was what is the backlog and came, the departmental committee was asked to examine the question. It has given a finding. There is a backlog of 3 in SC, 2 in ST. That is increased to 11 and 2 by the Social Welfare Department. Reservation Act says Social Welfare Department shall be the nodal agency. Let me consider, but the ultimately it is an arithmetical question. 15% ಯಾವಾಗ reach ಆಯ್ತು 2% irrespective. Manods backlog concept was introduced.
But running account ಬೇಕಾಗ್ತದೆ.
Running account cannot be continued. That is what Supreme Court has said. Para 5 and 6 of R.K. Sabharwal. Thereafter, Nagaraj reiterated that post-based roster is mandatory to keep the reservation within 50%.
Now it exceeds nearly 70%.
It exceeds nearly 70%.
Lords, may I submit this
Backlog,
synopsis,
insofar
my
as-
lords?
Lords, one submission. So far as calculation of backlog is concerned, it is the stand of the state, my lords, that the backlog vacancies will not be considered for the purpose of calculation of the representation. That is 15% and 3% earlier, my lords.
On
Now
what
it has changed.
basis is the question?
No, there is a circular earlier, my lords, we said it will be considered, it was immediately amended, that circular, my lords, is also part of the record. Only question I would respectfully submit is about calculation. In fact, we have placed, my lords, the correct calculation, and even the written submissions that was placed before the tribunal stated, they had also placed the written submission with regard to how the calculation error was there. We had placed it how the calculation error, it is only a matter of calculation. Insofar as if it is a question of principle is concerned, backlog, my lords, I will be able to demonstrate, but that insofar as the state policy is concerned, while the backlog vacancies will not be filling up of backlog vacancies and representation, my lords, are two different things. Because backlog is in a running roster, in an earlier point, that point has not been filled. That is the concept of a backlog.
But once entire roster points are exhausted,
Please, my lord.
still you cannot operate.
Because Sabharwal actually stated that once Sabharwal, my lord, spoke about the moment you run the roster point cycle once, then in future there is no question of running it, it becomes post-based. But my lord, there the concept is about you moving to a total post-based system. Insofar as the state of Karnataka, we will not follow the running roster across board continuously. But even while following running roster, we have said, if in the second cycle or the third cycle, if the roster point is, my lords, for a SC or a ST point, then if the representation has reached, you skip, then it will be filled up. It will be filled up in accordance with seniority. That is how we are doing it.
It becomes a general merit.
General, under yaar senior irta general merit prakara. You don't fill it. Representation is reached, roster will jump. That's all. That is how we have run. And my lords, there is two other concepts: post-based and, my lords, vacancy-based. Insofar as post-based, insofar as the state,
Our roster is post-based or vacancy?
no, my lords,
Post-based.
with regard to filling up of direct recruitment and promotion quota from December 2021, we have shifted from vacancy-based to post-based.
Correct.
Now, insofar as promotion is concerned, it continues to be vacancy-based.
Okay. Is the question.
It is always vacancy-based. As long as
My lords, can they say Constitution judgment which interpreted the scope, object and purport of the reservation, can they say that it excludes Karnataka? Assuming they have a right to say so, can they say that Nagaraj, which went from this court questioning Karnataka Consequential Seniority Act, when it has said that more than 2 paragraphs, that it was dealing with promotion. Nagaraj dealt exclusively with promotion. And it said post-based roster is mandatory.
Read, take out that judgment.
That is, my lords,
My lords, lords, there is list of authorities, my lords.
ಇರೋ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ನಾವ ಡಿಸೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬಂದ್ರೆ ಮತ್ ಟ್ರೈಬ್ನಲ್ ಹೋಗೋದು ಅಲ್ಲಿ ಮತ್ತೆ 5 ವರ್ಷ ಮತ್ ಬೇರೆ ಎಂಪ್ಲಾಯೀಸ್ ಕೆಲಸ ಮಾಡೋದ್ ಬಿಟ್ಟು ಕೇಸ್ ಜೊತೆ ಲಾಯರ್ ಹಿಂದಿಂದ ಅಡ್ಡಾಡ್ಬೇಕಾಗ್ತದ. ಸರಿನಾ ತಪ್ಪ ಒಂದ್ ಸೈಡ್ ಇತ್ಲಾಗ ಹಿಂಗ್ ಮಾಡ್ತೀವಪ್ಪ ಮುಂದೆ ಅಲ್ಟಿಮೇಟ್ಲಿ ವಾಟ್ ಎವರ್ ಹ್ಯಾಪನ್ಸ್. Which paragraph, Mr. Rajgopal?
Nagaraj, there is no, sir. My synapse, I have stated which are the paragraphs.
Nagaraj is from Karnataka only.
Yes, my lords. M. Nagaraj,
Karnataka.
it first went as a Rule 32, Article 32 petition. Matter was remanded. Then, my lords, after the Constitutional judgment, the respective high courts were directed to examine the validity of individual acts
Then, my lords, the matter went back to Supreme Court as BK Pavitra 1. That is, my lords, para 86 of
2008
Nagaraj.
Supreme Court, huh?
M. Nagaraj. Quote it, Sahib.
2008? 6.
My lords, there are list of authorities, my lords, in this. Nagaraj case is.
ಇವ್ರು ಹೇಳಿ.
Para 86. Para 86.
Interfere ಆಗ್ತದೆ. Disturb ಆಗ್ತಾರೆ.
ಅದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೊಳಗಡೆ ಇದೆ ಅಂತ ಹೇಳೋದು.
Para 86.
Third judgment in the.
Clause 4 capital A, para 86 at page 262. man.
Clause 4 capital A.
Yes, follows the
Follows
pattern
the
specified
pattern
in clauses
specified in
3 and 4 of
3(4).
Article 16. Clause 4 capital A of Article 6 emphasizes the opinion of the states in the matter of adequacy of presentation. It gives freedom to the state in an appropriate case depending on the ground reality to provide for reservations in matters of promotion to any class or classes of posts in the services. The state has to form its opinion on the quantifiable data regarding adequacy of presentation. Clause 4A is an enabling provision. It gives freedom to the state to provide for the said clause is carved out of 16(4). Clause 4A balances the principle of secularism, which is the basic feature of Constitution, by bringing up the concept of creamy layer. Views have often been expressed in this court that caste should not be the determinant for backwardness. As we are bound by the decision in Indra-Sani, question as to the determinant of backwardness cannot be gone into by us in view of this one. In addition to the above requirements, this court in Indra-Sani has evolved numerical benchmark like ceiling limit of 50% based on post-specific roster, coupled with the concept of replacement to provide immunity against the charge of discrimination. Then, my lords, paragraph 121 onwards. (121) to 123.
Conclusion.
Conclusion. The impugned constitutional amendments by which the Article 16(4)A, 4B have been inserted flow from Article 16(4). They do not alter.
Uphold that.
Yes, my lords.
Then they uphold that.
Yes, they uphold that. Then, my lords, they do not obliterate any of the constitutional, namely ceiling limit of 50%. 50% is still constitutional.
That remains intact.
Intact. Then, my lords, next paragraph. We reiterate that the ceiling limit of 50% concept of compelling reasons, namely backwardness, represent overall all constitutional requirements. Of course, this was slightly modified in Jarnail Singh, where they said creamy layer would not apply for direct recruitment of scheduled caste, but it applies at promotion level. Then, my lords, however, in this case, as stated above, the main issue concerns the extent of reservation. In the state concerned, we'll have to show in each case the existence of compulsion, namely backwardness, adequacy. As stated, impugned provision is the state is not bound to make reservation. However, if they wish to exercise their discretion and make such provision, the state has to collect quantifiable data showing backwardness of the class and inadequate representation of that class in private employment, public employment. In addition, it is made clear that even if the state has compulsory reasons, as the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling limit of 50%. That is why, my lords, I said that whatever nomenclature, backlog, front log, whatever it is, roster, it cannot, this is the conclusion.
What is the slight modification that this judgment?
The Supreme Court in Jarnail Singh said, my lords, because scheduled caste and scheduled tribe, they are deemed to be backward. Therefore, creamy layer cannot be applied to them at the threshold. There is more for a direct recruitment. When the
promotion it operates.
Promotion, the state is entitled to provide.
What is the latest view of Justice Gawai's judgment? 2024 judgment.
That is one of
creamy layer.
There also, my lord, this has not undergone a change. 50%.
That's a rule.
Is the rule. In this case, my lords, the creamy layer question does not arise.
Will not arise at all.
Nobody has raised that question.
Anybody did raise that question?
No, no,
Nobody,
no, criminal.
not yet late.
Not.
Yes,
Only
we have not
quantifiable,
Huh?
quantitative limit. That is the only question.
Also read it in juxtaposition to Article 16(4)(b).
4B, my lords.
16(4)(b).
B itself.
That is considered in para 121.
No, no, text of 4B. 4B.
4B.
Please.
But it's Constitution. Nothing in this article.
Please, my lords, nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance with any provision for reservation made under clause 4 or 4A as a separate class of vacancies to be filled up in any succeeding year or years. And such class of vacancies shall not be considered together with the vacancies of the year in which they are being filled up for determining the ceiling of 50% reservation on total number of vacancies of that year.
Then what is that? What does it say?
Lords, it says that backlog vacancies shall not be considered, my lords, for the purpose of determining the ceiling of 50%.
50% of that
50%.
year vacancies, but it does not obliterate the requirement of 50% of the
No, no.
cadre strength.
Otherwise, you can easily skip off 50%.
ಹೌದು ಏನ್ ಬೇಕಾಗಿಲ್ಲ 2 ವರ್ಷ ಪ್ರಮೋಷನ್ ಮಾಡದೇ ಇರೋದು
ಅಲ್ಲಿಗೆ ಬಂದ್ಬಿಡುತ್ತದೆ.
ಅಲ್ಲಿ ಒಂದು 100% you promote ಅಂತ ಹೇಳಿ that
It's not like-
cannot be the law.
Backlog, my lords, is something that has happened as a historical fact. ಅದು ಆಗೋಗಿರೋದು. The backlog vacancy is something whereby vacancy arose, it has not
No,
been
for
filled.
that particular year ಅಂತ ಹೇಳ್ತದೆ. Huh?
116
How this is interpreted by the apex court? 4B is interpreted by which judgment?
Sir, in Nagaraj.
Same Nagaraj.
Huh?
Nagaraj.
Text. Yes, let us read again. Nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance with any provision for reservation made under clause 4 or 4A as a separate class of vacancies to be filled up in any succeeding year or years.
The vacancy arising in this year can be filled up in the succeeding year.
121.
No question of limitation at all.
Part 3, right?
121 I read.
That's a very broad proposition, I think.
And in fact, my lords, that para 116 of Nagaraj, Sabharwal is reiterated.
Whether Sabharwal considered 4B also?
Sabharwal.
I don't think that 4B much like
Sabharwal, my
given by
lords,
any judgment on
Sabharwal-
4B, text of 4B.
4B is considered in
Only validity is up.
in Nagaraj.
Operational effect.
Operational effect. It has not been considered, but it has been categorically held while upholding 16(4)A and 4B. 50% quantitative limit on the cadre strength. It is there.
ಅದನ್ನು violate ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ. In other words,
ಹೌದು.
that ceiling of 50%
Subsequently-
has to be kept in view
Yes.
while interpreting 4B and
4B. And
submission.
subsequently, this came up for consideration in Jai Shri Lakshman Rao. Jai Shri Lakshman Rao, my lords, is 2021 8 SCC
But
page
ಈ
1.
angle ನಿಂದ ಇಲ್ಲ ಅಲ್ಲಿ.
ಇಲ್ಲ ಅದರಲ್ಲಿ ಹೇಳಿದ್ದು 50% quantitative limit.
ಅದಕ್ಕೆ ಅದು 50% ಅದಾಯ್ತು.
What
but
is the
ಈ-
extraordinary circumstance ಅಂದ್ರು 50% ಇದು ಮಾಡ್ಬೇಕಾದ್ರೆ then it is analyzed and said that this is not an extraordinary circumstance. Subsequently, this has been this very question.
ಹೇಳೋದೇನು ಅಂದ್ರೆ ನಿಮ್ಮ ಪ್ರಪೋಸಿಷನ್ ಒಪ್ಪದೇ ಇದ್ದಲ್ಲಿ ರೂಲ್ ಆಫ್ 50% with impunity you can violate by accumulating the vacancies and not making the
But
appointment
in
for
fact,
5
my lords, earlier, if my lords would remember, say about 25 years ago, IAS, IPS ಹೋಗ್ಬೇಕಾದ್ರೆ ಒಂದು ವರ್ಷ DPC ಮಾಡೋದೇ ಇಲ್ಲ. Selection committee will not meet. 4-5 years ಮಾಡೋದಿಲ್ಲ. 1:4 ಅಂತ ಹೇಳಿದೆ, 1:3 ಅಂತ ಹೇಳಿದ್ದೆ. ಆವಾಗ 4 ವರ್ಷದ್ದು ಅಕ್ಯುಮುಲೇಟ್ ಮಾಡಿ 25 people ಕನ್ಸಿಡರ್ ಮಾಡಿ 23, 24, 25 will be promoted. Then this rule was amended to say that for each year you have to prepare a separate panel. How that each year to be treated as a separate panel came is because of this manipulative ingenuity.
That bias case ಯಾವ್ದದು bias
That is
bias ಅಂತ ಯಾವ್ದೋ ಒಂದು judgment.
This has been discussed, my lord. So
What is your answer to this question? You see, rule of 50% ceiling limit
Please.
has to be read into reservation. Ceiling limit is part of law of reservation. Number 1.
Please.
Unless you say 16(4)(b) is an exception to rule of 50%.
Please.
Huh? Year or years ಅನ್ನೋದಕ್ಕೆ
16(4)(b) ಬಂದಿದ್ದೆ ಯಾಕೆ first? What is that you see?
ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಹೆಂಗ್ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ?
I'll place.
ಈಗ ನೀವು ಬರೋದ್ರಾಗ 2 ಸರಿ ಓದಿದೀವಿ ನಾವು, ಇನ್ನೊಂದ್ ಸರಿ ಓದೋಣ, ಓದಿ.
Came because in one of the judgments, even
And such clause shall not be considered together with the vacancies of the year in which they are being filled up for determining the ceiling of 50%.
In fact, my lords, I'll place the bill itself, what was moved before the parliament.
ಅಲ್ಲ,
Why
bill-
that?
billing it, Mr.
Allala, why 16(4)(b) was introduced?
We
Because
go to bill
because my lords,
only when
one of the
text is not clear.
yes, in one of the judgments, Supreme Court said, backlog also, if you take, it cannot exceed 50% of the vacancies in a year.
Agreed.
To overcome that, this was made. But at the same time, 50% of the cadre strength as a quantitative outer limit is not tinkered.
No, then what is the meaning in saying the filled up for determination?
Vacancies of that year.
The ceiling of 50%.
Of that year. Vacancies of that year. Vacancy and post, there is a lot of difference in that. Cadre strength is determined by posts. And on the basis of the cadre strength, ceiling is 50%. That is undisturbed by 4B. In a given year,
4B is vacancy specific ಇದೆ. Post
vacancy
specific ಇಲ್ಲ,
specific
therefore rule of ceiling is not
is not violated there. The two things, my lords, the two things are totally different. Particularly, my lords, after the enunciation of difference between post and vacancy in R.K. Sabharwal, where it said they distinguished for the first time the word phrase post and vacancy.
ಇದನ್ನ ಯಾವ್ದಾದ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿದಾರಾ ಈ ಹಿನ್ನೆಲೆ?
ನಾಗರಾಜ್ ಕೇಸ್ itself.
Para 100.
Para 100, my lords,
Para
Nagraj case.
Nagraj case.
Para 100 and
100.
and the concluding paragraph 120.
Amendment is of the year 2000.
16(4)(b), my lords.
ಯಾವ year?
Well, it would have been
2000, my lords.
interpreted in some.
2000. 2000, my lords. 95 onwards in Nagraj case is
Introduction of time factor in Article
9, my lords,
16.
if from 95 it is read out, my lords, it is very clear. Nagraj case, may I read, my lords?
Yeah.
Para 95. By class 4B, the carry forward unfilled vacancies of a year are kept out and excluded from the overall ceiling limit of 50% reservation. The clubbing of the backlog vacancies with the current vacancies stand segregated by the Constitution 81st Amendment Act 2000, quoted herein below in the statement of objection and reasoned with the text of the Constitution. Lords, thereafter, my lords, statement of objects and reasons. Prior to 29/8/1997, the vacancies reserved for the scheduled caste and scheduled tribes, which could not be filled up by direct recruitment on account of non-availability of candidates belonging to scheduled caste or scheduled tribes, were treated as backlog vacancies. These vacancies were treated as a distinct group and were excluded from the ceiling of 50% reservation. The Supreme Court of India, in its judgment in Indra Sane versus Union of India, held that the number of vacancies to be filled up on the basis of reservations in a year, including carry forward reservation, should in no case exceed the limit of 50%. As total reservations in a year of the scheduled caste, scheduled tribes.
That is what Indra Sani said.
Yes.
That's para 100.
Indra Sani says even by applying carry forward, it should not exceed 50%. Therefore, to overcome that, they introduced
This
64.
amendment is made.
Yes.
Therefore, this 4B
Yes, my lords.
is an exception to the rule of ceiling limit. Operational point which he is saying is another thing.
No,
We will come to
from,
that one.
that is from 110 onwards, paragraph 110.
No, my lords, again, the Supreme Court in this judgment itself clarifies how 16(4)B has to be applied. As total reservation in a year for scheduled caste, scheduled tribes and other backward classes combined together has already reached 49.5%, and the total number of vacancies to be filled up in a year could not exceed 50%
of the year.
Yes, year. Time factor is important. It became difficult to fill up the backlog vacancies and to hold special recruitment drives. Therefore, to implement the judgment of the Supreme Court, an official memorandum dated 29/8/1997 was issued to provide that 50% limit shall apply to current as well as backlog vacancies and for discontinuation of the special recruitment drive. Due to the adverse effect of the said order, aforesaid order dated 29/8/1997, various organizations, including the members of the parliament, represented to central government for protecting the interest of the scheduled caste and scheduled tribe. The government, after considering various representations, reviewed the position and has decided to make amendment in the constitution so that the unfilled vacancies of a year, which are reserved for being filled up in that year, in accordance with any provisions for reservation made under clause 4 or clause 4A of article 16 of the constitution, shall be considered as a separate clause of vacancies to be filled up in any succeeding year or years, and such classes of vacancies shall not be considered together with the vacancies of the year in which they are being filled up for determining
the ceiling limit of 50%.
50%. Reservation on total number of vacancies of that year. This amendment in the constitution would enable the state to restore the position as prevalent before 2019.
1 second. This is, it restores the earlier position.
Prior to Indira Sahani.
Correct. That object is to dilute Indra Sahani.
Yes. Object, the amendment was.
What was how it was operated earlier?
Yes.
What was the law?
Page 100 minutes, para 100 minutes. Para 100. Introduction of time factor in view of article 16(4)B. This is what the Supreme Court says. Para 100 minutes. As stated above, article 16(4)B lifts the 50% cap and carry over vacancies, backlog vacancies. The ceiling limit of 50% on current vacancies continues to remain. In working out the carry forward rule, two factors are required to be kept in mind, namely unfilled vacancies and the time factor. These positions need to be explained. On one hand of the spectrum, we have unfilled vacancies. On the other hand, we have a time spread over a number of years over which unfilled vacancies are sought to be carried over. These two are the alternating factors, and therefore, if the ceiling limit on the carry over of unfilled vacancies is removed, the other alternative time factor comes in, and in that event, the time scale has to be imposed in the interest of efficiency in administration as mandated by Article 335. If the time scale is not kept, then posts will continue to remain vacant for years, which would be detrimental to the administration. Therefore, in each case, the appropriate government will now have to introduce the time cap depending upon the fact situation. What is stated herein above is borne out by the service rules in some of the states where the carryover rule does not extend beyond 3 years. Now, my lord, the state will have to work out.
They are saying some rules in some other states.
No. For implementing 16(4)B to overcome this 50% ceiling limit, the state will have to, my lords, determine this time cap factor, their representation, whether it adequately represented in the previous year or not. All these things, my lord, state will have to work out. If there is no policy or guidelines of the state, my lords, to fill up this backlog vacancies for that particular post, they cannot directly say that, no, backlog vacancy we will do, we will overcome this 50% ceiling limit. Now, my lords, in the concluding paragraph 123 also they have again said this. 123, my lords. However, in this case, as stated above, the main issue concerns the extent of reservation. In this regard, the state concerned will have to show in each case the existence of compelling reasons, namely backwardness, inadequacy of representation, and overall administrative efficiency before making provision for reservation. As stated above, the impugned provision is an enabling provision. The state is not bound to make reservation for SC and SC in matters of promotion. However, if they wish to exercise their discretion and make such provision, the state has to collect quantifiable data showing backwardness of the class and inadequacy of representation of that class in public employment, in addition to compliance with Article 335. It is made clear that even if the state has compelling reasons as stated above, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling limit of 50% or obliterate the creamy layer or extend the reservation indefinitely. Therefore, Lord, this 16.4b now comes with a rider. The state will have to make a quantifiable data, say there is no adequate representation, it will not affect administrative effectiveness.
Yes.
Here is 123.
123, my lords.
With 124, there's a subject to the above, we uphold the constitutional amendment of 16.4.
The main issue concerned extent of reservation. Then, my lords, in this state will have to show the reservation, all that my lords may. It is made clear that
even if the state has compelling reasons,
the state will have to see that its reservation does not lead to excessiveness so as to breach
the ceiling limit of 50%.
50%.
Or obliterate the agreement, that may not be applicable to you.
Because that is in relation to the cadre strength is my respectful submission.
Lords, now, my lords, I'll just provide one synopsis, my lords. Your lordship, for the bare, in about, my lords, a few minutes, I will demonstrate they are sufficiently represented.
124, paragraph 1.
Replacement theory is upheld.
121 upholds the validity.
121 says this, my lords. The impugned amendments has been inserted flow from Article 16.4. Now 16.4 is what is interpreted, the 50% and all that. R.K. Sabharwal judgment admele ivella bandu 4A, 4B. Indira Sani, they said broadly, there can be no reservation in promotion.
Promotion at all.
ಆಮೇಲೆ ಅಜಿತ್ ಸಿಂಗ್ ಅಲ್ಲಿ ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ಸೀನಿಯಾರಿಟಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. To overcome all these things that 16.4A, 4B came. Now, my lords, the harmoniously interpreting 16.4A provides for reservation, 16.4 provides for reservation subject to quantitative limit of 50%. 16.4B makes an exception that where there are backlog vacancies, 50% ceiling limit will not apply to the vacancies. It does not say 50% of the cadre strength or the post as a ceiling will also vanish because of 16.4B. That is not the law.
It speaks of vacancies.
This speaks of vacancies because
Of the year.
Yes, 16.4B itself
In
deals
so many
with
words
vacancies.
says vacancy.
Suppose, my lords, in a year, suppose 10 vacancies arise.
Cadre strength of the X anta ಇಟ್ಕೊಳ್ಳಿ.
Cadre strength, and let us say that 50. ಅದರಲ್ಲಿ ಬ್ಯಾಕ್ಲಾಗ್ ಅಂದ್ರೆ ಶಾರ್ಟ್ ಫಾಲ್ ಆಫ್ 50% ಗೆ
ಎಷ್ಟು ತುಂಬೋದಿತ್ತು ಅದನ್ನ
ಎಷ್ಟು ತುಂಬೋದು ಅಷ್ಟು ವೇಕೆನ್ಸೀಸ್ irrespective of 50% of that year you can fill ಅಂತ. But the ceiling of 50% of the cadre strength, that is intact.
That remains intact.
That remains. Otherwise,
in other words, 4B is structured keeping the vacancy 50% of the vacancies in a year without altering the 50% rule applicable to the cadre strength.
Yes. Yes.
50%
yes, my
ceiling
lord.
of carrier strength continues.
That continues intact.
At the end, it continues. In fact, Lords, BK Pavitra 2, I don't know how far it is no valid judgment because of subsequent journal single. BK Pavitra 2 was rendered holding that Ratnaprabha Committee's modalities to ascertain the backwardness and inadequacy of representation is valid. That has been reversed by larger bench in journal Singh subsequently. Now, I don't know whether I can reopen even the validity of that act itself, but in this case, I will not do it. Because
In
I have
England,
not pleaded in the ground floor.
not only that, in England, the authors say there are judgments also. Once an act is struck down as unconstitutional, it is end of the matter. In review, we cannot say, no, it is now constitutional. But the finality is if the legislature does not want, if the parliament does not want, let them amend. But our duty is over. By review, we cannot say, no, it is valid, it is not valid. That alternate
In fact,
views we cannot. That creates not many problems.
Journal Singh, in fact, Morrissey, it is another thing. It is prospective on the better head. I don't know, really, I am not able to understand. What is the meaning of prospectivity of journals? Big Karnataka, they said prospective, that is perfectly understandable. But Journal Singh being prospective, after saying that, Nagaraj has been followed in more than a dozen judgments, ಅವೆಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು prospective ಅಂದ್ರೆ ನಾವು
ಅವುಗಳೆಲ್ಲ
ಅದಲ್ಲ ನಾಗರಾಜ್ ಇಸ್ ರೀಬಾರ್ನ್ ಅಂಡ್ ಈ ಜನ್ಮದಲ್ಲಿ ಇವನಿಗೆ ಇವತ್ತಿಂದ ಒಂದು ಫಸ್ಟ್ ಡೇ ಬೇಬಿ ಅಂತೇಳಿ ತಗೋಬೇಕು ಅಂತ ಹೇಳಿದ್ರು. ಇನ್ಫ್ಯಾಕ್ಟ್ ಐ ಮೇಡ್ ಎ ಕ್ರಿಟಿಕಲ್ ಕಾಮೆಂಟ್ ಆನ್ ದಟ್ ವೈಲ್ ಟಾಕಿಂಗ್ ಸಮ್ವೇರ್ ಅಬೌಟ್ ದಿಸ್ ಜರ್ನಲ್ ಸಿಂಗ್.
That liberty you have. But from when you come this side.
ಎಲ್ಲ ಇಮಿಡಿಯೇಟ್ಲಿ ನನಗೆ ಫೋನ್ ಬಂತು ನಜೀರ್ ಸಾಹೇಬ್ ಹೇಳೋದು ಏನ್ ರಾಜಗೋಪಾಲ್ ಅಟ್ಯಾಕ್ ಇಟ್ ಲೈಕ್ ದಟ್ ಅಂತ.
Lords, even other mails, on facts also, this backlog vacancies they are which they are making you on crime, Lord, that doesn't exist. If I pass on this synopsis, my lord,
Even though the short note ಕೊಡಿ.
ಅದು ಕೊಡ್ತೀನಿ. ಅದ್ರ ಮೇಲೆ I'll prepare.
ಇಬ್ರು ಕೊಡಿ. ನಿಮ್ಮ ರೆಸ್ಪಾನ್ಸ್ ಏನು? 50% ರೂಲ್ ಇದೆಯಲ್ಲ, ಅದು ಕೇಡರ್ ಆಲ್ವೇಸ್ ಇಟ್ ಈಸ್ ಅಟ್ಯಾಚ್ಡ್. ಬಟ್ ವೇಕೆನ್ಸಿಗೆ ಏನ್ ಸಂಬಂಧಪಡ್ತಾವ ಆಫ್ ದಟ್ ಇಯರ್ ಅದನ್ನ ನೀವು ಹೆಂಗಾರ ಮಾಡ್ಕೋಬಹುದು.
There is any backlog vacancies, then all those backlog vacancies still comes out of the purview of Article 16. Once it we build up in terms of 64B only. That once a separate class by itself, then the Lord see if the argument is to be accepted, then the very provision which was made, the object for which it was made is Indra Sani. Indra Sani said that whatever be it may be, because Indra Sani was not dealing with the situation of vacancies, it was dealing with the total reservation as such. So when Indra Sani is what was sought to be circumvented by the constitutional amendment saying that 4B should be inserted. But the argument is again going back to Indra Sani.
No, pre-Indra Sani.
They are going back to the principles in Indra Sani. Indra Sani will not put the clock. The gap which was put in Indra Sani was 50%. Not the vacancies, if the total card.
I think 50% rule was even earlier also there was 50%.
M.R. Balaji.
M.R. Balaji versus state of Mysore.
Yes.
Correct.
That is, my lords, in admission to education institutions. When reservation was made in excess of 70%.
But now.
M.R. Balaji, they tried to, in between.
Venkatranga Iyengar.
ಹೌದೌದು, in between Nagaraj and M.R. Balaji, ಒಂದು 2-3 ಎಫರ್ಟ್ ಮಾಡಿದ್ರು. 50% ಅದು it is only second class ಅಂತ ಹೇಳಿ. ಮತ್ತೆ it came out in first class again in Nagaraj.
But when economic amendment was considered, you would say 50% is not a hard cost. 50% was assessed as on the date when the facts were faced. If there are other elements of backwardness which is brought about with the constitutional amendment, you can always incorporate it. So 50% is now not a kind of
that Maheshwari, Maheshwari Saab and Bela Trivedi.
Therefore, it is not saying that 50% is not there now. Once EWS was, because EWS principally was challenged on the same ground, of course, other than social backwardness, not their etc. They said that ceiling should not exceed 50%. That was not accepted by the Supreme Court.
It cannot be accepted at the name. Supreme Court throughout heading. Except, exception, you have to make out a case for exception.
You have to make out a case.
Because constitution veridical 16.4 has already been upheld.
That's right.
There
But
it was.
what is meant by 16.4 is our question now. 16.4B.
Let us assume a situation where there was no 16.4B. Then every vacancy as and when arising, in every year, 50% embargo was there because of Indra Sarin's case for the purpose of filling up, including the background vacancies. This is what is addressed under 16.4B. The question is, what would have happened if there was no 16.4B?
Economically weaker section.
Now,
ಅಲ್ಲ ಅದಕ್ಕೊಂದು ಆರ್ಗ್ಯುಮೆಂಟಿಗೆ ಅವ್ರು ಹಂಗೆ ಏನೋ ಔಟ್ ಆಫ್ ದಿ ಸ್ಕೈ ಹಿಂಗ್ ಪುಲ್ ಡೌನ್ ಮಾಡ್ಕೊಂಡು ಮಾಡಿದ್ದಲ್ಲ. ದೇರ್ ಇಸ್ ಸಮ್ ಅಬ್ಸರ್ವೇಷನ್ಸ್ ಎಲ್ಲ ಇದೆ. ಇಟ್ ರಿಕ್ವೈರ್ಸ್ ಕನ್ಸಿಡರೇಷನ್, ಡೀಪರ್ ಕನ್ಸಿಡರೇಷನ್ ಬೇಕಾಗತ್ತೆ. ಕಾಂಕ್ರೀಟ್ ಕೇಸ್ ಮೇಲೆ ಇಲ್ವಾ ಜಡ್ಜ್ಮೆಂಟ್? ಹೌ ಆಪರೇಷನಲೈಸೇಷನ್ ಆಫ್ 4B ನೋಡ್ಬೇಕು. ಹೌ ಅದರ್ ಹೈಕೋರ್ಟ್ಸ್ ಹ್ಯಾವ್ ಅಟ್ ಲೀಸ್ಟ್, ಯಾಕಂದ್ರೆ ಇಬ್ರು ಎಕ್ಸ್ಟ್ರೀಮ್ ನಲ್ಲಿ ನಿಲ್ತಾ ಇದ್ದೀರಿ. ಮತ್ತ ಹೌದು, ಇದರಲ್ಲಿ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಹಾವು ಮುಂಗ್ಲಿ ಎರಡು ಇದಾವು. ಇನ್ ದಿಸ್ ಬೋತ್ ಮಂಗೂಸ್ ಅಂಡ್ ಕೋಬ್ರಾ ಬೋತ್ ಆರ್ ದೇರ್. ಒಂದು ಅದನ್ನು
It appears so, but it is not really so.
not like that. So the underlying principle of inviolable rule of 50%, that we have to keep in mind.
That we have to keep.
And if somebody argues that there is it is not inviolable, for him to establish special circumstances.
Special circumstance, and that too not in the court. While making the legislation, state should have established. Not, it is not an after the event defense.
Not by pleadings anta.
Not by pleadings. Mohinder Singh Gill.
Of elections. Technical rules of pleadings or the satisfaction, all these things do not come into play as long as the circumstances exist and that can be demonstrated before the court that warranting the extension of the reservations. Reservations in itself is a different class.
It's a jurisprudence.
Cannot be.
It's a reservation jurisprudence.
Yes. Of technicalities or whether it's in the pleading, the satisfaction, all these things do not arise. Question is whether it can be justified before the court of law with whatever materials. That is how it should be, because it's a separate jurisprudence altogether.
But the principle is this, my lord, that any reservation cannot be excessive so as to obliterate Article 16(1).
Because 4B, these are all exceptions.
These are all.
And that basic norm as such will remain
16(1) remains intact.
The exception should not eat away the rule annod nimma
And that is,
contention.
and then, my lords, in Indra Sanin, observation has also been made. 16(4) is not an exception. 16(4) is a facet of 16(1).
14, it is 16(1).
16(1), it is a facet of 16(1). Therefore, 16(1) becomes inviolable. And 16(4), 4A, 4B are to bring into effect real equality in place of formal equality spoken in 16(1). But real equality should not become real inequality. Therefore, 16(1) has to pervade our discussions
Even
on
when
all
we are
other clauses of Article 16.
In other words, exceptions should not swallow the rule itself.
Yes, that is the thing.
Goes beyond it, then the general rule will have to apply. Exception, however, as your lords have said, it cannot be interpreted in a manner that the general rule which has been prescribed.
That commits legal suicide.
Doing offense to the general rule itself, but exception itself indicates that we are deviating from the general rule. So deviation has to be respected. General rule is always in place.
That is why that is a limitation insofar as vacancies. That is why it has been
Not,
used for
not
B.
cadre ಅಂತ.
Cadre ಅಂತ use
Cadre
ಮಾಡಿದ್ರೆ
strength
it
ಅಂತ.
would have eaten away 16(1). That is why to protect it 16 for B.
ಇದು ಯಾವ ಹೈಕೋರ್ಟ್ ಇದನ್ನ ಸ್ವಲ್ಪ ಆಪರೇಷನಲೈಸ್ ಮಾಡ್ಯಾರ ಅಂತ ನೋಡಿ.
No, I will do my best.
You have understood what is what now.
That sort of said that you can never breach the embargo of 50%. So
ಅದು ಡೈಲ್ಯೂಟ್ ಆಗಿದೆ.
now, if the argument of the other side is, we are again going back to the principles as enunciated in Indra Sani.
ಇಲ್ಲ ಅವ್ರು ಹೇಳೋದು ಪ್ರೀ ಇಂದಿರಾ ಸಾನಿ.
Pre-Indra Sani, the reason myself, pre-Indra Sani is concerned, but it was regulated under the service rules only. But the constitution itself did not recognize the backlog vacancies as a separate class by itself. It had not recognized. This was necessitated because of Indra Sani's case where there was some impediment for giving effect to this backlog vacancies for the succeeding years with the embargo of 50 years.
Ultimately, my lords, R.K. Sabharwal has not been diluted, nor it has been
reiterated ಅಂತ.
reiterated, and R.K. Sabharwal has not been the subject matter of dilution by any constitutional amendment. R.K. Sabharwal stands.
Can we fix another here? But once it forms a separate class, the backlog vacancies are a separate class. It does not fall within the mainstream cadre. Therefore, my lord, to include the separate class within the mainstream cadre and say, my lord, the breach of 50% limit will apply. It might not be, my lord, essentially it would say, include a separate class within, my lord, the main quota. That was not the objective of 16.4. 16.4 was to bring it outside the general cadre of the vacancy.
But the moment they used the words separate class, it means it was taken out of the purview of Article 16 for the separate class rates. So that on the principles of 16.1 to 16.4, the backlog vacancies which will be extended beyond the permissible limits of 50 quota in the vacancies will be challenged. That's the reason why it is given a special status. Now, if it is again given back to the vacancy saying that it was restricted only to the vacancies of the respective year, then what happens is this is the scenario which came about in Indra Sani's case, which was answered by the Supreme Court saying that no, don't reach 50%.
Vacancies is the word used by the parliament, not by me.
Vacancies form a separate class.
So what happens?
You lawyers always play with the words.
Every word has its worth, my lord.
Vacancy.
In Sanskrit, word is called Shabda Brahma because it creates the world.
So of the word vacancy conspicuously under Article 16.4b is for creation of a separate class and a distinct class, not for the purpose of
Where general rule will not apply at all anta nim contention.
vacancies that arise from out of a given reserved category in the given year itself comes out of that category and forms a separate class. That's pulling out all these vacancies which were there, which was unfilled, and then putting into a different class, and then appointments takes place under 16.4b only.
ಅಲ್ಲ ಹಂಗ ಆಪರೇಟ್ ಮಾಡಿದ್ರೆ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ ಏನು ಅಂತ ನೋಡ್ಬೇಕಾಗ್ತದೆ. ಈಗ ಇಂಥದ್ರ ಮೇಲೆ ನಾವೇನಾರ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರೆ ಇದು ಅವಸರ ಮಾಡಿ ಕೊಡುವಂಗಿಲ್ಲ. ನಾವೇನೋ ಸ್ವಲ್ಪ ಏನೋ ಸಿಂಪಲ್ ಇದೆ ಅಂತ ಅನ್ಕೊಂಡಿದ್ದೆ, ಈಗ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ನಮ್ಗೆಲ್ಲ ಕನ್ಫ್ಯೂಷನ್ ಆಗಿ ಹೋಗಿದೆ ಈಗ.
ನಾನು I had no intention to commence today. ನಾವು ಹೇಳಿದಾಗ ಮಾಡೋಣ ಅಂತ. But then my lords, my lords, I would say
we have
prodded
the ball in motion. We'll also discuss our brothers.
Gives a lot
ಹಿಂಗೆಲ್ಲ ಇತ್ತು ಅಂತ.
Not only that, my lords, on facts, my lords, insofar as SC, ST, my lords, vacancies, backlog vacancies are there, that is provided for. 15% and 3%, 15% was SC, 3%. That was the representation, my lords, to which you could have reached. Now it is increased to 17 plus 7. Earlier it was 18, now it is 24. So assuming, my lords, the ceiling limit, my lords have used the word how it was operationalized. Now assuming, let us assume, my lords, we had a ceiling limit. We bring it to backlog. I have backlog vacancies. I have the statistics. I try to fill it. I reach 50. I stop it. But still the backlog vacancies remain. The next round comes. Again, those backlog. Whether those backlog vacancies lapse, all these things, my lords, have to be taken into consideration. So otherwise, it's not a case, my lords, where every category has a backlog here. It is only, my lords, SC and ST, my lords, backlog vacancies are there. So therefore, even going beyond 18% or 24% is what backlog is, but whether it could be capped at 50 and it could be a one-time cap, or once we cap it at 50, whether all the earlier,
What you say is it goes on continuing.
it goes on continue at the end of the day. And on facts, my lords, if something is on own merit, but they have admitted to that legal position that if it is on own merit, then let us not consider it, my lords, as backlog. So even their calculation, my lords, falls on its heads now. What the calculation they gave before the tribunal. Therefore, so at the end of the day, my lords, we will assist the court, my lords, on this aspect. But we have, being a state, my lords,
Lapsing of the backlog vacancies. That's the object. Lapsing of backlog vacancies.
ಅದನ್ನ ಅವುಗಳನ್ನ ಬೇರೆಯವರು ಉಪಯೋಗಿಸಬಾರ್ದು, ಅದು ಆಯಾ ಕಮ್ಯುನಿಟಿಗೆ ಕೊಟ್ಟದ್ದು ಅನ್ನೋದು ಒಂದು ಪ್ರಿನ್ಸಿಪಲ್ ನಮ್ದು.
1000 words says only one principle.
No, my lords.
Permit the backlog vacancies.
Another anomalous situation in our state regarding the roster. No, my lords, when we speak of 15%, let us take 15%. The first point in the roster that can go to the SC is 7th point. 3% if it is taken, first point that can go to ST is 17th point. Points 1 and 2 are reserved for SC and ST. That is the reason Supreme Court said post-based reservation. Post-based reservation, post-based roster was introduced in the central government in May 1995. Because judgment was rendered on 13th February 1995 in R.K. Sabharwal. 30 years have passed. No post-based roster, still number 1 SC, number 2 ST. How can that be countenanced? Because that is the basis for calculating your backlog. Backlog, if at all any backlog vacancy occurs after 13th February 1995,
After that judgment,
it has to be on post-based roster.
that they have not altered.
That they have not done. And even now, they say that for direct recruitment post-based, for promotion vacancy, how can it be? Recruitment is recruitment. And R.K. Sabharwal dealt with promotion as a method of recruitment, not as direct recruitment. It is not, I would say, Manu,
Anomalous anta.
anomalous antalla. It is
Contrary to Supreme Court judgment.
it is offensive to the very concept of equality.
ನಿಮ್ದೊಂದು ರೈಟ್ ಅಪ್
Equality by law.
ಆಯ್ತಲ್ಲ, ಅದೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ.
But after reading Sabharwal, I share his view. It is like that. I have felt so many anomalies in law. In fact, the famous book of our Justice Ravindran Saab, it should have touched this aspect also. Of course, many anomalies our Honorable Justice Ravindran Saab has enlisted in anomalies in
Yes,
law. Is a famous book.
anomalies in law ಅಂತ ಹೇಳಿದ್ರು. That makes a very interesting.
Very
reading.
interesting.
Huh? No password.
Equality in law should not remain as equality in law, but it should also be.
Should be reflected in fact anta.
Where the transition takes place from the law to fact. Essentially what was done.
That is, but not that simple. Not that simple. Many, a lot of scope for contemplation of consequences, holding this, holding that. Ultimately, ಯಾವ ಆಬ್ಜೆಕ್ಟಿಗೆ ಇದನ್ನ ಮಾಡಿದ್ದಾರೆ ಆ ಆಬ್ಜೆಕ್ಟ್ ಸರ್ವ್ ಆಗ್ಬೇಕು. And whatever limitations are also contemplated, all limitations operate ಆಗ್ತದೆ.
That also will have.
That's also, because it's a package. One package. Benefit, it's a rose and thorn like there. If you want rose, you have to take the thorn off. You can call the thorn as the limitation. You can call the rose as the benefit of reservation, the etc. ಬಟ್ ಅದನ್ನ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಒಂದು ಹಾರ್ಮೋನೈಸ್ ಮಾಡಿ ಒಂದು ಎನಿ ಜಡ್ಜ್ಮೆಂಟ್ ವಿಚ್ ಇದನ್ನ ರಿಯಲಿ ಆಪರೇಟ್ ಮಾಡಿದಂತ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇರ್ತದೆ. 25 ವರ್ಷ ಆಗಿದೆ ಈಗ ಬಂದು ದಿಸ್ ಪ್ರಾವಿಷನ್. ಇಂದಿರಾ ಸಹನಿ ಅಲ್ಲ, ಅವು ಜಡ್ಜ್ಮೆಂಟ್ ಇದಾವೆ 3. ಅನದರ್ ಥಿಂಗ್. Existence, how 16.4B is operated, construed by various high courts. Anyhow, ಇರುತ್ತೆ ನನ್ನ ಪ್ರಕಾರ 25 ವರ್ಷದಲ್ಲಿ.
Essentially, like going back to Indra Sahni's case, the reason why I'm saying this is 16.4B came into existence. What was the law which was there prior to that date, and what was the change which was sought to be brought in? That brings about the intention with which 16.4B came into itself.
ಆಗ್ಲಿ, ನಿಮ್ಮದೊಂದು ಇದು ಮಾಡಿ. ಓಕೆ, ಹೇಳಿ ನೀವು ಯಾವ್ದೊಂದು ಡೇಟ್ ಹೇಳಿದ್ರೆ ಸ್ವಲ್ಪ ನಮಗೂ ಸ್ವಲ್ಪ ಇದ್ರ ಮೇಲೆಲ್ಲ ಓದ್ಕೊಂಡು ಬರ್ಬೇಕಲ್ಲ.
Now you will actually have to hear afresh and read everything, which I am sure that all of it will be on your
371J ಒಂದಿದೆ, ಅದರಲ್ಲೂ ಇದೆ ನೀವು ಮೋಸ್ಟ್ಲಿ ನಾಳೆ ಅಥವಾ ನಾಳೆ ಹಾಕೊಂಡಿದ್ದೇವೆ.
Informed that my lords are sitting in a special bench.
ಹೌದು, ಸ್ಪೆಷಲ್
371 ನಾಳೆ ಬರ್ತದೆ.
ನಾಳೆ ಬರ್ತದೆ, ರೆಡಿ ಇದ್ಬಿಡಿ ಪ್ಲೀಸ್.
No, we are in fact, no, Mr. Chandrasekhar was on his legs.
ಸ್ವಲ್ಪ ಲಿಸ್ಟ್ ಮೊದಲೇ ಗೊತ್ತಾದ್ರೆ ಹೊರಗಿಂದ ಬರೋರಿಗೆ ಬಂದು ಇಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಅನುಕೂಲ ಆಗ್ತದೆ. ಈ ಲಾಸ್ಟ್ 8 ಗಂಟೆ ಕೇಳಿದ್ರೆ ಲಿಸ್ಟ್ ತಗೊಂಡು ಕಾಪಿ ಏನ್ ಮಾಡ್ಬೇಕು? 6 o'clock. 19th
next week. ಇಲ್ಲ
20th ಆಗ್ತದಾ?
20th I have one.
Difficulty. Any other date?
the next
24th ಆಗ್ತದಾ? 24th.
Please
ಮಾಡ್ಕೊಂಬನ್ನಿ, ನೋಟ್ಸ್ ಮಾಡ್ಕೊಂಬನ್ನಿ ಅಲ್ಲ. ಓಕೆ,
On facts, my lords, are prepared this,
ನೋಡಿ ನಿಮ್ದು ಸಿನಾಪ್ಸಿಸ್ ಇಲ್ಲಿ ಗೊತ್ತು.
that we give fact, my lords, whether actually there is backlog vacancies or not. That points also when their post got vacant and when the process from the got filled up.
That's the fact determination.
ಒಂದು ಆಮೇಲೆ ಯಾರು ಇದನ್ನ ಮಾಡ್ಬೇಕು, ಹೂ ಶುಡ್ ಡೂ ಇಟ್ ಅನ್ನೋದು ಒಂದು ಆಸ್ಪೆಕ್ಟ್ ಇದೆ. ಜಸ್ಟ್ ಲುಕ್ ಇನ್ ಟು ದಟ್ ಆಲ್ಸೋ. ಓಕೆ,
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಒಂದಿದೆ, ನಮ್ದೊಂದಿದೆ. Now you all have to fill out those.
No, we'll do our best. Okay. ಎಲ್ಲ 2 weeks. 2 formats, sir. Correct.
entry models to continue.
Entry models to continue.
Grateful.
Heard, learned senior advocate, learned additional advocate general, learned senior advocate and other advocates appearing for the parties. But heard in part on that. First off, calling this matter for further hearing on 24/3 for further hearing. First off, bar is requested to submit short notes. Okay.
Number 39, Prithvish.
It appear
Preparation.
repatriation at accommodation.
Next week,
Very well.
call after to
Some urgency, my lord.
Chief.
Some urgency in the matter. So the intermodal which is granted, the petitioner is without posting for the last 1 month, minutes, and is due for retirement in July.
Court has directed that he be given a posting also.
In
He had
fact,
challenged it.
ಯಾರು ಗವರ್ಮೆಂಟ್ ಯಾರು
On the interim order granted,
ಪೋಸ್ಟಿಂಗ್ ಕೊಡಬೇಕು ಅಂತ ರಿಟೈರ್ ಆಗ್ತಾ
Respondent ಗೆ ಕೊಡ್ಬೇಕು ಅಂತ
ಪೋಸ್ಟಿಂಗ್ ಕೊಡಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರು. He is retiring in July. You want to make him retire without posting so that he will not get pension settlement? ನಾವು ಕ್ಲಾರಿಫೈ ಮಾಡಿವ.
ಅಲ್ಲ, ನನಗೆ ಪೋಸ್ಟಿಂಗ್ ಈಗ ಸ್ಟೇ ಪ್ರಕಾರ ನನಗಿದೆ, ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೊಡ್ಬೇಕು ಅಂತ.
ಅವರಿಗೆ there is an order already. We remember. Respondent said he would be retiring in July.
Yes, please.
ಎಲ್ಲರ ಒಂದ್ ಕಡೆ ಆಫೀಸ್ ಇರ್ಲಿದ್ರೆ ನಾಳೆ ಒಂದು ಸೆಟಲ್ಮೆಂಟ್ ಆಗಲ್ಲ ಪೆನ್ಷನ್.
Your lordships may call it next week so that. No,
Huh?
respondent, the order is
Respondent.
respondent.
Order. We have seen that.
Only 2 points were
Let,
consideration.
may I just draw your lordship's attention to the order sheet?
Yes, notice sheet.
Without any posting the third or fourth place of the council present but without any posting by the competent authority. The order dated 21/1.
Let's, after that,
Posting ಕೊಡ್ಬೇಕು. Retire ಆಗಿರೋರಿಗೆ ಕೊಡ್ತೀರಿ.
But in fact,
ಅವ್ರದ್ದು ಬಿಡಿ.
Respondent has ceded before. The respondent was the respondent before the criminal.
Correct.
The petitioner was the applicant before the criminal. The applicant lost the case before the criminal. Therefore, he has approached. He has not yet succeeded. Therefore, he is without posting. He was a deputation.
he was on deputation.
He says he is without posting.
yes,
I'm without posting
Because of the
PWD
interim order.
department,
Yes.
please. Because of the interim order, he's displaced my.
Posting
Yes.
is not given. After all, he should not suffer because shortly he is going to retire. ಮುಂದೆ ಅದು ಏನ್ ಮಾಡಕ್ ನೋಡೋಣ ಅಂತ ಮೊದ್ಲಿಗೆ ಅವ್ರಿಗೆ ಒಂದು ಪೋಸ್ಟಿಂಗ್ ಕೊಡಿ, ಅದರ್ವೈಸ್ ಪೆನ್ಷನ್ ಸೆಟ್ಲ್ ಆಗಲ್ಲ.
Not very.
ಹಾ
great.
One
The issue
posting.
is I come from the rural panchayat department and petitioner is from the PWD department. So he was placed on deputation.
You want a posting, ಇರೋದೇ ಒಂದ್ 3 ತಿಂಗಳು ಇರ್ತೀರಿ.
I request for a short date minutes, new of the urgency.
ಇದು ನೋಡ್ರಿ ಅವ್ರು the coordinate bench wide order dated 21/1/2025 said like this.
My lords, yes. Other aspect which has to be brought to my lord's consideration.
Learned counsel for the private respondent vehemently argues that, contends that his client is going to retire in the month of July, instant, imminent. And therefore, unless the posting is given, he may face hardship in getting terminal benefit settled. Full stop. The hearing of the matter may take some more time. And that should not put the answering respondent to problems. Full stop. Next paragraph. Consistent with the order of the coordinate bench referred to above, and the requirement of justice, the official respondents are directed to give posting to the private respondent herein on the department.
Rural panchayat.
The RDPR, in the RDPR report, before the next date of hearing. First off, non-compliance of this direction may result into a direction being given to the principal secretary of the department to be personally present before the court for offering explanation. Full stop. We hope that such an occasion would not arise. First, call this matter week after, one date, week after next. Astral kodbek.
One submission, my lords. When I suffered an interim order, the respondent had approached the Supreme Court. Supreme Court disposed the matter.
Lord,
In fact, the date was fixed on February 18th for hearing, my lord. Since then, it's been getting adjourned.
ತಗೊಳ್ಳಿ ಮೊದಲು, ಆಮೇಲೆ ನೋಡೋಣಂತೆ. ಅದು ಇಲ್ದಂಗೆ ಮಾಡ್ಕೊಂಡು ನಾಳೆ ತೊಂದರೆ ಆದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಿ ಕ್ಲೈಂಟ್ಗೆ?
Any date in the next week, my lords. Humble request.
Very humbly we are also saying, ಅವ್ರು ಪೋಸ್ಟಿಂಗ್ ಕೊಡ್ಬೇಕಲ್ಲ. ಪಾಪ ಅವ್ರ ಮೇಲೆ we are pressurizing him. Why you did not make submission on 4B? You have so much creativity and other things we have seen in your argument.
Repeatedly, we have sent communication to both the departments. The petitioner came from the department of PWD.
ಅಲ್ಲಲ್ಲ 4B ಮೇಲೆ ಯಾಕೆ ಮಾಡ್ಲಿಲ್ಲ argument? Both you perform so well. We have seen 16/4 ಮೇಲೆ 4B. Okay.
I pointed out the paragraph.
Okay.
In fact, my lord, the government order point will reveal that the shortfall during a particular period in reservation will be compensated by an excess in the future. When reservations are filled, backlog are filled, my lord, there will be, it will reach the quota as per the additional roster points in the government order.
There is,
That is the
yes,
principle.
yes, there is one
That is
government
ಅವ್ರು
order for-
ಅಬ್ಸೆಸ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಅವ್ರು ಏನ್ ಅನ್ಕೋತಾರ? ಅವ್ರು ಹೊರಗೆ ಕಳಿಸಿದ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದ್ರೆ
ಅಲ್ಲ ಅದರಲ್ಲೇ ಒಂದು ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಎಲ್ಲ ಬಂದು ಅಡಿಷನಲ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ಸ್ ಟು ಬಿ ಎಕ್ಸ್ಟೆಂಡ್.
entry order to continue, subject to this direction.
Great.
Okay. 40.
Interim order need to be extended.
Interim order.
There is urgency, my lord. Because of interim order, my lord,
urgency?
respondent number 6 is not having any post and also is not getting the salary, my lord.
In posting ಇಲ್ಲ salary
The
ಇಲ್ಲ.
salary ಇಲ್ಲ.
ಯಾವಾಗಿಂದ?
My lord, since 23/8/2024, my lord.
23/8/24.
24.
You are without posting.
Yes, my lord.
The direction may be given to give this.
On my lord,
Government
23/8/2024, my lord, he has been relieved, my lord.
Sir.
ಏನ್ರಿ August 24 ನಿಂದನು ಪೋಸ್ಟಿಂಗ್ ಇಲ್ಲ ಸ್ಯಾಲರಿನೂ ಇಲ್ಲ ಅಂತಲ್ಲ. ಹೌ ಹಿ ಶುಡ್ ಸರ್ವೈವ್? ಬದುಕೋದು ಹೆಂಗೆ ಅವನು ಎಂಪ್ಲಾಯಿ? ವಿಲ್ ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಇಮಿಡಿಯೇಟ್ಲಿ ಹೇಳ್ಬೇಕು ನೀವು. ಕಾಲ್ ನೆಕ್ಸ್ಟ್.
Applicant succeeded before the creditor.
That's what.
Applicant succeeded.
Applicants that respondent succeeded.
Respondent succeeded. Applicant.
That's it.
The applicant succeeded.
Got it. Okay. Call this matter next week, yeah. 20th.
Interim order. need to be-
Interim order to continue till then.
Yes.
Okay.
Number 41, seat
One,
allocation.
I'm for the respondent number 3, my lord.
Ah.
The respondent number 3 is the applicant before the tribunal succeeded in his application, my lord.
Ah.
That transfer order in favor of the petitioner, who is the respondent number 3, is totally illegal and contrary to the transfer guidelines, my lord. That was the specific observation of the tribunal. My lord, here stay ಕೊಟ್ಟಿದ್ದಾರೆ ಅದು
Not next week on the 24, 25 ಯಾವ್ದಾದ್ರು.
ಇಲ್ಲ ಏನಂದ್ರೆ ಸ್ವಲ್ಪ ಶಾರ್ಟ್ ನಮ್ಗೆ ಅದೇ ಒಂದು ರಿಲೀಫ್ ಟ್ರಾನ್ಸ್ಫರ್ ಅಲ್ಲಿ ಡೈಲಿ ಕ್ಲೈಂಟ್ಸ್
ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬಹಳ ಬೀಚ್ ಇದೆ ಎಲ್ಲ ಫಸ್ಟ್ ಆಗಿದೆ. 27 ಹಾಕೋಣ ಅವತ್ತು ಮಾಡಿ ಮುಗಿಸಿ.
ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಹಾಕೊಂಡ್ರು ಸ್ವಾಮಿ.
ಏನ್ ಮಾಡಿ ಎಲ್ಲ ಅಷ್ಟು ರೀಚ್ ಆಗ್ತಾವೆ.
24
Number 42, Leela Raj.
ಯಾವ ಡೇಟ್ ಕೊಟ್ಟು
For the petitioner.
Yes, Nagaraja.
Two connected matters, my lord.
Ah.
In one of the matter, my lord, the lordship had granted the interim stay, my lord.
Ah.
In the other connected matter, my lord, had come up once, my lord, and we had not got the sufficient resources, the books we didn't get. So the honorable court had directed us to reappear before this court, my lord.
My lord, we have just filed a wakalat in this matter. The learned counsel may be directed to serve a copy of the.
ಕಾಪಿ ಕೊಡಿ.
I'll serve the copy, my lord.
ಕಾಪಿ.
In the meantime, my lord, requesting.
ಅವ್ರು ಕೇಳಿದ್ರೆ ಕೊಡ್ತಿದ್ರು.
My lord, let us file our objections and thereafter we can be heard on the IAS.
ಇವತ್ತು ಕಾಪಿ ಕೊಡಿ. On 27th ಇಟ್ಕೊಳ್ತೇವೆ. In the meanwhile, you file objections.
My lord, on the other matter, also, the same connected
ಕಾಲ್
matter.
ಕಾಲ್ along with ಮಾಡ್ಬೇಕಾ?
It's already been
ಇದೆ.
connected, my lord. In one
Sir.
matter, stay has been granted. The similar stay in the same circumstances, my lord.
Identical matter ಅನ್ನೋದು.
Both similar identical matters, my lord.
Is it identical matter?
It is an identical matter. my lord.
ಬರ್ಕೊಳ್ಳಿ. Counsel for the petitioner submits that the case in WP number is identical with the case in WP number so and so, wherein interim order has been made on 9/1/2025 and therefore ಅದರಲ್ಲಿ ಎಷ್ಟು ಅಮೌಂಟ್?
50,000, Swami. Yellow same 1,50,000 has been deposited in the state.
Therefore, on the principle of parity, same interim relief has to be granted.
My lord,
In
let us.
view of division bench decision, ಅದು 77 the other one ಇದೆಯಲ್ಲ. First, we find force in this. First, interim order as in WP number 35657 of 2024 and subject to the same condition. ಇದು ಮಾಡಬೇಕು.
It's been deposited
First,
already. my
till next date of hearing. Call this matter on 27. All right, amount ಬರಲಿಲ್ಲ. That may help you.
In both the matters, my lord.
Or two steps ತಗೋಬೇಕಲ್ಲ ಅದರಲ್ಲಿ.
I'll take steps. My lord,
Steps
in
to be
both the
taken in
matters,
respect of what?
The amount is deposited in the state commission.
State commission.
It's been deposited already.
ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಇದೆ ಅದೇ ರೀತಿ.
Same thing.
Same order.
Yes.
Okay. ನೋಡೋಣ.
Grateful.
41, 27
27, 3.
ಮುಂಚೆ ಇಲ್ಲ.
27, 3.
31
Court officer, serial number 41 is to data.
31 next week. Finally.
Okay.
Next week, finally.
ಎಷ್ಟು? Sir, date.
Sir, ಹೇಳಿ ಯಾವ್ದು ನಿಮ್ದು?
Serial number 41.
41, 27, 3.
Okay, sir. Thank you.
39, 25. 25, 3. Yes. Thank you. ಶಿವದಿಯೋ ಸಿಂಗ್ ಏನು ಆಬ್ಜೆಕ್ಟ್ ಅದು